Good morning, everybody. Good morning. Welcome back to the Law of Self-Defense Show for December 20th, 2022. December 20th, only 5 days to Christmas. Holy cow. And of course, we are here to continue our sentence watch in the trial of the wrongful conviction of Aaron Dean. Okay, I have something else playing. Hold on. All right, fix that. Welcome, everybody. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Come on in, make yourselves comfortable. So, Aaron Dean, a former Fort Worth police officer, on October 12th, 2019, was ordered by dispatch to an open structure call. Open structure calls are treated as potential burglaries, silent alarm calls. They are not welfare checks. He was not sent on a welfare check. It was coded as an open structure call, sufficiently dangerous call that 2 officers are required to respond. So 1 cop per patrol car, 2 patrol cars sent. The lead officer was Aaron Dean. His backup was Officer Carol Darch. Dean had been a police officer for the Fort Worth Police Department for 1 year. Carol Darch had been a police officer for the Fort Worth Police Department for 3 weeks when they received this call. So 2 rookies go to the house. The reason they were sent is the neighbor across the street, James Smith, excuse me, had observed that the home in question, the doors had been open from 10 p.m. until about 2:30 in the morning. That's when he called the police, saying, hey, we've never seen the doors open before. The lights are on, the doors are open. It looks unusual. I walked over, couldn't really see anything, but was too scared to knock on the door myself. I didn't have a gun. So he called the police to come take a look. Police protocol when you respond to a silent alarm call is you do not announce your presence until you've evaluated the situation. They approached the home, looked through the door. The home looked disheveled. Partner Carol Darch would testify in the witness stand that the home appeared to her to be ransacked, to be the scene of a robbery. There was stuff everywhere inside the house. There was odd things piled up outside the house, as a burglar might do if they were gathering things in preparation for flight. And so they began to investigate it as a potential burglary in progress. They began to look for forced entry on the exterior of the home. They approached the window on the side of the home. Aaron Dean shone his flashlight in his left hand, actually, into the window. And on the other side of the window was Atatiana Jefferson pointing a gun at him, raising a gun until he saw the muzzle. He shouted, show me your hands, show me your hands, fired a single round that struck Atatiana Jefferson in the heart. It would turn out that Atatiana Jefferson was not, in fact, a burglar. She was lawfully in the dwelling. I believe she lived there. She was babysitting her 8-year-old nephew at the time. So a tragic event, certainly. She was not a bad actor. She didn't deserve to die, per se. The 8-year-old nephew she was babysitting was awake at 2:30 in the morning, observing her, and would tell investigators within 2 hours of the shooting that his aunt had pointed the gun out the window. Aaron Dean would say he saw the muzzle of the gun. His firing of the shot, giving first orders, then firing the shot would be consistent with first having an opportunity to give orders and then no longer having the time to give any more orders. When a muzzle is pointed at you, that's clearly a deadly force threat. And so he shot and killed her, killed Atatiana Jefferson with that fatal shot to the heart, non-survivable wound, obviously. And within 2 days, he'd been basically fired from his job or resigned in lieu of being fired and had been charged with murder in the case within 2 days of the shooting. So more than 3 years later, we find ourselves now in the last couple of weeks with his murder trial. So he'd been charged with intentional murder, which was good for 99 years in prison if convicted. To intentional murder, he raised the legal defense of self-defense. And a lesser included offense of murder, intentional murder, is reckless manslaughter. And of course, his defense in reckless manslaughter would be that he didn't actually do anything reckless in his use of force. It's not like the gun went off by accident. Quite the contrary. He said all along, I intentionally shot her. And here are my reasons. A relatively short trial, as these high-profile trials go. The state rested abruptly 2 days after beginning its case in chief, so suddenly that nobody was prepared for the defense to go right away. So the court took a couple of days off, and the following Monday, the defense presented its case, also only a couple of days, and then the jury went into deliberations. The jury, especially during the state's closing, but really throughout the trial, was badly misled by this prosecution in terms of what the actual law is for both self-defense and reckless manslaughter. In fact, the state explicitly lied to the jury about what self-defense requires, and they got away with it because the defense team here didn't fight for their client effectively. The defense should have clarified what self-defense law actually was. Instead, they bought into the misstatement by the state. For example, the state said on the question of reasonableness, and of course, reasonableness is an element of self-defense. Folks, if you don't have our 5 elements of self-defense cheat sheet, you really need to get it. It's free. We don't charge a penny for it. lawofselfdefense.com/elements. These are the up to 5 elements that make up any claim of self-defense, no matter what state you're in. Not all 5 always apply. In this case, for example, in Texas, avoidance wouldn't apply. But these 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. If you don't know these 5 elements, you can't possibly understand self-defense law. So this cheat sheet, it's just a PDF download, doesn't cost a penny, lists the 5 elements, provides a brief description of each. Again, at lawofselfdefense.com/elements. And one of those elements is reasonableness. So your perceptions, your decisions, your actions in your use of force have to be reasonable, meaning both you subjectively believed it to be necessary and a reasonable person in the same circumstances would have believed them to be necessary. Well, the state argued to the jury that what needed to be reasonable was Atatiana Jefferson. Well, that's not what needs to be reasonable. What needs to be reasonable is the person claiming self-defense, Aaron Dean. But the state argued, no, Atatiana Jefferson, all she had to do was be acting reasonably. And she wasn't acting unreasonably. She was just seeking to defend herself from what she probably perceived as a prowler outside, an unknown man with a flashlight outside her home at 2:30 in the morning. And that's probably true. But that's not the legal question. The legal question is not whether Atatiana Jefferson was acting reasonably or unlawfully. It's irrelevant. What matters are the reasonable perceptions of the officer who fired the shot that resulted in her death, that resulted in the criminal charge here. And the way the state phrased self-defense law, it made it sound that as long as Atatiana Jefferson was acting reasonably, then it can't have been self-defense by Aaron Dean. That's not the law. Both parties could be acting reasonably. Both Atatiana Jefferson and Aaron Dean could have been lawfully privileged to use deadly force in self-defense based on their reasonable perceptions at the time. So, and the defense not only didn't contest this misrepresentation, this misstatement of the law of self-defense, they bought into it. The defense actually argued that, no, Atatiana Jefferson, she was actually acting wrongfully, unlawfully by pointing a gun at a police officer, because anytime you point a gun at a police officer, it's a felony. Well, that's just not true. It's not true. First of all, she'd have to know she was pointing a gun at a police officer. She likely didn't know he was a police officer. And now that put the jury in a position of they had to choose who they liked, who they preferred. Do they prefer the police officer who fired a bullet into the heart of a 28-year-old woman who was not, in fact, a criminal? Or do they prefer the 28-year-old who died as a result of that bullet? That's not a decision you want the jury to be making when they're deciding the fate of your client. So the defense is very lucky that they didn't walk their client into a murder conviction, because there was never any denial by this defendant that he fired the shot intentionally. If you shoot someone through the heart intentionally, it's murder, unless you can justify it as self-defense. And it's very lucky that the jury didn't throw out self-defense as a legal defense based on the state's misrepresentation of what self-defense required. The state also suggested that, similar to the argument I just presented, that unless Tatiana was acting threatening force unlawfully, it can't have been self-defense by Aaron Dean. Well, that's not true. It doesn't matter whether she was actually acting unlawfully. It only matters whether Aaron Dean could have had a reasonable perception that he was dealing with an unlawful use of force against him. And he was investigating a burglary scene. So there was reason. I mean, he didn't imagine this. He was responding to the silent alarm call, the open structure call. The police officers involved, including his partner, perceived the house as being ransacked. There was good reason to suspect there was a burglary in progress. So what matters is his perception of whether the threat he was defending himself was an unlawful threat, not whether it was actually unlawful. None of us are required to make perfect decisions in self-defense. We're required to make reasonable decisions in self-defense. So Aaron Dean is very lucky that his defense team didn't walk him into a murder conviction, because if the jury had bought the state's misrepresentation of what self-defense required, they would have thrown it out. And then it would have been a straight up murder conviction. But they didn't throw it out. They did not convict Aaron Dean of murder, meaning they must have bought the self-defense narrative for the purpose of the murder charge. But they did convict him of reckless manslaughter incoherently, because his use of force wasn't reckless. It was intentional. Intentional and reckless are opposite things. A reckless killing is a killing you did not intend. It's like a drunk driving homicide, where you get drunk, you get behind the wheel of a car. What are you doing? You're acting recklessly. You're knowingly creating an unjustified risk of death to others. And then if you run somebody over while you're doing that and kill them, that's a reckless manslaughter. You didn't intend to run them over. You didn't aim your car at that person to hit them deliberately. You did it unintentionally. But because you were drunk, operating a motor vehicle, that's reckless conduct. Knowingly creating an unjustified risk of death to another, ignoring that risk, death results. That's a reckless killing. But what has to be reckless is something proximate to the injury. Here it's the drunk driving. It's not that you didn't go to the gym that morning. It's not that you forgot to take your medication. It's not that you didn't tie your shoes properly. There's lots of things you might have done all day that arguably were reckless, but unless they're proximate to the actual injury in question, the death of the pedestrian, they don't matter. It's only a reckless manslaughter with a vehicle if the recklessness is somehow associated with the vehicle. So here, there may have been things that Aaron Dean could have done better. In fact, when he was on cross-examination and being grilled by the prosecution on his conduct during his approach to this suspected burglary scene, their observation of the home, the slicing the pie around the doors, the inspection of the cars in the driveway with a flashlight, the failure to inspect a closed garage. There were lots of things the prosecution pointed out that Aaron Dean himself said, yeah, I could have done that better. Give myself a B, not an A. But none of those are things that resulted directly, proximately, in the death of Atatiana Jefferson. Now, if he had handled his gun in some kind of reckless manner and unintentionally shot her, maybe that would have been reckless. If it had had a hammer and he cocked the hammer and the gun went off unintentionally, maybe the cocking of the hammer under those circumstances would have been reckless. But there's no hammer on this gun. It's a Glock pistol. And there's nothing about his handling of the weapon or firing of the shot that was reckless. It was all intentional. And frankly, for its intended purpose, well done. A single round through the heart. That neutralized the apparent threat, for sure. So the only way the jury could have arrived in a reasonable way at a finding of reckless manslaughter is if they believe that anything he did that was reckless, even if unassociated with the firing of the shot, with the use of force, was sufficient to result in a conviction for reckless manslaughter. The way he crossed the street, the way he used his flashlight, the way he didn't open up the garage or to inspect inside the garage, the way he didn't open up the trunk of the car to look in the trunk to see if anybody was hiding there. If the jury was misled into believing, and they were, because the state spent hours on those points, if the jury was misled into believing that any of those things could have been a driver for let me just make sure I got my window up here. A driver for reckless manslaughter, then it's a wrongful conviction. It's an unjust conviction because there's no rational way to get there. And again, I blame his defense team, because his defense team should have made clear that it's irrelevant for reckless manslaughter purposes if he used his flashlight incorrectly or if he crossed the street incorrectly. Those things, none of those things are what killed Atatiana Jefferson. And they didn't do that. So they made it easy for the jury to be misled. So now their client's convicted of reckless manslaughter, and he's looking at up to 20 years in prison. could just get probation, could get 2 years, could get up to 20 years. And in an oddity of Texas law, apparently the defendant has the option of having the jury decide the sentence. In most states, the jury only decides guilt or not guilt. And then the trial judge would decide the sentence. Here, Aaron Dean has decided he'd like the jury to decide a sentence, which results in another mini trial after the trial. So the state gets to present additional evidence and witnesses, arguably relevant to a sentence. I think a lot of what the state presented was not relevant to sentencing, but regardless. And then the defense got to present some of its own witnesses, mostly family members of the defendant. And then the jury gets instructed on sentencing, what the range is, what the options are, and they go into deliberations. This happened. They went into deliberations yesterday morning, and all day passed, and they had no sentence resulted. So they're back at it today. In fact, at about half an hour ago, the local news reports about 8:45 Central Time, the jury was back in the deliberation room with the door closed and back at work. And another unfortunate part of the defense is the state presented a psychologist who had done the psychological screening for Aaron Dean when he was applying to be a Fort Worth police officer. And that psychologist had apparently taken a pretty intense dislike to Aaron Dean. This flagged him as not being suitable to be a police officer. And he testified at length for the state about how he thought Aaron Dean was narcissistic, egotistical, all kinds of personality failings that made him an unlikable person. Now, how did Aaron Dean become a police officer with that negative psychological review? Well, there were 3 other psychologists who also reviewed him and disagreed with the initial psychiatrist. So the initial psychiatrist, his opinion got overridden by 3 other psychologists. And that's how Aaron Dean got to become a police officer. So did the defense call those 3 other psychologists and have them testify at length why they disagreed with the negative psychologist? No, they didn't. Why not? I don't know. Not even one of them. It's crazy. And it just, that negative psychologist just made Aaron Dean come across as a completely unlikable character, frankly, quite different than Aaron Dean's testimony. I mean, on cross-examination, he was quick and frequent to acknowledge, I could have done this better, I could have done that better. It came across as anything but egotistical. It's another irony here is the negative psychologist, made a big deal out of the fact that Aaron Dean, when asked, said he believed he could fly a commercial airliner based on his playing flight simulator games, some of which, by the way, folks, are quite sophisticated. And this was an indication to the psychologist that Aaron Dean had a unrealistic, exaggerated sense of his own capabilities, basically mocking Aaron Dean over this. At the same time, we're supposed to believe that the victim here, Atatiana Jefferson, was going to cure diabetes. That's supposed to be credible. But someone flying a plane, and planes want to fly, folks. They inherently want to fly by design. And I've flown planes. It's not that hard. And I have no formal training. Now, landing well can be tricky. But just flying through the air, it's pretty easy. So that's where we are. Second day of deliberations. I've sent out a number of guest invites to the usual crew you see on this channel from time to time, and people will pop in and out as their interest and time permits. So no promises on any of that. And there's not much happening, obviously, in the courtroom because it's just the jury deliberating in isolation. So what I'll do is I'll play portions of the trial over again. So what I have spooled up right now for us is the cross-examination of the defendant, which goes on for some time. And you'll basically get to hear the shouting male prosecutor here, Dale Smith, and the frequency with which the defendant agrees that he engaged in, suboptimal police work at various points in this thing, none of which had anything to do with the firing of the shot, which the defense then failed to clarify for the jury. If you want questions or comments addressed directly by me or any of our guests that pop in, there's 2 ways to do that. If you're watching on YouTube, first of all, if you're watching on YouTube, please hit that thumbs up button, the like button. It's free. I mean, you may as well subscribe. You need to subscribe on YouTube to comment on these shows. But also, please hit the thumbs like up. We need at least 50% of you hitting the thumbs like up, or I'll just stop the YouTube stream. I mean, there's no point. If you don't like the content, there's no point in me streaming it to YouTube. If you do like the content, there's no reason not to hit the thumbs up button. So please do that. If you'd like to ask a question on YouTube, it needs to be a super chat, at least $5 to separate it from all the other chatter that goes through. Or alternatively, you could be a Law Self-Defense member and ask all the questions you want on the member dashboard, where we're also streaming this. You get all your questions answered for free. Being a member at Law Self-Defense is less than $10 a month, 30 cents a day. So for 30 cents a day, you get all your questions answered. Yesterday, we had a member indicate in the member chat that he'd asked about 20 questions so far, with the day not yet over. That would have been $100 at least on YouTube. And that day cost him 30 cents for his Law Self-Defense membership, less than $10 a month. So it only makes economic sense to me, it seems to me, that you would become a Law Self-Defense member rather than pay super chats. But I leave that up to you. If you'd like to become a Law Self-Defense member, you can do that right now, instantly, at lawofselfdefense.com/join. And all the questions posed there. Now, I do ask, if you are a member, become a member, you're asking questions in the member chat, please preface your question with the word question in all capitals. So it's easy for me to distinguish from all the chatter that also happens there, the members talking amongst themselves. Or make it a $5 super chat on YouTube. That's how that works. Let me just make sure everything is streaming correctly. It looks like it is. Let me pin the live stream on Twitter. And is Rumble working? Are you working, Rumble? It looks like it is. All right. So we're good. We're good on all the platforms. Let me see if there's any immediate questions that need to be answered. By the way, if this jury during the sentencing phase cannot agree upon a sentence, which seems like a real possibility given they've already spent more time deliberating the sentence than they did deliberating guilt on reckless manslaughter. So they may really be at loggerheads. If they can't agree on a sentence, normally at the guilt phase, if the jury can't agree, it's a hung jury, it's a mistrial, like the trial didn't happen, and the defendant could be tried again by the state. Here at the sentencing phase, you wouldn't lose the conviction. You wouldn't lose the effort of the whole trial, but it would be a mistrial for the sentencing jury. And the procedure then would be to disband this jury and panel another jury and have that new jury reconsider the sentencing questions, presumably with the sentencing witnesses again. The weird thing, of course, is that the new jury would not have watched the trial, which seems a little odd, but that may be where we are. So people have asked me what I think the sentence should be. Well, I don't think this officer is actually guilty on the legal merits of anything. He's not guilty of murder. Even the jury agreed with that, or they would have convicted him of murder. And I don't see how any rational jury could arrive at a conviction of reckless manslaughter because his use of force wasn't reckless. If you believe it wasn't murder, you have to believe it wasn't murder because it was self-defense, because he says he deliberately shot her. And if it was self-defense, it was by definition reasonable. And if it was reasonable, it wasn't reckless. So it can't be reckless manslaughter, both because there was no question that he shot her intentionally, and you have to have concluded that he acted reasonably, or you would have convicted him of murder rather than acquitting him of murder on the grounds of self-defense. So there's no rational way a jury could arrive at reckless manslaughter. It's clearly a kind of a politically motivated compromise verdict. So I don't think he should have been convicted of anything. So if I were sentencing, I would certainly fight for the lowest sentence possible, which in this case would be probation. No time at all. And that's my feelings on that. All right, so let me see if we have any questions that may already have come in. Let's see. From Law Self-Defense member Konsaki, question: if the sentence is probation, can the judge use bail time as time served? I think he's mostly been out on bail, so he wasn't serving. That wouldn't be, he's been out on bail. So I'm not sure. maybe I'm misunderstanding the question. But for all practical purposes, the judge can order just about anything for probation. So, and any conditions he wants, pretty much. Let's see. Law self-defense member Kansaki says, as far as he knows, the jury is just recommending a sentence to the judge who makes the final determination. I don't believe that's how it works. I think the jury's decision on sentencing is final. Otherwise, why bother? Why bother having this option if the judge is just going to decide anyway? But I'm not a Texas attorney, and sentencing is not my area of expertise. So, let's see. Yeah, another major issue in this trial is all these, wrongful arguments, improper arguments, misstatements of law made by the state. Almost none of them were objected to by the defense. And if they're not objected to contemporaneously, objected to in the moment with specificity, I object for this reason, they're not preserved for appeal. So to have a hope of getting a conviction reversed on appeal, you have to be able to show an error. You have to show that the error mattered, that the verdict would have been different but for the error, and the error has to have been preserved, unless it goes to some fundamental issue of justice, which is a hard argument to make on appeal. So generally, you're only safe if you preserved it by objection, and this defense team objected to almost nothing. None of the things that really mattered. And Texas is very hard, the appellate courts, on requiring this preservation of claimed error, or it's waived. So just because it was error, just because it was wrong for the state to misstate the law, is not enough by itself to result in a reversal. Now, if it were to be reversed somehow, it's not like the appellate courts would find him not guilty. They just send the case back. They remand it for another trial, typically, and then the state could just try him again. Now, they wouldn't be able to try him for murder again, because what they convicted him of, reckless manslaughter, is a lesser included offense of murder. So first, the jury considered murder and declined to convict him of murder. That's an effective acquittal on the murder charge. So that's gone under double jeopardy. But they could retry him for manslaughter again. Let's see. Law self-defense member Kansaki again, comment, flight schools use Microsoft Flight Simulator to train their students. Yeah, why not? I mean, I haven't used a flight simulator in 20 years, but even 20 years ago, they were good on a PC. They were fine. I mean, lots of technical detail. Sure. Yeah, I don't see any reason why they wouldn't greatly facilitate someone's ability to operate a plane. Now, again, landing may be tricky. Maybe not. Maybe you could do it. But it's certainly flying is not all that difficult. And let's see if there's any super chats yet for today. It looks like not yet. No super chats yet today. So again, if you want questions answered, you need to put them into super chat form, minimum of $5, folks. If it's under $5, I'm not going to read it. Or become a law self-defense member at lawselfdefense.com/join and get all your questions answered for free. So before I jump into the cross-examination, the replay of the cross-examination of Dean, I need to mention the sponsor of today's show, which is none other than American Law Courses. These are law school courses, law school level courses, taught by expert attorneys in their fields of expertise at a fraction of the time and cost of law school, and without the political toxicity that exists in law schools today. Trust me, I speak at law schools regularly. They are progressive, equity, diversity, inclusion, social justice warrior hellholes in terms of politics. Really unpleasant places to be, unless, I guess, you're one of that crazy tribe. So if you'd like to learn the law at a lawyer-like level, but without the toxicity of law school, without anything like the cost or time of law school, I would encourage you to take a look at American Law Courses. All our courses are taught live, streamed over Zoom on a semester basis, typically 14 weeks, one class a week per subject, of course. and then with an optional final exam at the end. And we just finished up criminal law this past fall, taught by our own Steve Gosney, the provost of American law courses. And this spring, we have evidence and property law being taught by two real experts in those topics. I'm really excited about these classes. You can learn more about them and save 50% through the end of the month. So another, 11 days. This is the pre-registration period for the spring semester. Save over 50% on these courses if you sign up during that pre-registration period. Folks, if you have family members who don't know what to buy you for Christmas, this would make a great gift, or maybe a group of them collectively could each pitch in a little money and pay for your course. And you'll have the experience of what it was like to take property and evidence, our spring courses, as if you were in law school, taught by a law professor level instructor. Now you can learn more about these courses, and we have video interviews of the professors, their visions for the courses, all of that. You can learn more about these courses by pointing your browser to AmericanLawCourses.com. All right. So I'm going to spool up the cross-examination of Aaron Dean, one of the more interesting parts of this trial. Let's see. Just got to find the right tab. It's one of these. Here it is. So this is the cross-examination of Aaron Dean. It happened on his first day of testimony a week ago yesterday. And I'll put the closed captioning on. Nope, closed captioning unavailable. Sorry, folks. And I'll go ahead and play. This cross-examination is by the Dale Smith, the male prosecutor. He yells a lot, so it shouldn't be too hard to hear him on the audio. And the defendant, of course, is in the witness stand, so he's got a microphone, so he's not that hard to hear. So the audio should be okay.
At this time, ask the witness step down into the well for demonstration.
Mr. Dean, just follow Mr. Smith's instructions, okay?
You talked a lot about where Atatiana Jefferson was, and you called her the silhouette. I want you to demonstrate to the jury what exactly you saw through the window, what position the silhouette was in.
If the rail's the windowsill.
How about I'm you? Face me like I'm you, and you're the silhouette.
Like this?
She had her left shoulder towards you?
Yes.
And where did you see the gun?
Somewhere here, after she stood up.
Okay. So she started off bent over, and for the record, you were bent over with your left shoulder toward me, bent at the waist, almost in a 90-degree position. Is that an accurate description?
Yes.
Okay. And so at what point did she come up into a more raised position?
Somewhere in the time that I was drawing my gun.
Okay. And then when she raised up, when she got up to a raised position, in what position was she in front?
I'm not entirely sure. I saw the upper part of her body upright.
Do you know if she was bent over?
I'm not sure.
Where was the gun in her hands?
Somewhere here.
And you just kind of put your hands together in front of your chest. Are you saying she had her gun all the way up in front of her chest like that?
I never actually saw her hands.
You never saw her hands. All you saw was a gun.
I saw the gun.
And where was the barrel of the gun in reference to the silhouette? Again.
If the silhouette's here, somewhere in the middle.
Under her chin?
Under her chin, yes.
Was it extended out?
I'm not sure.
You couldn't even tell if she had the gun extended out pointed at you?
No, I couldn't.
You couldn't tell if the gun was up in a raised position, ready to fire?
It was pointed at me.
You couldn't tell if it was up in a raised position, ready to fire?
No.
How long was she in this upright position before you pulled the trigger?
Not very long.
As soon as you saw the barrel of that gun, you decided to pull your own trigger?
Yes.
You decided to shoot her once you saw the barrel of the gun?
Yes.
Once you saw the barrel of the gun, you decided to pull the trigger and take who was on the other side of that window's life.
Yes.
Sit down.
So there's a question here from a law self-defense member, Jerry. He asks, this may have already been discussed, but what does the defense in a murder trial like this typically cost? The ones I'm involved in, it's very common for the legal expense to be on the order of $200,000 before you get to trial. So easily hundreds of thousands of dollars for the defense. Now, of course, you may not have hundreds of thousands of dollars, in which case you get whatever, you get a legal defense that you can afford. But I can assure you there's an enormous difference between a $20,000 legal defense and a $200,000 legal defense in terms of the investigations, in terms of the experts you can consult, the experts you can get to testify, the quality of the legal team, the size of your legal team. The money really matters, folks. We'd like to think we live in a world where the amount of resources you can bring to bear doesn't affect the justice that you get, but it absolutely does.
You testified a minute ago that you thought whenever you walked into the bedroom and you saw Zion, who brings a kid to a burglary? Is that correct?
Yes.
Because in your mind, this burglary was still ongoing. Is that correct?
Yes.
And after you pulled the gun, after you pulled the trigger of your gun, this burglary was still ongoing, correct? In your mind.
I didn't know.
And folks, I would point out that it's not it's not some universal truth that when a jury returns a guilty verdict, that the client's guilty, the defendant's guilty on the merits. If that were true, we wouldn't have appellate courts, right? Appellate courts exist because trial courts make mistakes, have bad outcomes. Convictions get reversed.
Well, you just said you thought that this was still an ongoing emergency, correct?
Yes.
And that there could be dangerous people inside, correct?
Yes.
And that you and or Officer Darts could still be in trouble, correct?
Yes.
Did you push Darts out of the way of that window after you fired?
No, she was behind me.
Did you step out of the way of the window after you fired?
Not that I recall.
I mean, that's a fatal funnel, isn't it?
Yes.
What is a fatal funnel? What have you been trained about fatal funnels?
A fatal funnel is a doorway or window. It's just a narrow area that is difficult to move in or out of, and you can be injured or shot there.
I mean, according to you, you still don't know how many people are in this house, correct?
Correct.
You don't know how many of these people have guns, correct?
Correct.
I mean, that's what you're telling us here. You thought this burglary was still an ongoing emergency, isn't that correct?
Yes.
But you didn't push Darsh out of the way of that fatal funnel, did you?
No.
You didn't get out of the way of that fatal funnel, did you?
Not instantly. No.
You even tried to open the window to get inside that house, didn't you?
Yes.
You tried to open the window to get inside a house where you didn't know where unknown assailants could be hiding that could be armed. Is that what you're telling this jury?
Yes.
That's your sworn is that good police work?
No.
And let's go back to this. You said that it was Officer Garch's idea to go in that house, right?
No, we both intended to go inside.
Who was the first one that said, let's get inside there?
Officer Darch.
And then you tried to get into the window of the house filled with dangerous people.
Yes.
But you didn't tell Officer Darch there was a gun in that house, did you?
Not until we got inside, no.
Did you tell her when you got to the fatal funnel of the cars?
No.
Did you tell her when you got to the fatal funnel of that side door that was open where the bad guys could be?
No.
Did you tell her when you got to the fatal funnel of the front door?
No.
Did you have any trouble opening that front door?
No.
You just went right on in, didn't you?
Yes.
Hey, when you were in the back shooting at Atatiana Jefferson, do you know how many people could have run out the front door?
No.
I mean, did you have backup there?
No.
Was that front secure?
No.
All the bad people in that house could have just went right out that front door, couldn't they?
Of course, none of this is relevant to any of the legal questions in the case. The legal questions are, did you intentionally shoot Atatiana Jefferson? The answer is yes. Never contested that. Were the conditions met for lawful self-defense? Was there a reasonable perception of an imminent unlawful threat of deadly force against you? Yes. Even the jury agreed with that. They acquitted him of murder. And then the final legal question is, did you shoot recklessly, meaning not intentionally, and in an unjustified manner to create a risk of death to another? Well, we know it was justified because the jury acquitted him of murder by self-defense. So it was a justified use of force. So there's none of this that the prosecutor's talking about is relevant to any of the legal questions in the case. It doesn't matter whether or not theoretical bad guys in the house could have fled. That's got nothing to do with the criminal questions in this case.
Yes.
Would you have any way of knowing if they would have went out that front door?
No.
Is that more good police work?
No.
So now you've opened the fatal funnel. Hey, what is slicing the pie? We've heard that. I want to hear you tell me what's slicing the pie.
Slicing the pie is when you're entering an opening, taking it in sections, and then dividing up the area inside.
You kind of peek a little bit and then retract to protect your body. Is that right?
No, if you retract, then you've given up the ground.
Well, you peek and then move a little bit more, move a little bit more, only exposing yourself as much as necessary until you get as much of view to determine what's safely on the other side. Isn't that right?
Yes.
How fast did you slice the pie at that fatal front of the front door before you went in?
You can do it quickly or slowly.
Did you do it?
Very quickly.
Oh, you did. You determined there was nothing unsafe on the other side of that front.
Yeah, all of this entire cross-examination is objectionable on grounds of relevance. It's not relevant to any legal question in the case.
Door for you to just walk right in.
I think so. It's been 3 years.
You saw the body cam. It took as long as it took. Do you really think that in the body cam, if you were being graded on that slicing the pie at the front door, you'd get an A+?
Probably not.
It's more bad police work, isn't it?
It's not the best.
It's more bad police work, isn't it?
Yes.
When you got in the house, did you tell Darks there was a gun then?
When I found it, yes.
Oh, when you found it. I'm talking about in the living room after you opened the fatal funnel of the front door. Did you tell her there was a gun in that house?
No.
You got another fellow officer from the Fort Worth Police Department entering a home which you have determined to be a burglary in progress with possible armed assailants, and you didn't think to tell your partner, hey, there's a gun inside?
By the way, the state never presented a single Fort Worth Police Department official, trainer, who said any of what Aaron Dean did was outside policy. The most the state could argue was where there were multiple things that the general orders wanted you to do, he didn't do all of them simultaneously. Because, of course, it's impossible to be in multiple places at the same time.
No.
You didn't think to tell her, hey, I saw somebody with a gun?
No.
Do you not like Officer Darch?
I like her just fine.
But you didn't seem too concerned for her safety. If in your head is what's going on, and there's this burglary in progress, and bad guys are there with guns, you let your partner walk into that house without giving her any heads up whatsoever that the bad guy might have a gun. Is that really what you did?
We were talking on the radio and yelling commands.
Did you tell her there was a gun?
I did not.
Is that good police work?
No.
That's more bad police work, isn't it?
Yes.
So, in your head,
Keep in mind, there was a gun. I mean, this isn't a question of fact. The gun was recovered beside the body of Atatiana Jefferson. And her nephew, who she was babysitting, told interviewers that he watched his aunt get the gun out of her purse and pointed at the window.
you testified that whenever you saw Zion, the first thing you thought was, who brings a kid to a burglary? So before you get to that bedroom, you still think there's a burglary in progress, right?
Yes.
Did you clear every room in that house?
I don't think so. I think she cleared one or two that I didn't see.
Is it good for an officer to clear a room by themselves?
No.
When you have two officers, how many officers does it take to clear each room?
2 is best.
Two's best. You had two there, didn't you?
Yes.
But y'all didn't use 2 officers to clear each room, did you?
No.
I mean, in your mind, there's still bad guys with guns. You just let darts possibly walk into a bedroom where there could be a bad guy with a gun, right?
Yes.
Again, that's got nothing to do with his use of force upon Atatiana Jefferson. This doesn't have anything to do with that. Maybe it was a good idea, maybe it was not a good idea, but it's got nothing to do with the act that resulted in Atatiana Jefferson's death. I saw we did get a super chat come in, so let me see if I can address that. One from L Fox, $5 super chat. Thank you very much. Says, I wonder why we didn't see the laser in the body cam if he had to shut it off when he went into the house, if it was pointed at him. I don't know, but the video's of very poor quality, obviously. The Streamlight flashlight and his weapon light on his pistol put out hundreds of lumens of light against the glass of the window. It pretty much blinds everything out in terms of what the camera picked up. Carl Simon, $10 super chat. Thank you very much. He asks, can the defense team have believed that the jury needed to find him guilty of something and so wanted to leave manslaughter on the table so they didn't argue that manslaughter should not be an option? No, that wouldn't be a reasonable thing for the defense to do. Maybe you believe the jury has to find him guilty of something for political reasons. Well, manslaughter's still on the table. I mean, it's still there. The charge doesn't go away. The state's entitled to the lesser included, but you don't not argue against it. You don't leave it as a default conviction for your client. You argue that it can't have been reckless manslaughter because there's no evidence of recklessness in the use of force that resulted in the death. And then if the jury wants to compromise on manslaughter, they'll do it anyway. But you make the argument. You don't just leave your client hanging out there. Let's see. Yeah, law self-defense member Kansaki notes, nothing Aaron could have done would have been right. Yeah, this is a common argument by prosecutors. Whatever you did, it was the wrong thing. If you did A, you should have done B. But if you had done B, they'd say you should have done A. If you used hollow point ammunition, you should have used ball. If you used ball ammunition, you should have used hollow point. If you went left, you should have gone right. If you went right, you should have gone left. If you went in the door, you should not have gone in the door. If you didn't go in the door, you should have gone in the door. Here, if he'd inspected the garage, that would have been wrong. That would have been trespassing, like they argued that him going through the unlocked gate was trespassing. But if he didn't inspect the garage, as he didn't here, that was a failure of police work. And in terms of all this, why is the prosecutor talking about all this stuff that's not relevant to the legal questions in the case? It's because they don't have anything to talk about that is relevant to the legal questions of the case. They don't have any actual evidence to support what they're arguing here. For example, the state wants to argue that it's not true that this officer saw a gun, that he didn't know there was a gun until he went inside the house and found the gun beside the body. But there's no evidence of that. We're supposed to make a negative inference from the fact that he didn't shout gun. But that's negative evidence, where the state has the burden of proving the crime beyond a reasonable doubt. And there's other offsetting evidence consistent with the gun having been pointed at him, including the evidence of the 8-year-old nephew, who can only presume to be favorably disposed to his aunt, whom he loved, that he watched her. In a statement he gave 2 hours after the shooting, he watched his aunt retrieve the gun and point it at the window. No reason for the nephew to lie about that having occurred. Let's see. Yeah, so I've shared this cliche with you before, but you know, when the law is on your side, you pound the law. Well, the law is not on the prosecution side here. So if the law is not on your side, but the facts are on your side, you pound the facts. Well, the facts are not on the prosecution side here. And if neither the law nor the facts are on your side, you pound the table. And that's what the prosecution did throughout this trial. They pounded the table, they misled, they lied to the jury about the law that should apply, and the defense never checked them. So I put that at the feet of the defense. I mean, we've grown accustomed to these really vicious prosecutors knowing that they're railroading a defendant with bad law, bad facts, right? Binger with his little pinch and zoom, adding pixels. That's bad facts. He's making up evidence. And here we have bad law. They know they're doing it. It's not good. They shouldn't be doing it. But you're supposed to have a legal defense for a reason, and that's to check that kind of abuse. And this defense team just never did that. Yeah, and it's hard to know. I mean, this whole cross with Aaron Dean constantly saying, "I could have done this better. I could have done that better." I really wondered about that. That seemed like very inadequate prep of their witness. But then for the sentencing phase, we saw them bring in that psychologist, who I have to presume the legal defense team knew that psychologist with the negative report was going to be brought in. He was going to say, this guy's narcissistic, this guy's egotistical, he has an overinflated sense of his own capabilities. Well, this is the opposite of that, right? So maybe Dean was instructed by his legal team to, listen, concede on the stuff that doesn't matter legally, because none of this matters legally. Concede that you could have done a better job there, so we undercut that psychologist testimony. If you keep saying you did everything right, it's going to tie in with the egotistical label, right? Inflated sense of capabilities label. Maybe that's what was going on here. But then if that was the plan, the defense should have made explicit to the jury that all this stuff that he could have done better doesn't matter. It doesn't matter to the legal question in this case. Was this murder? Was this recklessness? And yes, folks, the fact that he wasn't convicted of murder means the jury bought self-defense. The legal defense of self-defense. Because if there's no self-defense, this is nothing but an intentional homicide, unlawful homicide, unjustified homicide. He says he shot her intentionally through the heart. That's murder unless you can justify it. So if they didn't buy the self-defense justification, it would have been a straight-up murder conviction, and it wasn't. And the only way this could not have been murder was because it was self-defense. That's simple legal reasoning. Let's see if there's any new super chats, and then I'll start playing again. Nope. Okay, here we go.
And you gave her no heads up that you had seen a gun inside.
No.
Is that good police work?
No.
Was that good work for your partner? Do you think Officer Darch appreciates that now?
Probably not.
Again, that was objectionable. Do you think Officer Darch appreciates that now? How would he know what she appreciates? He can't read her mind. It's pure speculation. Objection, speculation. But the defense didn't object to anything.
Would you ever want a fellow Fort Worth officer to let you walk into a house without telling you they'd seen somebody with a gun inside?
No.
But that's what you did on October 12th, right?
Yes.
And so y'all didn't really clear those rooms. Y'all just kind of peeked your head in each one, didn't you?
We did a fast clear,
What's a fast clear?
a quick check for threats, and then you move on.
How were you taught to do a fast clear?
Quickly looking into the room to see if someone's there and then moving on.
Do you do fast clears whenever you have potential perpetrators with firearms armed inside a residence?
Not usually, no.
You don't do it, do you? Not in that ultimate dangerous situation, do you?
No.
So that was more bad police work, correct?
Yes.
So you get back to that bedroom and you finally see Atatiana Jefferson. How fast did you start CPR?
I don't recall.
Did you see the video?
Yes.
You saw us play States Exhibit 1, right?
Yes.
How fast did you start CPR?
It was a while.
Did you start CPR?
No.
Okay. So again, when I ask you how fast did you start CPR, your answer should be I didn't, right?
I should point out that it wouldn't have mattered. This was a mortal wound. When I was a younger man, I worked on an ambulance crew, folks, and sometimes you see people and they're just dead.
Yes.
I mean, you saw she was bleeding, correct?
Yes.
You heard her last breaths, correct?
I heard what I now know to be her last breaths.
Because you didn't know they were her last breaths then, did you?
At first, I thought it was the dog.
So she still had a chance in your mind, didn't she?
Yes,
She still had a chance in your mind, and you didn't get down there to help her to stop the bleeding?
I did. I rolled her over and pressed an Afghan to her chest.
How fast did it take you to, you didn't roll her all the way over, you kind of just lifted her up, didn't you?
I lifted her and observed that she had a bullet wound to her chest and looked around for something to stop the bleeding, found an Afghan, and then rolled her all the way over and pressed that Afghan to her chest.
How long did that take you to finally put pressure and cover that wound?
I don't know.
A long time?
In watching the video, it appears to be a long time,
Tell
yes.
you what, if you were laying on the floor shot, how long, would you want someone to take that long to cover your wound?
No.
Why?
Because bleeding out.
Again, all this is irrelevant because none of this caused her death. She was mortally wounded. Whether he provided aid or not would make no difference.
It's dangerous to that person, right?
Yes.
So I know you're crying right now, but on October 12th, 2019, you weren't crying when you decided not to administer CPR to Atatiana Jefferson, were you?
I didn't decide not to.
But you weren't, were you?
I was about to when the other officers ran in,
Oh, you're about to start crying.
about to start CPR.
Oh, about to start CPR. But you didn't do it, did you?
No.
So you shot Atatiana Jefferson thinking she was some bad guy in the back window, is that right?
Yes.
A bad guy who had just been hunched over and who had a gun that you couldn't even see if their hands were around it?
I saw the gun pointed at me.
Is that all you could see? Is that what you're saying?
The gun in the upper part of her body.
That's all you could see. That's all your memory is said that you saw that night was an upper part of the torso of that gun.
Yes.
Do you remember seeing anything behind her?
No.
So you don't know if there was anything behind her.
No, I don't.
How smart is it to shoot a gun at a target without knowing what's behind the target?
Happens in every police shooting. If a cop has a gun pointed at him, the cop shoots back, and he's not doing a thorough analysis first of what's downrange. That just doesn't happen in a real violent conflict or for civilians defending themselves. You're focused on the threat. You're not doing a downrange analysis of making sure everything's clear before you fire the shot. That just never happens. Why are you violating? That's one of the rules of gun safety, one of the 4 rules, right? Know your target and what's beyond your target, right? Because of the exigent circumstances, because you have to prioritize between saving your life and doing a downrange check. You're going to save your life.
I took a well-aimed shot with ammunition that's designed not to overpenetrate.
How smart is it to take a shot at a target without knowing what's behind the target?
It's not.
You're trained against that, aren't you?
Yes.
And like one of the 4 most basic rules about firearms is don't shoot at a target unless you know what's behind the target, isn't it?
Yes.
Like the top 4, right?
Yes.
But you disregarded that, didn't you?
Yes.
So I want to go back. May I approach the witness, Your Honor?
Yes, sir.
So a couple of questions here. This from Law Self-Defense member Kyle, he writes, this is pissing me off all over again. It took a lot of research, but I had to rebudget and bought my CCW Safe. CCW Safe is a company that offers what's commonly referred to as self-defense insurance. I've lived a statistically improbable life as far as violent encounters, and I don't want a lying DA and a feckless defense sending me to prison. Yeah, this could happen to anybody, right? You get a lying DA, lying prosecutors, misrepresenting the law to the jury, and you have a defense team that's not fighting for you. Whether through, I don't know why, but they're not. CCW Safe is when people ask me about quote unquote self-defense insurance, they're the organization I recommend. They're the only organization I recommend. Full disclosure, I do quite a bit of partnering work with them. What I like about CCW Safe is not only do they cover your legal expenses without limit, by the way, also on appeal, also on retrial, which a lot of these other their competitors don't do. But beyond covering your legal expenses, they also fly in an experienced investigative team for you. These are retired homicide detectives that work for CCW Safe, and they become your detectives on the scene. They look for evidence favorable to you, exculpatory evidence. You think the police investigators do that? They basically work with the prosecutors. They're looking for evidence of guilt. You want your own investigators on the ground working for you. And to my knowledge, CCW Safe is the only one of these quote unquote self-defense insurance companies that does that. By the way, if you'd like to get a CCW Safe membership, you can save 10% off your membership by going to lawofselfdefense.com/CCW Safe and use the discount code LSD10. LSD10, you'll save 10%. And if you then would also like to be a Law of Self-Defense Platinum member, if you sign up at the highest level of CCW Safe membership, you can also become a Platinum member at a third of the normal cost. So you would want to contact CCW Safe customer support to get that Platinum option. But that's a pretty darn good deal. I think if you get a lower level of CCW Safe membership, you still get a big discount on Platinum membership, my own Platinum membership, about half price. But you'll want to talk to CCW Safe customer support about that. It's a package deal that I've set up with them. And by the way, what the Platinum membership does, folks, is if you ever want me available to consult on a use of force case that you're involved in, you're a defendant, the only people we provide legal consults to these days is our Platinum members. If you're not a Platinum member, we're not available to work on your case. Law of Self-Defense, me, is not available to work in your case. The only way to have me work on your case is to be a Platinum member. So even if you're just a member of whatever, CCW Safe, Law Shield, USCCA, they pay for your legal expense, but they can't pay for me because I'm not available unless you're a Law Self-Defense Platinum member. And if you are a Platinum member, you get my legal consult services for free. I don't charge you a penny for that. When we did take outside consults, we charge a minimum retainer of $10,000. So it doesn't cost you $10,000 if you're a Platinum member. It doesn't cost you anything other than, of course, the Platinum membership. And if you're not a Platinum member, you can't retain me at any price. I won't take the case. So you can learn more about that at lawselfdefense.com/platinum if you'd like to learn more about our Platinum membership. See if there's any questions. Let's see. Law Self-Defense member Kansaki asks, how much time is usually spent preparing a defendant for cross on the stand if they're going to testify on their own behalf? As much time as you'll give me. I mean, I'll do it every week if I can, until it's perfect or I run out of time. That's how often we drill. I would drill the defendant if he's going to take the stand. And of course, by drill him, I mean, I would act the role of the prosecutor. I would do this to the defendant. Let's see. Yeah, I didn't hear any objections. Law of Self-Defense member Kansaki. I didn't hear any objections, so it didn't happen. Yeah, if bad conduct by the prosecutor, improper argument by the prosecutor is not objected to contemporaneously for appeals purposes, it didn't happen. Kyle Cowden, Law Self-Defense member Kyle Cowden. Are you free to indicate how many times you've consulted and on average, how many? On average, I don't know what that means. We do a lot of consults, folks, but I don't discuss the internal business details of my legal practice. So, but There's plenty of lawyers out there who've I consulted for that talk about it themselves. You've probably heard them on my shows as guests. Let's see, any super chats? Super chats have to be at least $5 to get answered, folks. So, or become a law self-defense member for $10 for a month, for the next month, 30 cents a day, and get all your questions answered. But don't bother with a $2 super chat. It's not enough. All right, back to the cross.
I'm showing you State's Exhibit 7. Do you recognize that?
Yes.
And is that the home where you shot Atatiana Jefferson kind of right there in the middle of State's Exhibit 7?
Yes.
And East Allen is running kind of perpendicular of the photo and kind of curving back over to the left part of the photo, is it right?
Yes.
And then what's the street that goes right across horizontal?
That's Mississippi.
Where did you and Darch park?
Right here on southbound Mississippi.
So if I was to...
So this is another line of irrelevant questioning. If he parked just around the corner from the house, and that's supposed to be wrong. But if he parked in front of the house, that would have been wrong. Now that he was across the street parked, they had to walk across the street to get to the suspect home. The way they crossed the street was wrong. But if he'd done it a different way, that would have been wrong. Everything would have been wrong.
Hold my finger right here, right up here, where this car is right here?
Yes.
Is that kind of where y'all parked?
Roughly, yes.
What house did you walk up to? The first house that was the wrong one?
It would have been the one on that southwest corner.
The one on this southwest corner right here?
I think so, yes.
So if I'm pointing to it right now, that'd be correct. This one in the top right corner of the photo to my left, if I'm looking at it, that house, right?
Yes.
Well, you said you didn't park in front of the house so you could maintain some officer safety, but y'all just pulled right up next to the one y'all were going to walk into first?
No.
Well, then tell me. You were parked right there. You got out and walked to that house.
I knew which house was 1203 East Allen.
Oh, you knew, so it was Officer Darch. It's her fault that y'all parked over there.
I pulled up behind her, yes.
Yeah. So again, that's someone else's fault. That's Officer Darch. Is that right?
I pulled up behind her because I wanted to meet with her, and I knew that we were going to 1203 East Allen. I didn't know that she didn't know.
Why you didn't, when she started walking towards the other house, you didn't stop her?
I believe she was coming back from that house already. She already knew that it was the wrong one at that
She
time.
already knew. So how'd you get across the street on State's Exhibit 7 from those cars parked to Atatiana Jefferson's home?
No, we walked across.
You walked across this intersection, you went just straight across?
I think so.
So just diagonal straight across the intersection, is that right?
I don't recall.
That's what you testified to earlier. Did you forget from just a minute ago?
It's been 3 years. I don't recall if we went diagonally or if we went across the crosswalks. I don't remember now.
But you were.
Hey, all the people on YouTube, thanks for hitting that thumbs like up. I really appreciate it. There are a couple hundred of you that still haven't done it, though. So if you could take a moment to please hit the thumbs like up on YouTube, you get my thanks.
Out in the middle of the intersection, right?
Yes.
If you're trying to conceal cover, isn't walking out in the middle of the intersection of two streets a dumb way to do it?
We had to cross the street somehow.
But you could cross the street closer. Aren't you taught like maybe to conceal yourself better? You don't walk out in the middle of the street. You might walk around the house line. Isn't that right?
We could have.
You're taught that, aren't you?
Yes.
But no, y'all just went right out across the street in the open and the most obvious place you could cross where anyone in that intersection could see it. Isn't that correct?
Yes.
Wouldn't you agree with me that's not a good way to sneak up on anybody?
Yes.
So more bad police work?
Yes.
Okay, so you testified, and you've heard people testify with their attorneys asking questions, that you don't get all the information on a call, and that you were trying to gather as much information as possible. Is that correct?
Yes.
So your testimony is you walk up to an open structure, you don't know what's going on, do you?
No.
So you better have your eyes peeled so you make sure that you're not getting any dangerous situations. Isn't that right?
Yes.
How long did it take you to notice James Smith and all his family sitting on the stoop of that house across the street?
I didn't see them.
You didn't see them,
No.
so you're going to open structure. You just told this jury that you're trying to do everything you can to take in as much information as possible, and you didn't see a group of adults standing on a stoop across the street from your target investigation?
No, the house was dark. I didn't see them.
Think that's good police work?
I was focused on the primary threat in front of me.
The primary threat in front of you, but threats can come from all over the place, right?
They can.
I mean, if James Smith and his niece and his nephew and his sister were bad people, y'all didn't have any backup, did you?
Not at that point, no.
I mean, that would have left you and Officer Darts. That would have left y'all an unprotected 6, right?
Yes.
Is that a good thing for officers, an unprotected 6?
No.
What is an unprotected 6?
It's where your back's exposed to people.
So if you're just so focused on the bad guys that are in this house, you didn't even think to look that there might be some bad guys somewhere else?
I did what I usually do. I took a quick look around and I didn't see anybody else.
And again, none of this has anything to do with the legal questions in this case. Was this murder or lawful self-defense, or was it his use of force reckless in his shooting of Atatiana Jefferson? This is all irrelevant, inconsequential nonsense.
You didn't see 4 adults standing across the street.
No.
And you said you took a quick look around. I mean, that's a pretty honest statement, isn't it? You did take a quick look around, right?
Yes.
I mean, everything you did in the early morning hours of October 12, 2019 was just a quick look. You didn't really follow any rules or regulations, did you?
No. We inspected the structure.
You inspected the structure. I mean, were you going in kind of gung-ho?
No.
Were you excited to maybe get a good call?
No.
As if being excited about going on a call, you shouldn't be excited if you're on a potential burglary in progress call. It's so silly. All right, we have a super chat here from Berserker, $10. Thank you very much. Says, do you think if Dean was confident and upfront with his answers like Rittenhouse, the jury would have acquitted? No, I don't think. Well, I think the jury was given an excuse to convict on recklessness because they were allowed by the defense counsel to believe that all this inconsequential nonsense that he's conceding he did wrong would qualify as recklessness for purposes of his use of force. That's nonsense, but the defense never pointed that out. So indirectly, if he had not said 40 times, that wasn't good police work, I could have done that better, I give myself a B, then the jury would not have had that irrelevant but existing pool of he didn't do things perfectly that they mistakenly thought could be the basis for a finding of reckless manslaughter. So in that sense, if he had not made all those concessions, yeah, maybe he would have been acquitted. The real way to keep him from being acquitted would have been for the jury to have been given a correct understanding of what reckless manslaughter means by defense counsel, and they never were. So I think the trouble here is they probably knew that that negative psychologist was going to be testifying at some point, either during guilt or during sentencing. And he was going to testify that he believed Dean was egotistical, had an extravagant, exaggerated sense of his own capabilities and so forth. And so maybe they coached Dean to concede on unimportant matters, irrelevant matters, to offset that expected testimony. If they did that, that's a mistake. That was foolishness. Let's see. So that's the super chat. Law self-defense members. Sam, law self-defense member Sam asked, does CCW Safe help in case of self-defense incidents not involving deadly force? You know, folks, I don't work for CCW Safe, so I don't like to get into the details of their coverage because I'm afraid I'll get something wrong. So for questions about the details of CCW Safe, I'll just point you to their website. lawofselfdefense.com/CCW Safe will get you where you want to go. Let's see. Law self-defense member Kansaki says, question, now that we know how Cross went after the fact, do you think he would have been better off not testifying? No, I think he had to testify. This is a bad outcome case, right? No one's happy that Atatiana Jefferson is dead, least of all this guy, the defendant. And if it's a bad outcome and somebody's died who was not, in fact, a bad actor, the jury wants to know why that had to happen. Why did this 28-year-old have to die? And really, the only person who can explain that is the defendant. So I think he has to take the stand. But when he's on the stand getting abused by the prosecution, your defense counsel should object. When the state's making improper argument, when the state's asking questions about matters that are legally irrelevant to the criminal charges and legal defenses in the case. So it feels like they just hung this guy out in the wind. But I think he had to take the witness stand. I think they would have convicted him if he hadn't. Yeah, it's always a risk, you know, when you have to put, I mean, normally you don't want to put your client in the witness stand because normally if you're a criminal defense attorney, normally your client's a criminal, most commonly. But in one of the ways good guy cases of self-defense differ from bad guy cases of self-defense is normally in the good guy case of self-defense, your client's never been in trouble with the law before. So they don't have prior convictions, prior charges, all this kind of nonsense. So you don't run that particular risk, the risk of having prior record exposed to the jury when it otherwise would have been excluded from evidence. But once you take the witness stand, all that character stuff comes in. You're a witness just like any other. The jury's entitled to know about all your purported bad acts as part of evaluating your credibility. But if you have a good guy case of self-defense, there's usually not that baggage. There are, of course, other risks to putting your client on the witness stand, and this is one of them, that they're going to get berated by the prosecution on irrelevant matters. You're supposed to offset that risk by being ready to object when they do that. That never happened here. Let's see. YouTube could really use a better super chat function. Law self-defense member Kansaki asks, what would be the proper one-word objection? For most of this relevance, some of it is badgering, some of it is asked and answered. There's a number of times when the prosecutor asks a question and the defendant answers, but the prosecution's not happy with the answer. So he'll ask it 2 times, 3 times, trying to get different words out of the defendant's mouth. That's asked and answered. That's badgering the witness. But most of this is simply relevancy. This is not relevant to any of the criminal charges or the legal defenses. It's just an effort to generally communicate to the jury that this guy's not a good cop or something, but he's not charged with not being a good cop.
That adrenaline wasn't pumping just a little bit?
I was as apprehensive and as cautious as I was on every call.
Apprehensive and cautious enough to ignore 4 adults sitting across the street on a stoop.
I never saw them.
Might have been a good thing to notice, don't you think?
Yes.
So after you missed the 4 adults sitting on the stoop across the street, how did you walk up to that front door on East Alley? Did you walk slowly?
I'd say a moderate pace.
Were you crouched down to conceal yourself?
I don't recall.
Was Darce crouched down to conceal herself?
She was behind me. I don't know.
She was behind you, but you didn't know exactly where she was behind you?
Not at that moment, no.
Not at that moment. Because you don't have eyes in the back of your head, right?
Right.
So when you got to the front door, you knocked.
So another example of how you can never do anything right. So Dean was accompanied by his partner, Darch. They were basically back to back covering each other's 6s as they were inspecting the outside of the house. Apparently that was the wrong thing to do. He was supposed to leave someone at the front door to guard the front door. But of course, if he had done that, he doesn't have eyes in the back of his head, right? He would have left himself exposed. He would have left Darch exposed to attack by theoretical gunmen. So there's no decision Aaron Dean could have made that would have satisfied this prosecutor.
On it and identified yourself as forward police?
No,
You could have identified yourself as forward police at that point, couldn't you?
yes.
Can you tell me the rule that said you shouldn't identify yourself as forward PD? The general order that says you should not have identified yourself on that front porch?
It's part of the general training that we don't announce ourselves in order to not alert bad guys.
So you've never walked up to a house before that maybe there's a burglary in progress and identified yourself as forward PD?
Not on burglary in progress, no.
You sure about that?
Yes.
Tell me specifically the rule that says you shouldn't have identified yourself as forward police on that front porch.
There isn't a specific line in a specific general order. It's the general practice. It's the general training.
Tell me specifically what that general training was. Can you tell me who told you that? The person.
The instructors at the academy.
Which one?
I don't recall specifically. Several.
Several instructors told you never to announce yourself when you walk up to a home.
Not never to announce yourself, just not on that kind of call.
On an open structure, you never announce yourself.
Correct.
Ever.
No.
Do you announce it for a burglary in progress?
No.
Would you have gotten in trouble for announcing forward police?
So I'll point out that the state didn't bring in the court any instructor from the Fort Worth Police Academy to say that they are supposed to announce. You think the state would have done that? If he's wrong about how he was trained, you think the state wouldn't have brought in an instructor to impeach this evidence by the defendant? Of course they would have. Why didn't they? Because there is no such evidence available to the state.
The front of the house?
Yes.
You would have been written up by the Fort Worth Police Department for identifying yourself as Fort Worth Police?
I wouldn't have been written up. I'd have been told by a sergeant, don't do that.
You're going to tell this jury.
By the way, it's worth noting that every step of this approach to the house, inspection of the outside of the house, everything up to the shot being fired, everything that Aaron Dean did, all these things he supposedly did that were wrong. First of all, he was never written up by his department for any of that. But more importantly, his partner, Carol Darch, the other officer with him, she was with him every step of the way. They were doing exactly the same things. And she was never chastised by her department for bad police work.
That a Fort Worth sergeant would tell you not to identify yourself on the front porch.
On an open structure call, yes.
Because what in your head, what should you be doing at this point?
Excuse me. Observing and inspecting the structure to see whether there's signs of forced entry.
So did you do that?
We were in the process of doing it, yes.
Do you know how long it took on your body cam from the minute you walked up to that front door and turned your body cam on to the second that you shot at Atatiana Jefferson?
No.
It's 1 minute and 17 seconds. You aware of that?
I am now.
Do you get a lot of information in 1 minute and 17 seconds?
It's hard to be specific. I guess that depends.
And this is another objectionable line of questioning. He didn't determine the minute and 17 seconds. That wasn't up to this officer. That's when the muzzle was pointed at him. The muzzle determined the minute and 17 seconds.
Are you going to tell this jury that in 1 minute and 17 seconds you can check whether 2 doors have any damage that they've been broken into? That you've also cleared 2 cars and made sure there's not anybody else in them? That you've also then opened a gate to someone's private backyard? That you also then went in that backyard and that you saw a silhouette with a gun all in 1 minute, 17 seconds, and you had all the information you needed at that point?
We were still conducting our investigation at that point.
You didn't have all the information you needed at that point. Just tell the jury. Just tell them you didn't do a good job.
We were still,
Good argumentative, just then.
Finally,
Would you give yourself an A+?
one
for that
objection.
minute, 17 seconds?
there's probably things I could have done better.
What grade would you give yourself? A to F? I'd like to see how you, oh, go ahead, tell us. I'm talking before you pulled the trigger, that minute and 17 seconds before you pulled the trigger, A to F.
From Law Self-Defense member Paul, he asked, did the defense bring in an instructor to verify not announcing during a silent call? No one called an instructor from the academy, but Carol Darch, who was called as the state's witness, a state witness, testified that her training was that they were not to announce. And the defense brought in an expert witness on police policy, a retired law enforcement officer, who also testified that was the normal practice, to not announce when there's a open structure, apparent burglary in progress. And of course, the defense doesn't have to prove anything, right? They're the defense. The state has to prove guilt beyond a reasonable doubt.
Probably a B.
Oh, B, high passing grade. What do you think you did the best?
Not sure.
You gave yourself a B and you can't tell this jury what you did the best, not minute and 17 seconds?
No, I'm not sure.
You want to change your grade maybe?
No.
So you're happy with every decision you made up until that moment you pulled the trigger about investigating this open structure?
I'm sure there were things we could have done better.
You're telling this jury you're happy with every decision you made from that, when you first turned that body cam on to the minute and 17 second mark.
Based on what I knew at the time, yes.
All checking that house, checking that perimeter, you're giving yourself a B.
Yes.
Okay. Connor, can we play State's Exhibit 1?
Yes.
And I'll be stopping it next.
That's fine.
Thank you. All right, that was about 4 seconds of looking at that front door. Did you check the door jamb of that front door to see if anything had been pried open?
I took a look at it. I didn't see any evidence that anything was pried open.
That was like 3 seconds. You looked at that and decided nothing had been pried open in 3 seconds?
That video doesn't start at the beginning of the call.
Okay, so you were standing there a little bit longer, right?
Yes.
Did you check the inside? Did you check to see if the screen door worked?
No.
If it was open?
No.
If it was unlocked?
No.
Did you check and see if that was off its frame at all?
A visual inspection, but other than that, no.
Did you check? Did you check the hinges?
No.
Did you see any tool marks on the doorknob?
No.
Did you look for tool marks on the doorknob like somebody tried to jimmy a lock open?
Yes.
You didn't see any.
No.
But at this point, you've already decided this is a burglary in progress.
No. At this point, it's an open structure, and I'm doing what the policy says and inspecting the structure for signs of forced entry.
Where'd you go next? The side door?
To the side door, yes.
Okay. Start. Okay. Now, I see some like weather stripping or something coming off that screen door. Is that what you were talking about?
Yes.
That was your big evidence that somebody had maybe tried to manipulate this door open some way.
It's a piece of evidence.
So are you telling this jury from seeing that, you think they somehow lifted open the front portion of that screen and snuck through and then closed it back?
No,
Is there any way that that weather stripping that's coming off is connected to the operation of that door whatsoever? And what I mean by that is, if that weather stripping the way like that is that way, is there any way to know that the door's unlocked?
Another example of how this officer could not do anything right, no matter what he decided from this prosecutor's perspective. The prosecutor would argue extensively on closing that he showed up with preconceived notions, jumping to conclusions. When in fact, what he's doing is he got a specific call from dispatch, open structure, which is treated under Fort Worth PD policy as a silent alarm, possible burglary in progress. And he's actually gathering additional intelligence by observing the outside of the structure, which is exactly what he's supposed to be doing on such a call. So either preconceived notion is bad, he shouldn't have been doing this investigation, or he should have been doing this investigation. But whatever he chose was going to be the wrong choice.
no,
Is there any way to know that the door doesn't open if you try it with that weather stripping that way?
no,
Is there anything that weather stripping has to do with the operational function of the door handle on that screen?
no.
But you're
Yeah, all this grading stuff. So law self-defense member Chris asks, what does PA say if he gives an A or if he gives an F? I don't know. Maybe he meant DA. All this grading, what grade would you give yourself? That's objectionable because that's a burden shift. That's shifting the burden from the state, which has the burden to prove the specific crime, the elements of the crime, beyond a reasonable doubt, and disprove the elements of the legal defense beyond a reasonable doubt. That's the burden on the state. There's no burden on the defense to do anything. Once we're in trial, once they've raised the legal defense of self-defense, they've met that burden clearly because they're allowed to argue self-defense here in the trial. But the burden of proof, once the state's met the defense has met its burden of production to get self-defense allowed in court in the first place, the burden is on the state entirely to prove guilt beyond a reasonable doubt, disprove self-defense beyond a reasonable doubt. All this grading stuff, would you give yourself a grade? That's burden shifting. That's suggesting to the jury that there's some burden on the defense. There isn't. And in particular, this cop's not charged with the crime of getting a failing grade on police work. There is no crime of getting a failing grade on police work.
your mind, you say, bam, someone's messed with this door, so there must be a burglary in progress.
It's a data point in the investigation of the open structure.
Is this a big data point to you?
So here the prosecutor's arguing that he's wrong for overvaluing these data points, but later the prosecutor argues that he came to a preconceived notion that this was a burglary, that he'd already decided it was a burglary, and therefore he should have followed the SOP for an actual burglary, which is to call for backup. But he hasn't decided yet. He's collecting evidence to determine whether or not there's been a forcible entry.
I don't know if I'd say it's big. It goes into the stack.
So, but did you try this door, the side door?
No.
Did it work?
No,
Did you knock on it?
no,
Could you have knocked on it?
not without alerting someone that I was there.
So you were doing everything you could to not alert somebody you were there.
That's what we do if we're concerned about someone burglarizing the house.
But if you would announce yourself Fort Worth Police, then maybe Atatiana Jefferson would still be alive, correct?
Maybe.
If you would announce yourself, Atatiana Jefferson would still be alive, correct?
Asked and answered, right?
I don't know.
You still might have shot her anyway?
It would have depended on if she came out the front with a gun.
Are you telling this jury there might have been a situation where you still might have shot her anyway?
Only if she pointed a gun at me.
Hey, you just stepped over the weed eater. Is that the lawnmower that we see now at the pop?
So I just took a look, folks, and YouTube's already demonetized this live stream. Thanks, YouTube. You have to demonetize legal analysis on a public trial. That's streaming on Law and Crime every day. WFAA every day.
House portion on State's Exhibit 1 at the 25-second mark.
Yes.
You were here last week when the defense attorneys were asking questions about the stuff piled up outside. What significance did that have to you as an officer at the time?
That it was a possible collection of items to be removed by a burglar.
Explain that to me. Like I don't know. I've never seen a burglary case before. Explain it to the jury. What does that mean?
Well, burglars will often collect loot near where they're going to leave, and so they have a pile of stuff to take.
Is that what you thought when you saw that stuff?
I thought it was a possibility.
How many people keep a lawnmower in their house?
I'm not aware of any.
How many people keep a weed eater in their house?
I'm not aware of any either.
But you think that someone had broken into this house?
Objection, speculation. How would he have any idea who might keep a lawnmower in their house?
Took the weed eater and the lawnmower from inside and stacked it up to take?
I didn't say that.
But you just said that people stack up things to take in a burglary. So if it's a burglary of a habitation, they stacked up the stuff, but they stacked up stuff you don't find at home.
There's a detached garage to the back. I hadn't gotten there yet.
There is a detached garage. How much time did you spend with that detached garage?
I took a look at the door.
Did you try and open the door?
No.
Did you try and open, when I say the door where the car would go, right?
Yes. That door.
Yeah, so folks, I'm not an expert on this YouTube stuff, but my understanding is that the demonetizing means YouTube won't run ads on the content, which is fine. I mean, I'm not in this for ad revenue from YouTube, but the trouble is when YouTube doesn't run ads on your content, they also don't promote your content. They only promote content on which they're making money by running ads. So when they demonetize you, it's not just that you don't get any ad revenue, which is fine. It's that they squelch distribution of the content. They don't promote it anymore. So that's the bad thing. I think being demonetized, I think it's just for advertiser purposes. I think the super chats still work. Although I haven't gotten a super chat in a few minutes. So I guess I'll find out about that if I get another super chat. Law Self-Defense member asks, well, a couple questions here from a couple different members. Vermillionaire and member Kyle, both basically asking if a witness could object if the lawyer is being morons. Can a defendant object if his lawyers are not? No, not really, folks. The objection is a big part of it is trial strategy, preserving things for appeal. The court expects your lawyer to do that, not you, not the defendant. So the court would not be favorably disposed to the defendant. They'll tell the defendant to shut up. Pick good legal counsel, folks. And by the way, if you're a Law Self-Defense Platinum member and you're involved in a use of force event, part of what you get is me speaking with your attorney, vetting your attorney, giving you my sense of how capable or not that attorney is. You are probably almost certainly not in a position to really critically evaluate the quality of your defense attorney. You're just an uninformed consumer. It's not trying to be derogatory towards anybody, but you just don't know what to look for or what to ask. By the way, as long as we got a pause here and we're about an hour and a half in, don't forget, folks, Law of Self-Defense Principles, best-selling book. I think last time I looked, it was Amazon number 25 in the criminal law silo. Over 1,200 reviews on Amazon. I encourage you to take a look at those. 5-star rated. Over 1,200 reviews, but don't buy the book on Amazon. They'll charge you $25 plus shipping and handling. We will give you the book for free. We'll give you the book for free. We only ask that you cover the cost of getting the book to you. So cover the shipping and handling. There's that banner. You see the link there, lawofselfdefense.com/free book, lawofselfdefense.com/free book. And when you go to take advantage of it, by the way, there are also options to get an audio version of the book, a PDF version of the book. So lots of options to pick from. But that's where you want to go, lawofselfdefense.com/free book for your own, a real physical book, folks. Soft cover. Lawselfdefense.com/free book. And during this holiday season, gift giving season, you might consider getting friends and family the hardcover, beautiful hardcover. It's a gorgeous book, looks great on the shelf. May keep your loved ones out of prison if they're ever compelled to defend themselves or their family against criminal predation. This one is not free because the books cost too much to print in hardcover, but you can get this book, the hardcover, at lawofselfdefense.com/gethard. Let's see. Law of Self-Defense member Kyle says, yeah, the demonetizing is just ad revenue. For the record, they often still run ads. You just don't get the money. That could be. I don't know. Interesting. Thanks. Thanks, YouTube. All right.
We'll play that part. We can see how long you took with this garage.
So they're obviously playing the body camera footage here in the background, off screen.
All right, you just watch yourself. We paused at the 1 minute and 5 second mark. How good a look did you take at that garage?
Just a quick one.
You didn't check the door, did you?
I took a quick look at it.
You did not check that garage door that actually opens up where the car would go in, did you?
I didn't try to pull it up.
You didn't actually look down to see if it had been jimmied open anyway, did you?
I took a quick look and didn't see any signs of
How
that.
did you take a quick look? I mean, you're right.
All of this is completely irrelevant. None of this has anything to do with his use of force against Atatiana Jefferson.
Whatever you did was quick, but how did you take a quick look?
Just looked down at it as I was passing by.
You looked down as you were passing by. Is that good police work?
The focus was the house at that point.
But you just told this jury that you got people stacking up stuff that's outside of a garage and you're just going to ignore the garage?
I would have turned my attention back to the garage after we took care of the house.
Did you check the actual door that the people walk through in that garage?
I didn't try to turn the knob, no.
Did you even look at it?
I believe it took a quick look as I passed by.
You didn't check to see if there were tool marks on that door, that it could have been jimmied open some way?
I didn't see any.
You didn't see it, that it could have been pulled to and was still kind of just barely open? You didn't check it, maybe push on a little bit?
No.
You didn't think that maybe if the bad guys had taken that stuff out of the garage, they could still be there and that's where the danger is?
No, I was focused on the house at that moment.
All the stuff that's stacked up for these burglars to take is stuff that's out of the garage, and you didn't think that the garage might be a place you need to check out a little more?
My focus was on the house at that moment.
You didn't think the garage needed to be checked out at all, did you?
I did, and I would have done it after taking care of the house.
You didn't think the garage needed to be checked out at all, did you?
No.
But that could have been another place bad guys were hiding out, correct?
Yes.
So, let me get this straight. We've got the first fatal funnel at the front door. Did you stand in front of that fatal funnel?
I moved across it.
Is that good police work?
You have to move across it.
Could you have stepped away from the residence, maybe put some distance between you and the fatal funnel?
Yes.
Could one of you have covered the fatal funnel while the other one crossed to make sure there wasn't a bystander back behind the wall?
Yes.
Could you have knocked and said forward police to see if there's anybody inside?
Yes.
Could you have tried the door to clear the area to see if there was someone hiding behind the big wooden door or behind the wall?
Yes.
You did none of those things, correct?
Correct.
You just walked across the fatal funnel, correct?
Yes.
Is that good police work?
It was following the procedure for open structure and not alerting a potential burglar inside the house.
Is that good police work?
Objection, relevance.
It could have been better.
So now we get to the second door, that second fatal funnel. Your entire investigation of that door is caught on this body cam, isn't it?
Yes.
I mean, it's not like you walked up to that side door, walked back, turned your body cam on, and then went back to it, right?
No.
So as much time as you spend with that side door on the body cam on State Exhibit 1 is how much you spent with it there on October 12, 2019.
Yes.
You walk in front of that one? That fatal funnel?
I walked past it. Yes.
You let darts walk past it?
Yes.
Did you knock on that one? Knock at that time and alert whoever's inside that it was Fort Worth PD?
No.
But you could have.
Yes.
You could have tried the door to see if it even opens, correct?
Yes.
But you didn't, did you?
No.
You could have gone inside maybe to clear if there was someone behind either door or around the corner, couldn't you?
Yes.
But you didn't.
No.
And still, is that good police work?
You don't knock on doors and announce yourself when you're investigating an open structure or potential burglary.
If you're so afraid of this fatal funnel, what's going on with this open structure and this burglary, you're just walking in front of the doors without a care in the world?
I didn't walk in front of it without a care in the world. I moved past it, looking to see who was inside.
You didn't treat it as a fatal funnel as the way you're taught, though, did you?
Can you be more specific? I'm not sure what you're asking.
When you have a door that's a fatal funnel, you're trained to approach that door a certain way to look through it and make sure you and your partner are safe, correct?
Yes.
You didn't do that in this case, did you?
I looked and moved across it.
You, in the short time you looked, decided it was safe, and then moved across it.
Yes.
That's not exactly how you were trained, right? Come on, be honest.
There's no specific amount of time given to move across the door.
It should have taken longer if you're actually concerned about your safety and Officer Darch's safety, correct?
No.
Really? Or were you just not concerned at the time about y'all's safety?
I was apprehensive and cautious as I am on every call and moved across it in that manner.
This wasn't good police work at that second door, was it?
I'm trying to think what I could have done better. I'm not coming up with anything.
So the second door, you're giving yourself an A+. Is that what kind of raises your average there?
I think it was fine.
You wouldn't change a thing about that second door, would you?
I'm not sure.
We'll move away from the second door and your quote unquote pile of stolen goods from the garage. And you went past the cars. Now, explain to the jury again, why'd y'all check the cars?
To see if someone was hiding in there.
Did those cars have tinted windows?
Yes.
Was it easy to see inside?
With a light on it, yes.
With a light on? Why would you need a light to see inside?
Because of the tinted windows.
When it's dark outside and you turn a flashlight on, is that hiding your position?
No.
So you just announced to everyone at that house, these bad guys that you think are inside, that you're outside with a flashlight, right?
It's possible.
And let's assume that we're taking what you said, that this is a burglary in progress. That's not good police work, is it? To give away your position to the bad guys.
There are certain risks involved in police work, and some of police work is balancing the risks. And in this case, because I couldn't see anyone right there, I decided to go ahead and turn the light on.
So you turn the light on, you did a balancing test, that quick in your head that I need to turn the light on because the possible threat to this car, and to heck with my giving my position away. Do you not understand my question?
Not really.
You just said you did a balancing test. Who are you looking at over there? I see you keep looking to the left side of the courtroom. Who are you looking at?
My attorneys.
Why are you looking at them?
I was trained to address the room. I'm trying to look at various places when I'm
Who trained
talking.
you to address the room?
This is
That's
this
basic
is
public speaking.
completely argumentative. There's nothing wrong with him looking around the room.
That's
Okay. So let me get back to my question. You said that you did a balancing test right then, and that's why you used your flashlight to look in the cars. Is that correct?
yes.
So is it safe for me to assume that you decided that it was worth it to give away your position for the safety of you and Officer Darts in checking those cars?
Because I hadn't seen anybody in the house, I didn't think I was giving away my position.
But by shining a flashlight, you are giving away your position, right?
You can be, yes.
So you chose not to knock on the front door because that would be giving away your position, but yet you're just going to turn your flashlight on to give away your position. Is that correct?
If I'd knocked and loudly announced, anyone in the house would have known I was there. I didn't see anyone there when I turned my light on, so I didn't think anyone would see that.
Oh, so right at the cars, you don't think there's anybody in the house?
Not in the doors or windows facing, not in that front part of the house.
But, oh, so there still could have been people in the back part of the house that could have seen the flashlight there.
In the back part of the house,
Okay.
yes.
I just want to be clear that I didn't think, so you still don't know who's inside that house? That's
Correct.
Okay. So how fast did you clear those cars?
At a moderate speed, I'd say.
Moderate. You felt completely safe walking past them after you looked inside.
Yes,
You checked the floorboards?
yes,
Did you check the cars to see if that the car doors were open?
no. All I need,
Did you check the trunk, see if it had been open?
no,
Did you check to see if there had been any tool markings on the locks of the car?
no.
What information did you learn about these cars from your MDC?
That they match the description of the cars belonging to the person at the house.
Now that's kind of important, isn't it?
Yes,
I mean, you knew walking up that the owners of the home, their cars match the description, were in the driveway, right?
yes,
And matter of fact, you were also told that the owners are usually home at that time, correct?
yes.
Had you already determined that the owners weren't home?
No, I didn't know that.
So in your mind, while you're looking at those cars, you still think the owners are in that house, correct?
No, I thought they weren't there.
Oh, you thought they weren't there. You thought that there's no way those owners are at home.
I didn't think they were, no.
You thought there were no way that the owners of the home were present?
Based on everything that I saw inside that looked like a burglary, I didn't think the owners were there.
What exactly what about it inside that made it, that you said burglary?
Everything that was a mess on the floor, the cabinets and drawers open, and items that just looked like they'd been gone through somebody looking for valuables.
But you've been to messy homes before, right?
Some, yes.
I mean, come on. You've been to calls where people put their cigarettes out on the carpet, correct?
Yes,
I mean, some people have dirty homes. Is that right?
yes.
Where was the TV?
I believe there's a television in the living room
Where in the living room?
on the stand over there.
Set up where people on the couch could see it, right?
Yes,
It looks like exactly where you'd expect a TV to be with the living room set up that way, correct?
yes,
Burglars usually take electronics, don't they?
yes,
So the TV's sitting there right there where it should be, and that didn't No signal in your car brain went off. Hold on a minute. They didn't take the electronics
I don't know. Somebody might still be there and hadn't gotten to the TV yet,
because they were too busy unloading the stuff out of the garage.
or further back in the house.
Okay, so let's get back to the cards. You did those are fatal funnels, right?
Yes.
And you went right past those two cards that are fatal funnels and you did a quick look. Or you said moderate, right?
I did say moderate.
And you felt completely safe for you and Officer Darts to proceed.
Yes.
That garage, you never checked anything inside the garage, right?
No.
And that could have been a very dangerous situation, correct?
Yes.
There could have been all kinds of bad guys in that garage, correct?
It's possible.
But you didn't check it, did you?
No.
Hey, you want to change your grade yet?
Objection to sidebar, Your Honor, argumentative, sustained.
Do you still believe you've done a B?
That's the second objection. It's not just argumentative, it's burden shifting. He's not being prosecuted for a bad grade on police work. He doesn't have a burden of proving he did a police work. The state has to prove either this was an intentional murder, not justified as self-defense, which they failed to do because the defendant was acquitted on murder. And the only way he could have been acquitted on murder rationally was that the jury bought self-defense. Or the state has to prove beyond a reasonable doubt that his use of force upon Atatiana Jefferson was reckless. The use of force, not whether or not he inspected the garage or used his flashlight correctly or checked the trunk of the car. None of those things have anything to do with the use of force on Atatiana Jefferson. So this entire cross-examination essentially is completely irrelevant and objectionable. Let's see if we have any new super chats. I don't know. Maybe the super chat function is turned off when they demonetize the thread, the live stream. I haven't gotten a new super chat in a while. That may be off the table. If somebody wants to run even a $1 or $2 test, that would be appreciated. Let's see. From Law Self-Defense member Sam, question. The prosecutor keeps accusing Dean of just walking past these fatal funnels. The whole thing with a fatal funnel is you're not supposed to stay there, frozen in the doorway, correct? Yes, but again, nothing he did would have been right. If he sliced the pie slowly, he would have been spending too much time in the fatal funnel. Hey, thanks, Wrestler Town. $1 super chat. I appreciate that, man. Just so I know the super chat's still working. Very kind of you. Thanks. Yeah, so if he had sliced the pie slowly, he would have been spending too much time in the fatal funnel. If he slices the pie too quickly, then he didn't do a good job. So no matter what he chose, it would have been the wrong answer. Let's see. Law Self-Defense member Chris says, it probably makes me a shitty person, but the prosecutors where I work did this to a cop in my agency. I would make way less effort to testify, and I wouldn't be going anymore if I left the department. Spoiler, I left, so I'm done with court. And $10 super chat from Mike. Thank you very much. Saying his lawyer is terrible. Object to something. Object to something. And with this particular prosecutor, when you don't object, that just encourages him to keep engaging in the same improper argument over and over again, as we see here. Jacob Turnbow, $2 super chat as a test. Thank you, Jacob. I appreciate that very much.
Level job so far.
I think I did a fine job.
You think you did a fine job. Okay, we can keep watching that. May I approach the witness, Ryan?
Yes, sir.
So that garage, I'm showing you State's Exhibit 57. Is that the garage, right?
Yes.
And so the house kind of comes out right there, isn't that correct?
Yes.
And in State's Exhibit 59, you can see how that gate's kind of recessed, right?
Yes.
Back there. So there's a space where if you're standing at that gate, there's the wall of the garage on your right and the wall of the house on your left. Isn't that correct?
Yes.
And so somebody, if you're standing at that gate, somebody, I'm showing you State's Exhibit 58, somebody could be back over here behind this corner at the bike and you'd never see him, would you?
No.
So somebody could be standing right here where my finger is, and if you're at the gate, you're not gonna see him, right? Is that right?
Yes.
I mean, that's a dangerous place to be, isn't it?
Officer Dart had come through there. I'm not sure what you're asking.
Who's covering the front doors when you're back at this gate?
We were both back there.
Who's covering the front doors when you're back at?
Asked and answered. Asked and answered. And again, there would have been no right answer. If he'd left Darch behind to cover the gate, this prosecutor would be arguing, well, she was alone. She doesn't have eyes in the back of her head. She could have been attacked from someone behind her. And the same for you. Is that good police work? So there's no choice that this officer could have made that would have satisfied this prosecutor. But it shouldn't matter because all of this is irrelevant. None of this is what killed Atatiana Jefferson. And the defense is not objecting to any of it.
This gate.
No one.
So who could have seen anyone? Could anyone just walked out of that house at that point?
Yes.
And if you were back here in this recessed area of State's Exhibit 59 at the gate, somebody could have been around that corner we were just talking about, correct?
Yes.
Was that a safe place for you and Officer Darch to be?
After we cleared it, it was.
After you cleared it, had you cleared the inside of that house?
No.
Did you know who was inside the house?
No, not yet.
So that could have been a very dangerous place if somebody from inside that house had come out around the corner. Is that correct?
Yes.
I mean, because y'all hadn't secured.
This is all objection, speculation. I mean, these are all hypothetical things that didn't happen and didn't exist.
The house, right?
No, we were in the process of inspecting the structure.
You were inspecting the structure. With open structures, aren't you supposed to, after you're inspecting the structure, make sure that all exits are covered?
Yes.
After
That's part of the
inspecting,
general orders, right, with open structures.
Yes.
But you didn't make sure all exits were covered, did you?
Not yet.
At the point you and Officer Dart are standing at that gate, are all exits covered?
No.
all of this is objectionable. It's argumentative. It's impossible for two officers to cover all the exits, especially before they know where the exits are, which is what they're assessing when they're examining the exterior of the home for signs of forced entry. But in any case, it's irrelevant because it has nothing to do with whether or not the shooting of Atatiana Jefferson, that use of force that killed her, was itself reckless.
So you're going against the general orders here, correct?
We were on the inspecting the structure.
Is the perimeter secure when you're standing at that gate with Officer Darch?
No.
No, because those two front doors, you don't have anybody watching them, do you?
No.
I mean, you would think that there's no defense counsel in the room. I know they're not public defenders. They're actually both former prosecutors, which can be a bit of a problem, actually. Now, I should note that the original lead counsel for this defendant, the guy who was on board this case for the last 3 years, died like the week before the trial started. Apparently, he knew he was going to die. Apparently, he was in ill health, and he brought on the two defense counsel that are in the courtroom. They were brought onto the case over the summer. So they've been involved with the case for months. But I don't know. They don't seem to be doing much.
And isn't it an important part of the general orders to make sure all exits are secured?
Yes.
But you ignored that part of the general orders, correct?
I was in the process of inspecting the structure.
I mean, because with open structures and general orders, if you can't secure the perimeter, what's one of the things you can do? Call for help?
Yes.
I mean, that's part of the general orders. If you cannot keep the perimeter, you can call for help, back up so that all exits are covered, correct?
Yes.
And over to the east of Atatiana's home, of her mother's house, there's this huge open field, isn't there?
Yes.
And I mean, that huge open field would be a great place to kind of post up and run a base of operations to secure the perimeter of that home, wouldn't it?
Yes.
From that field, you could have seen the front porch, isn't that correct?
Yes.
And the side door, isn't that correct?
Yes.
And the 2 cars, isn't that correct?
Yes.
And the garage, isn't that correct?
Yes.
And the gate, isn't that correct?
Yes.
But you didn't pull back to that position, did you?
No.
You decided to go head first into that gate, into that backyard, isn't that correct?
I continue to inspect the structure. Yes.
You went into that backyard, isn't that correct?
Yes.
Did anyone invite you into that backyard?
No.
Did you hear anyone calling for help in that backyard?
No.
Did you hear anything that
This is all irrelevant. None of that is required for him to be justified in going to the backyard when there's reason to believe that there's an apparent burglary in progress.
somebody may be in trouble in that backyard?
No.
Can police officers just walk into anybody's backyard they want to if they feel like it?
No.
Why not?
Because it's private property.
It's private property, but you just went right into that gate, didn't you?
Yes.
Because you said, you're telling us that you're looking for what, more doors or something?
Yes. More access to the house. We're inspecting the structure.
Did you see any doors in that back of the house when you opened the gate?
Not on that face. No.
You didn't see any doors.
No.
And you're in a private citizen's backyard,
Inspecting for a possible burglary. Yes.
but you're in a private citizen's backyard.
Yes.
Asked and answered. $10 super chat from Rick. Thank you, Rick. Asks, isn't asking the defendant to grade himself a form of self-incrimination? Surely there should have been an objection. Yes, it's burden shifting. It's placing part of the burden for prosecution on the defense. It's objectionable, should have been objected to, wasn't done. And it suggests to the jury that, wow, if the defense didn't prove their grade, a good grade, that they must be guilty. Absolutely objectionable. Let's see. Law self-defense member, Old Bill asks, do you know who provided the defense counsel? His police union? I don't know who paid for the defense counsel. It shouldn't matter. Law self-defense member Kyle says, I'd have been in contempt so many times if I was Dean or his defense. I'd be like, WTF are you talking about? With added expletives as needed. Yeah, I mean, I've seen it suggested that perhaps the defense lawyers aren't objecting because this judge doesn't like objections, would start to bully them if they objected as much as they ought to. Who cares? Who cares? You're supposed to zealously advocate for your client. And if the judge doesn't like it, that's too bad. Now, you don't want to object over every penny ante thing that happens during the trial, but this is abusive. And Civil, I sent you I DM'd you a guest link, I think, in Twitter. If you'd care to pop in, up to you. Let's see. Law self-defense member Old Bill asked, we've heard you say the defense has to preserve issues for appeal, but if they don't, will that give the defendant an appealable issue of ineffective counsel? The defense appears to be the perfect example of ineffective. You know, the threshold to qualify as effective counsel is so low that ineffective counsel appeals, they never work. It's one of the most common claims made on appeal. But there's been cases where defense counsel has fallen asleep at the table during testimony and not found to be ineffective. So yeah, that's not going to work, and especially not for not objecting. It can work for things that go to the fundamental core of due process, like not requesting a jury instruction on the only legal defense that would be viable. Then there's no path to an acquittal for your client. That something like that could be ineffective, but not declining to object could be trial strategy, arguably, by defense counsel. So you make those calls all the time, whether you want to object or not object to a particular issue. They're not going to reverse a conviction for that. Let's see. See if there's any new Okay, all caught up.
If you would have walked up to one of those windows and seen something illegal going on, that might get suppressed, wouldn't it?
Objection, calls for legal conclusion.
Sustained.
Third objection.
So, you did
In about an hour and a
quick
half
check
of
that second
abusive
door, a
cross.
quick check of the cars, a quick check of the garage, but yet you get in front of this window that Atatiana's in with her nephew, and you linger there. Isn't that correct?
I took a longer look because the light wasn't on.
Isn't there another window that's just on the other side of the air conditioning unit?
It's on the other side of the house.
Is there another window just right over there, though? You didn't go check that out, did you?
I hadn't gotten to that one yet.
But you took a lot of time if this was more time than any other fatal funnel you've been in. Is that correct?
I didn't count the seconds.
So we've got the fatal funnel of the front door, the fatal funnel of the second door, the fatal funnel of each car, the fatal funnel of the garage and garage doors. Is that correct?
Yes.
The fatal funnel of that area right in front of the gate where if anybody come out of that house, you and Darts were in bad shape, right?
It could have been.
And then now we're in the backyard. The gate itself, that's another fatal funnel, isn't it?
Yes.
Did y'all clear that properly?
As best we could, yes. We went directly through it.
So now you're up at the window where Atatiana is. Where's Officer Darch?
Behind me.
How close is she behind you?
Right up behind me.
How do you know?
Because that's what she's testified.
But you didn't know that at the time, did you?
That's the way we're trained.
But you didn't know that at the time, did you?
Did I know it for an absolute fact? No.
I mean, as a matter of fact, you just testified earlier when I started asking questions that when you got to the front door, you didn't know if Officer Darch was behind you or not. And you said I didn't. Is that correct?
Correct.
And then I said, well, of course you didn't because you don't have eyes in the back of your head, correct?
Correct.
So has anything changed between the front door and the back door? Did you grow eyes in the back of your head?
No.
So you had no idea where Officer Darch was, right?
I expected that she was doing what we were trained to do.
At the front door, you said you didn't know where she was because you didn't have eyes in the back of your head. At the back of that house, at that window, you didn't know for sure where she was, correct?
No.
But yet you're standing in front of another fatal funnel, correct?
Yes.
Did you slice the pie there?
As much.
Or did you just kind of stand in front of the window?
I looked inside the window.
Did you tactically slice the pie as you're taught at the Fort Worth Academy or any other tactical schools to look in that window?
No, there was no room.
No room. So you're just out there for any bad guy that you think might be in that house to be able to shoot you.
Yeah, I should get a buzzer sound right on my soundboard. I think I got the bell. What else do I have here? Yeah. Yeah, I need some kind of buzzer. I'll have to get a buzzer sound effect. That would be fun. See if any questions have come in. Jay, super chat's got to be $5, man. I don't have I don't have a fart sound. No, that would work too, I guess. Okay.
Yes.
Is that good police work?
It's part of inspecting the structure.
Is it good police work? And you said that how scared you, how apprehensive you were. That this is a fatal funnel. Is it good police work just to stand at a dark window without knowing what's on the other side?
I was looking inside. I don't know of any better way to do it.
You could have called for backup, correct?
Someone had to look inside that window, look at the
You
window.
could have called for backup, correct?
Asked and answered.
Yes.
You could have moved to the side of the window, correct?
No.
You couldn't have moved to the side of that window real quick? I'm talking about before you even saw anything. You saw there was a window there.
No, there's an air conditioning unit next to me.
There's not enough room for you to stand there?
Not to move to the side.
What about the side closer to the gate?
No,
Why not?
because it's right up against the fence.
So
as
you
I
had
recall.
no choice but to stand right there where the bad guys can get to you if you're standing in front of that window.
Yes,
Use your flashlight going into the backyard?
yes.
What did we just talk about with flashlights? What do they do?
Let me see.
So again, nothing this officer did would have satisfied this prosecutor. He used a flashlight that's giving away his position. If he didn't use the flashlight, he wouldn't have been able to identify what he was looking at. Lose-lose.
What else do they do if there's bad guys around?
They can alert them to the position.
So now you're in the backyard of someone else's house and you just alerted whoever's in that home that you're present by flashing your flashlight, correct?
Yes.
That's not good police work, is it?
He's not charged with doing bad police work.
It's an unavoidable part of me inspecting the structure and looking around.
Well, I mean, because it's just not matching up. If you're so concerned about this structure and what's going on inside, then why are you also so cavalier with giving away your position in a private citizen's backyard?
I'm not being cavalier. I'm approaching it as cautiously as I can.
Cautiously as you can. Who's covering the front door while you and Officer Darts are in the backyard?
No one.
How many people could have run out that front door as you and Officer Darts are in the backyard?
I don't know.
A lot, right?
Yes.
All the bad guys could have gotten away, correct?
Yes.
And taken anything of value, correct?
Yes.
Is that good police work?
That was not the best. No.
But now you've given away your position to whoever's inside the house because you decided to turn your flashlight on in a citizen's private backyard. Is that correct?
Yes.
So now if there's anyone in that home, they know for a fact that someone is in their backyard with a flashlight. Is that correct?
Yes.
Now, is this an open area backyard? I mean, what I mean is it an easy backyard to get into?
No, I believe it's fenced all the way around.
Fenced all the way around. Is it one of those fences? Was there a cyclone fence where you can see through it?
I don't recall.
It was a wooden privacy fence, wasn't it?
I know it was at the gate.
You couldn't see in that backyard unless you opened that gate, right?
Correct. Excuse me.
Was it safe for you and Officer Darts in that backyard?
We didn't see anyone else in the backyard.
Can I approach the witness, Your Honor?
Yes, sir.
I'm showing the witness showing the witness states Exhibit 9. Is that the backyard that you can see kind of in the middle of it?
I think after this cross, I'll just go right into the redirect. I believe there was redirect by the state, by the defense rather. There definitely should have been if there wasn't. But I expect what we'll see. My recollection is that the defense did nothing to cure all of this improper argument.
Yes.
You can see the fence that goes all the way around it.
At least nothing effective.
Yes.
What is this building that's back behind the house?
I don't know.
Was it a tall building?
Yes.
Multi-story?
Yes.
This is where the prosecutor suggests that he should have been concerned about a sniper's nest in the adjacent building.
With windows looking down into that backyard?
Yes.
Is the garage, I mean, that's right there too, right? In the backyard?
Yes.
Now over here to the side of the backyard, to the west of where Atatiana was living, do you see another structure there?
Yes.
Is that a multi-story structure
Yes.
with windows looking down into the backyard?
Yes.
So you led your partner into a backyard with multiple multi-story structures with windows looking down into the backyard where any bad guys from anywhere could have taken shots from protected points of view at you or your partner?
Yes,
That's not good police work, is it?
it's part of police work.
That wasn't safe, was it?
Every day when we walk down the street, somebody could shoot at us out of a building.
Exactly, and that's why we have things like calling for backup, isn't that correct?
So every day walking down the street, he's supposed to call for backup? I mean, it's ridiculous on its face.
Who was screaming for help inside this house?
No one.
Who was yelling that they were in danger inside this house?
No one.
Who was running out of the house and creating such a commotion that you felt like they had needed all your attention?
No one.
Nobody that you know of is in the house at this point, correct?
Correct.
So instead of leading your partner into an area with two overhead positions where bad guys could be, wouldn't it have been smarter to have pulled back and asked for backup to set the perimeter?
I was trying to figure out how many people we needed.
Oh, you were thinking about calling for backup?
Once I saw what the state of the structure was, yes.
At what point did you think about you were going to call for backup?
Once I figured out how many doors we had and how many people we needed.
Did you call that in right then to the radio?
No.
You just kind of thought about it. Is that right?
Once I finished my inspection of the structure, yes.
Okay, tell me this. When did you finish your inspection of the structure?
I didn't.
So you thought about calling backup after you finished. So what you're saying is you wanted to finish your inspection first. Is that right? Is that what I'm hearing?
Yes.
But again, there was nothing exigent. There was nothing crazy going on that you had to finish it right then, correct?
I guess I'm not understanding your question.
There was nobody screaming for help inside, correct?
No.
There was no hostage situation. Was
The
there?
suspected burglary was the exigent
There was
circumstance.
nobody's life in danger, correct?
Not that I could see.
You didn't.
So there's a comment here. Law self-defense member Joseph says, a lot of the problem I see is that Dean's temperament comes off like a defeated puppy dog. He needs to learn how to testify with confidence. Yeah, but we probably have something of a Kim Potter situation here where he genuinely feels bad that Atatiana Jefferson is dead. I'm sure he's unhappy about it. Let's see. Any other questions? If you're watching on YouTube and can hit that thumbs like up, that's always appreciated, folks. Thanks.
Have any information that anyone's life was in danger, did you?
Not at that moment.
Matter of fact, you didn't have information that anyone was inside that house, correct?
No, not yet.
So there would have been nothing wrong with taking some time and setting a perimeter and calling for backup. Isn't that correct?
Other than that we're short-staffed and always try to do as much as we can with 2 officers, no.
There would have been, but the general orders say if you cannot cover all the exits, you need to call for backup. That's what they say, correct?
No, that verbiage is not in there.
Does it say that you have to secure all exits?
Yes.
And what happens if you can't secure all exits?
Then we'll call for backup.
Okay, so we'll use your verbiage. If you can't secure all exits, then we'll call for backup. Is that a better question?
Yes.
But you didn't secure all the exits here, did you?
No.
Matter of fact, the 2 biggest exits that there are, the 2 front doors, are just wide open for anyone to walk in and out of, correct?
Yes.
While you're in this backyard.
Yes.
That wasn't safe, was it?
That was not the best move, no.
And that's not good police work, is it?
This is all burden shifting. It's such improper argument. And it has nothing to do, it's completely irrelevant to either the criminal charges or the legal defenses in this case.
No.
Do you want to take your grade down some?
And the terrible part about this, really, folks, with the defense not objecting at all, is the defense had to see this coming. Like we talked about earlier, when the facts are on your side, you pound the facts. When the law is on your side, you pound the law. When neither is on your side, you pound the table. The defense had to see, especially at this stage of the trial, after the state has presented its case in chief and rested, that the state has neither the law nor the facts on its side. And so the only option the state has is to pound the table, to make irrelevant arguments, to shift the burden, to be argumentative, to badger the witness, and be prepared to hit that objection buzzer over and over and over again. Instead, they just sat there like they're sleeping.
Are you gonna answer the question?
Oh, I'm sorry. I thought that was rhetorical.
No, that's a question. You want to take your grade down, son? I just thought you were thinking about it like some of your other quick answers.
I don't think I did the best job at that, on that point, no.
You know what, let's stop the lunch, okay? We have the lunch here, and we'll come back at 1:15, okay? See you then.
Okay, that's the lunch break. Let me get us past the lunch break here.
Okay, so guys, we're just going to talk for a little bit while we wait. I guess we're waiting for the jury to come back in. This is kind of the standard fare for courtrooms. We were just talking.
This is only lasts a minute, folks. Here we go.
118, do you recognize that?
Yes.
And is that an open structure call that you went on back in 2019?
Yes.
Do you have any independent recollection of that call?
Vaguely, yes.
Do you remember walking through the structure and announcing yourself as Fort Worth PD
Yes.
on that open structure call?
Yes.
So again, there's nothing this cop can do that's right. If he shows up at the scene with a preconceived notion, that's wrong. But if he shows up at a scene and he evaluates the scene independently, that's also wrong. So if he had showed up at this open structure call and the house did not look like it was ransacked, they might well not have treated it as an apparent burglary. But the state of the house reinforced a reasonable perception of a burglary in progress. Carol Darch, his backup officer, testified to that. She was the state's witness. So it wasn't just that this officer, Dean, had an irrational, unreasonable view of the circumstances. His backup officer had the same view. So he's collecting evidence, collecting intelligence, making observations. That's bad. But if he shows up with just a preconceived notion of what's happening, that's also bad.
Then I'm handing you what's been marked State's Exhibit 119 and 120 if you want to take a second to review those.
$5 super chat from Clumsy Clairvoyance. He asks, Andrew, why do you believe the defense made the argument that the decedent broke the law by pointing the gun at the officer? Sounds like a bad argument. Yes, it's a bad argument. That was a terrible argument by the defense. First of all, it bought into the state's misstatement of the law. Self-defense on the part of Dean does not require that Atatiana Jefferson was doing anything wrong. The state lied to the jury by making that representation of what self-defense law required. Both Atatiana and Dean could have been acting perfectly lawful simultaneously, and both could have been justified in using deadly force in self-defense. It's not necessary that there be a bad actor in a self-defense case. There's awful but lawful self-defense shootings all the time. What matters is each party's perception of the others. They don't have to be a bad actor. There has to be a reasonable perception of a bad actor. So there's no requirement that Atatiana was doing anything wrong. She probably wasn't doing anything wrong, so it's a weak argument. Plus, then you put the jury in a position of who do they feel more compassionate for? Do they feel more compassionate for the cop who fired a bullet through the heart of a woman who was not, in fact, a bad actor? Or do they feel more compassionate for the dead 28-year-old? Why would you do that? Why would you put the interest of your client in juxtaposition with the dead victim? It's a terrible argument. The correct argument is that both of them could have had reasonable perceptions that they were acting lawfully. Both of them. And what's controlling here is whether or not Dean had that reasonable perception. And there was reason for him to believe he was dealing with a bad actor. He was investigating an apparent burglary in progress. So yes, very, very, very bad argument on many levels. First, the defense did not correct the misstatement of law. Then they bought into the misstatement of law. Then they put themselves in a losing position in an emotional contest between their client and the dead victim. It's just completely idiotic.
And so State Exhibit 119 and 120, are they about a burglary report call that you were dispatched to on May 14th? I'm sorry, let me make sure I have this correct. On May 11th, 2019.
Yes.
Would you be surprised to know that whenever you walked up to the shed behind the house, you announced yourself as Fort Worth Police?
No.
Okay. So earlier today, you said that you'd never announce yourself on burglary calls or open structure calls, but that's not necessarily true, is it?
I believe your question was burglary in progress.
Okay.
In that case, every call is different. And in that case, the call details stated that he thought they had been broken into sometime during the night.
But you didn't know what you were walking into at that scene, did you?
No,
But you announced yourself as Fort Worth PD.
just in case there was someone there.
Okay. So if I were, Your Honor, so if I were to ask you, I'm sorry, another question for the defendant. So if I were to ask you, there have been times that you've announced yourself at Fort Worth PD on open structure calls and burglary calls, would your answer be yes to that question? That you've announced yourself as Fort Worth PD?
Since I did it on that call, yes.
Okay. Your Honor, the state does not intend to impeach the witness with any specific matter. We would just ask that one blanket question again, to allow the witness the opportunity to correct some information already testified to in front of the jury.
Any objection?
Well, it's not correcting anything. It's relevance is the first one. It's collateral impeachment. It's improper impeachment.
I'll let you ask those general questions. Just don't go into any specifics of the call.
The state does not intend to go into any specifics, all
And do you intend to offer the call sheets or whatever that you handed to him to refresh his memory for purposes of the record?
Yes, Your Honor. The state would offer State's Exhibits 118, 119, and 120 for purposes of the record only. For the record, no objection.
All right, they're admitted for purposes of the record. Mr. Brissett, you may have a running objection. I'm overruling your objection. Both sides ready for the jury?
Yes.
I guess so.
You identified.
All right, everyone may be seated. Make sure I have everybody. Mr. Smith.
So if I were to ask you again, have you been dispatched to open structure calls in the past in your career where you've identified yourself out loud verbally as Fort Worth Police?
Every call is different, but yes, there have been some.
And there have been burglary calls that you've been dispatched to where you verbally announced yourself as Fort Worth Police, isn't that correct?
Again, there are different types of burglary calls, but yes.
So, all that stuff that's stacked up, the lawnmower.
So it's so despicably deceptive by the state, of course. You're not supposed to announce at a burglary in progress call because you don't want to alert the burglars in the progress of burglarizing the dwelling. If a burglary happened the day before or the night before, there's no expectation that the burglars are still there. Burglary is a transitory crime. So it's a completely different policy reason that you would announce or not announce. There's no reason not to announce if it's a past burglary. There's reason not to announce if you believe it's a burglary in progress and the burglars may still be present.
The weed eater, the bicycle that's being stacked up by you think the bad guy that's there in the house. Did you ever confirm the license plates of the cars to see if they did belong to the owner?
No.
Wouldn't it have been
Why would you do that first? Why would you do that before inspecting for forcible entry?
a good idea to determine if one of the license plates did not belong to the owner of the home? So you could maybe identify if your imagined perpetrator had a getaway car outside?
At the time, both of the cars matched the description.
Mr. Brissett.
Looks like maybe we're back, folks.
Rogers versus State, the defense would put stuff on outside the presence of the jury and the state for trial strategy purposes, but given the events that have transpired over the last 2 days we've been in court.
Oh, no, that's a replay. Never mind.
The record's very clear as to what was going on.
Sorry, false alarm. That's a replay of prior stuff. Back to the cross-examination of Aaron Dean.
That said they were supposed to belong to the house. I then turned my focus to the house to see what was going on in the house. I'm sure.
So you had no reason to think that anyone that shouldn't have been in that house had a car parked in that driveway?
Not at that point.
Well, did you just expect the burglar to pick up the lawnmower and the weed eater and the bicycle and carry it under their arms down the street? Where was
No,
the getaway car?
there could have been someone coming.
Could have been someone coming. Did you leave someone in the front yard and watch and see when they showed up?
No.
That would have been a good idea, wouldn't it have?
Objection to sidebar.
Stay.
Was that good police work to leave no one out in the front yard to see if the getaway driver was coming?
Objection, asked and answered.
Overruled.
It could have been better.
Was that good police work?
Objection, asked and answered.
Sustained.
Oh, finally, a couple of objections.
So, can we go back to playing the body cam footage, Your Honor?
Yes.
Okay, I'm gonna- Again, you're gonna tell this jury you had no room to stand somewhere to the side of that window?
No, not at that point.
Okay.
Bring it to Richie File, shots fired, Sergeant Supervisor. And then, sir.
turned around through body cam, where was Officer Dark standing?
She was in the gate at that point.
She wasn't behind you anymore?
Not at that point, no.
When did you know she moved?
I don't.
So there is no way for you to know who was, that if Officer Darts was behind you whenever you're up at that window, is there?
I trusted that she was standing behind me like we were trained to do.
But you have no way of knowing that night that she was behind you, do you?
If you're asking if I felt her, no, I did not.
And you don't have eyes in the back of your head, as you already said, so you did not know where she was, did you?
Again, I trusted that she was behind
Asked
me like we were trained
and
to do. Now
answered.
I don't know for
Badgering.
a fact.
And so right now, you've just shot Atatiana Jefferson. Is your gun, that Glock, is that a firearm?
Yes,
Is a firearm a deadly weapon?
yes,
When you pointed your gun at Atatiana Jefferson and pulled the trigger, did you intend for the person on the other end of that bullet to die?
I intended to stop the threat.
And stopping the threat means stopping the threat that they could die, right?
It's a possibility, yes.
And because pointing a gun and pulling the trigger, that's an act really dangerous to human life.
Yes,
If you do it to somebody else.
yes.
So, are you still standing in front of the window at this point?
No,
If somebody was looking outside that window that we see, and we've got this paused on 1:28 seconds, I believe. Someone from inside that window couldn't see out to you?
my apologies. I'm sorry. I thought you meant directly up against it.
No, but anyone inside that window, inside that house, can see you from that window, can't they?
Yes,
And if there were 10 bad guys, they could have 10 guns trained on you right now.
What about 1,000 bad guys?
And you're not doing anything tactical to protect yourself at this point, are you? You're just standing there. Isn't that correct?
yes, I believe so.
So all the bad guys that you think are in that house, they can take a free shot at you right then, and there's nothing you can do about it. Your gun's in your holster, isn't it?
No, it's in my hand.
Oh, it's in your hand. You still have your gun out.
I think so.
How come it's not trained on the window there?
It's a quickly evolving scene. We're moving around.
But the bad guys are all in that house for free to take any shots at you they want to in this position, correct?
So super chat, Andrew H, $5 super chat. Thank you very much, Andrew. He asks, how common is it for sentencing deliberations to take this long? What could be reasons for it taking more time than usual? Well, we don't normally have sentencing deliberations. It's not common for jurors to be involved in sentencing. The norm is that jurors are only involved in the guilt phase of the trial, and then the judge handles the sentencing. That's the norm. This is very unusual. Texas is very much an outlier for having this allowance for a sentence by jury, where you end up with this little mini trial and a second set of deliberations. So none of this is normal from my perspective. It's all abnormal. And when a judge does sentencing, often it can be a month. I mean, often there can be a big gap of time between the convictions and the sentencing. They do pre-sentencing reports. They do separate investigations of things, look for past criminal acts. They'll collect testimony. They'll have psychiatric evaluations. They'll get testimony from character evidence on things, kind of like what they did here in this little mini trial for sentencing. But none of this is normal. And unfortunately, it creates a weird situation where you can, in fact, end up with a hung jury on sentencing, which may well be what happens here. Now, someone had sent me a Texas Supreme Court decision that I just was reading while we were playing this back. It's from Court of Criminal Appeals. So Texas, if I recall correctly, their Supreme Court is bifurcated. So they have one highest level court for criminal matters and one highest level court for civil matters. So basically like two Supreme Courts, one criminal, one civil. And the criminal is the Court of Criminal Appeals. So that's the highest level court for criminal matters. They're handling an appeal from the state from the appellate court. So the mid-level appellate court. Below that, of course, is the trial court. And this involved the case in which a defendant, like here, had requested for sentence by jury. So he was convicted in the guilt phase, got to the sentence by jury phase, and there was a mistrial. Now, it wasn't a mistrial because of a hung jury. It was a mistrial because he went to testify on his own behalf at sentencing, and he was shackled. And the jury saw he was shackled, and they weren't supposed to see that. So his defense attorney moved for a mistrial, and the judge granted a mistrial for sentencing purposes, but not a mistrial for punishment. So that defendant, convict, appealed that judge's ruling as a matter of law to the appellate courts and said, no, if there's a mistrial on sentencing, it erases everything that happened before, even the conviction on the guilt phase. And the appellate court, the mid-level appellate court, agreed and basically dismissed the guilty verdicts from the guilt phase and said you have to retry this guy entirely. Well, the state appealed that appellate decision as a matter of law to the Court of Criminal Appeals in Texas, and the Court of Criminal Appeals reversed the appellate court. So the Court of Criminal Appeals decided, no, if there's a mistrial at the sentencing phase, sentence by jury phase, it only wipes out that sentencing phase. You dismiss that jury, you impanel another jury, and you have to redo only the sentencing phase. You don't have to redo the guilt phase. So that's what I expect would happen here. I mean, it's a weird situation because now you would have a new jury deciding on a sentence that didn't actually watch the trial. They're only aware of whatever witnesses or evidence may be presented during the sentencing phase. And I don't know if that would influence a judge to allow a lot more witnesses. Maybe the defendant would take the stand himself on sentencing. I mean, if I were this defendant, I wouldn't want to be sentenced by this jury if they had never heard my own testimony. If all they heard was the guilty, a wrongful guilty verdict, by the way. So I would want this jury sentencing me to be the jury that heard my testimony, but that wouldn't be the case if this sentencing jury is dismissed and a new one impaneled. Very, very weird. So let me see if we have any questions that have come in. Yeah, I've got a live stream going, folks. It's yes, so not this judge, but there was the previous judge on this case was removed from the case because of apparent bias against the defense and the defense counsel. And he was replaced by the judge we're seeing here. Let's see, questions. There were a few that piled up. From Law Self-Defense member Chuck, it wouldn't surprise me if there wasn't an under-table deal with the defense to throw the case. Well, it would surprise me. Chuck mentions that they replaced the first judge, and he linked to a news article about that. Thanks, Chuck. I appreciate that. Law Self-Defense member Kyle says, I would have thought, given our first impression of the judge, that he would have reined this stuff in. So I don't know. When I first was watching this judge, it seemed like he had good control of his courtroom. But he just lets everything in. I mean, he basically overrules pretty much every objection. And I can't help but wonder why the defense isn't objecting all the time. I mean, to almost every sentence of this cross-examination. And I thought, well, maybe could it be the judge? I mean, has the judge cowed the defense? It's very, very odd. Let's see. Tim S., Law Self-Defense member Tim S. Question, Officer Darch, your partner just fired a shot while investigating an open structure call. Do you need your partner to tell you he saw a gun? Or does the fact that he just fired his handgun for you to conclude things went to hell and danger level significantly increases? Yeah, that would have been a good question for Darch on cross-examination by the defense. Or on recall, they could have called her as a witness for the defense too. Right? After this cross-examination of their client, because Dean was the first witness called by the defense in their case in chief. So after they saw how this cross went, they could have called Darch, recalled Darch as a witness for the defense and asked her those questions. And they didn't do that. Why not? Why not repair some of this damage that they allowed to take place on cross of their client? Well, probably for the same reason they allowed the damage to occur in the first place. I don't know what that is, but it certainly doesn't strike me as competence. Let's see. Any new super chats? Nope. Okay, back to the playback.
If there were, it's possible.
Well, that's what you thought. That's what you told this jury earlier, that this was, you had determined this was a burglary in progress and there could have been lots of bad guys in the house.
I didn't have any way of knowing how many people were in there.
Coach.
We need to get in there. We need to get in there.
Yeah, you got your checkman kit?
Okay, so we paused it at 1 minute and 37 seconds. Where are you heading at this point?
Back around to the front to go inside.
So what, in your head as an officer, what do you know that you just left in that backyard on the other side of that window?
The person that I shot
With what?
with my gun.
I know, but what else is that person you just?
Again, there's nothing he could have done that would have been the right decision. So when he leaves the window after the shooting to go into the house, he doesn't do it fast enough. So he doesn't providing aid fast enough. But also when he does go into the house at all, he's leaving behind a gun that could have been used against him. There's no decision, according to this prosecutor, that he could have made that would have been the correct decision.
Shot. What do they have?
A gun.
Did you leave anyone back there to cover that exit at that back window?
No.
I mean, could the person, do you know for a fact that you hit the person that you shot at?
Yes.
Do you know if they're mortally wounded?
No.
Or did you know if they weren't capable of getting up and climbing out that window?
No, I didn't.
So who's covering your six when you and Officer Darts are running to the front of this house?
We've had a threat. I've shot the threat. The threat's down. Now we're trying to move into the house to render aid.
You just said you didn't know if the wound was mortal.
The person was laying on the floor and not getting up,
Could they have been playing possum?
I suppose.
Did you know if there were other people, other bad guys in there with guns?
Not at that time.
So who is covering your six, and Officer Darts' six, when y'all turn tail and run to the front of that home?
Going to the house and providing aid was essential because he's criticized for not providing aid fast enough. Leaving the window and going into the house was also wrong.
No one.
Is that good police work?
It's the only way to do that. We had to run inside and clear the house and render emergency aid to this person. There was no one else out there.
But see, you keep going back and forth. Were you going to the house to render emergency aid, or were you going in the house because there could have been more bad guys there?
Both.
Both. Okay. So if there could have been more bad guys there, was it a good idea to leave the back of the house without surveillance and expose you and Officer Darts' six as y'all ran to the front of the home?
As I've already stated, there are risks in police work, and I had to make a choice.
It wasn't a good idea, was it?
It was the only idea. It was the only way to do that.
Just like the only choice, is that just like you're telling the jury, the only choice you had was to shoot and kill Atatiana Jefferson.
Yes.
Did you have a choice whenever you didn't knock on that front door?
Yes.
Did you have a choice when you didn't announce Fort Worth police?
I could have, but I would have exposed myself to a potential burglar inside.
Did you have a choice when you did not knock on the side door?
Yes.
Did you have a choice when you did not announce yourself as Fort Worth police on the side door?
That's not what we're supposed to do.
Did you have a choice?
There's always a choice.
Did you have a choice to enter that home and open the door and see what was going on inside?
Not a safe one.
I made the best
You had a
choice
choice
under
whenever
the
you-
circumstances.
Did you have a choice whenever you could have stepped back, established a perimeter, and called for backup?
Yes.
Did you have a choice whenever you saw those cars parked in the driveway to establish that they were in fact the owners?
That would have been part of the procedure later, yes.
Did you have a choice whenever you did not call dispatch to contact the
Notice what the prosecutor's not arguing. The prosecutor's not arguing that what you did violated policy. He's simply saying there were other policy choices also available. Not that the one he picked was improper.
person that called police in the first place to get more information?
We weren't at that step yet.
But you had a choice, you could have done that, couldn't you?
Not without violating the general orders. We weren't at that
Which
step
one would
yet.
that have violated?
That would have been, we hadn't finished inspecting the structure yet.
I thought the situation was fluid. Was it not?
We were still investigating we were still inspecting the structure.
You made a choice whenever you did not further inspect the garage, correct?
Yes,
And you made a choice whenever you took Officer Darts right in front of that gate with your six completely uncovered without somebody in front of the house, correct?
police work is inherently dangerous and there were risks.
It's a yes or no answer. You had a choice, correct?
Yeah, so no officer is required to make the choice the prosecutor prefers. In hindsight, the general orders, all these scenarios have 2, 3, 4, 5, 6, 7, 8 things, steps, policies that the department would like to see done. You can't do all of them simultaneously. Some of them require assessment prior. Some of them can only be sequenced after others are done. 8 things can't be done simultaneously by 2 officers. So the question, the proper legal question is, did he make a reasonable choice from among the options? And the state brought in nobody to say that that occurred, that he made an unreasonable choice from among the options. A couple super chats. Tay Logan, $5. Thank you very much. Says this prosecutor is just asking questions on every scenario, which is not possible for an officer to complete on a call such as this or most any. Yes, absolutely. I mean, it's ridiculous. And the defense should have made that clear to the jury, and they never did that effectively. Phil Moore, $10 super chat. Thank you very much, Phil. I think all judges, prosecutors at the age of 60 or so should be exiled, like in the movie Judge Dredd. Keeps it fair for all the lives they potentially destroyed with bad faith arguments and sentencing. Look, the best immediate defense against this kind of prosecutorial abuse is a good defense counsel. The longer term defense against this kind of prosecutorial abuse is to elect better prosecutors. So most of you don't know who your local prosecutor is, do you? But he was elected. Somebody voted for him. Yeah, we have Danny On from Danny On Direct, her YouTube channel, Danny On Direct. She's a lawyer in the Salt Lake City area. She just ran for DA in her jurisdiction. She didn't win that race. I imagine she was quite the underdog, being a relatively young attorney and not expert in criminal law per se. Not that that should really matter. But she made the effort, and more power to her for having made the effort. But the only, we trust these prosecutors with enormous authority and discretion, and that can work okay if they're a high quality individual. But if you give that kind of authority and discretion to people who are politically motivated, you get politically motivated prosecutions, like here. Let's see. Did I answer that one? Yes, Phil Moore. Thank you very much, Phil. Let me take a look at the law of self-defense members. Let's see. Law of self-defense member Joe asks, with a little chance of appeal, how can one get the governor's office to review this case? Why would the governor's office want the heat of reviewing this case? Just go if you. It may pay to take a glimpse over at the law and crime chat on this, folks, because they, as usual, have the completely opposite viewpoint of the law self-defense chat. Completely opposite. Now, I think there are a bunch of ill-informed ignoramuses there. That's why they're at law of crime and not here at law of self-defense. But that suggests there's a sizable portion of the population who's completely bought the lies and misrepresentations of the state here. So a lot of people believe what the state is saying, even though it's not true. And why would the governor insert himself into that hot mess? Why would he want that hot potato? For this one guy who was a cop for 1 year? What's that get the governor? So no, I wouldn't count on the governor doing anything here. Law self-defense member Tim, question, comment. I can't believe how badly I would feel if I was a member of the jury, especially after the trial and finding out how badly the prosecution badly presented the facts and misstated the law. Well, the jury would probably never find out. I mean, how are they going to find out? They'd have to come to law of self-defense to find out. Right? I mean, the media is not reporting my analysis. They're reporting everything as usual favorable for the politically motivated prosecution. So, yeah. Who knows the truth? Who knows the actual law here? You guys do, because you're listening to me explain it. But the general public doesn't, and the jurors probably never will. Law self-defense member Kyle, comment. You've pointed this out before, but our SOPs had should and shall in the policies, and it wasn't strictly algorithmic, with many conditions providing multiple possible directions. Ultimately, it was the members' judgment that they trusted. Yes, of course, all of these things are subject, all these general orders, they're all subject to prioritization based on the facts, the circumstances, what's possible with the resources you have at hand, what's general practice in the department. Clearly, they don't send a SWAT team to every call. Clearly, they wouldn't expect our officers responding to a level 2 call to automatically call for a SWAT team when they got there before having investigated anything. I mean, this is all inanity. Let's see. Super chat. Let me take a quick look. Update that. Whoops. All right.
Yes.
And you had a choice whenever you walked off, you and Officer Darts walked in that backyard with exposure to unknown buildings that were looking over the backyard. You had a choice there, correct?
I suppose we could have just stayed home, but no.
Oh, you could have just stayed home? And why do you joke about just staying home? Is that because home is supposed to be a safe place?
It's not a joke. My point is simply that
It sounded like a joke to me. Is home supposed to be a safe place?
We object to the badgering, allow the witness to finish the question and answer it.
Sustain.
May the witness answer the question?
Well, re-ask your question, Mr. Smith.
Is a person's home supposed to be a safe place?
it is.
You should feel, if you don't feel safe in your home, there's nowhere else you're gonna feel safe. Is that correct?
I agree.
And this is Texas. There's nothing wrong with a person owning a firearm, is there?
No.
Irrelevant.
Matter of fact,
Objection.
If one of your loved ones was at home alone with a child and heard something in the middle of the night, you would hope that your loved one maybe would go to their backyard window with the
Objection. Irrelevant.
Maybe.
to protect themselves and the child. Isn't that correct?
Yes.
Especially if they saw flashlights in their backyard. Isn't that correct?
Possibly.
Flashlights of a person announcing their presence in their backyard where they're not supposed to be.
Possibly.
So you had a lot of choices that night, didn't you?
Yes.
Law self-defense member, Tax Pro Pam. She writes, the prosecutor's cross of Dean almost gives me PTSD. It's reminiscent of the never-ending circular arguments with my ex-husband. yeah, as someone who's got an ex-wife, I would concur with the genders reversed in my case, obviously. Yep, it does sound it sounds crazy.
Ready?
Okay, just pause it a minute, 50 seconds. You had no trouble with that front door, did you?
No.
You could have opened it just as easily whenever y'all first got to the residence, isn't that correct?
Yes, but that's not the procedure.
The Tatiana may still be alive though, correct?
I don't know that.
You still may have killed her?
If she had come out of the back of that house and pointed a gun at me, yes, I'd still have shot her.
3, 2, 5. Hands up! Show me your hands! Show me your hands! Show me your hands!
Did you just clear that room? That you just pointed your gun into?
I just did a fast clear.
Was that a really clearing of the room?
That was a fast clear. That's what you do.
Did you know if there could have been someone else standing to the side where you couldn't see once you walked through that door?
The camera doesn't see everything I'm seeing.
What did you see then?
I did not see a person in that room.
Do you know if they were hiding in a closet?
So again,
No.
he didn't provide aid fast enough, but also he should have taken time to search the closets of every room on the way to providing aid. So nothing this defendant could have done would have been the right course of action, according to this prosecutor.
I mean, because you're telling this jury that whenever you're walking through this house right now, you're still thinking there could be a threat in this house, correct?
It's possible, yes.
And you still haven't told Officer Darch that you saw a gun up to this point, have you?
No.
Hands up! Show me your hands! See what looks like a weapon here. Yeah, I'm good.
All right, we paused it at 3:08. Would you be surprised that according to the clock at the bottom of State's Exhibit 1, that you walked into that room at approximately 1 minute and, 2 minutes and 8 seconds?
I wasn't keeping track of time.
Well, I was. Would you be surprised if that was the time that you walked into the room?
That's what it says.
And now it's been almost a full minute later at 3:08, and you're just now touching Atatiana Jefferson. Is that correct?
That's what it says.
A full minute she laid there at your feet. Isn't that correct?
That's what the clock says.
A full minute she laid there bleeding out at your feet, at your hands. Isn't that correct?
That's what the clock says.
Without you doing one thing to try and save her life. Isn't that correct?
I had no idea how much time was passing, but that's what the clock says.
Morning.
Hey, you know wherever you and Officer Darch were outside by the cars, you said y'all whispered something. What y'all whispering?
She said, we've got to clear that car. I said, yeah.
That's it.
That I recall, yes.
There was no more whispering or communication other than that before y'all went through that gate.
I thought I heard her say something else, and I didn't hear it. And I said,
So no planning about what you were gonna do when you got on the other side of that gate?
We followed our training and did as we were trained.
No planning about what you were gonna do?
We didn't make a specific plan, no.
I mean, you had no idea what was on the other side of that gate, did you?
No.
That's why they looked.
An open air patio with a lot of people on it.
If he hadn't gone through the gate, the prosecutor would be arguing that he left himself and Darch in danger of what ninjas on the other side of the gate, like the snipers on the adjoining buildings. Nothing this officer did would have satisfied his prosecutor.
Correct?
Well, we'd have heard them, but
Could be the person back there waiting to ambush you, Officer Darts, correct?
yes.
It could have been somebody escaping the house from this burglary that you thought that was happening, correct?
That's why we were back there to check to see what was going on.
So $5 super chat from Jazz Trucking. He writes, the verdict could have been more favorable to the defense had Dean not testified. Isn't this why it's almost always a bad idea to testify? So there's three risks, three primary risks to having your client testify. There could be up to three primary risks. One is that if you're a criminal defense attorney and you got a client, in most cases, your client's a criminal. They've been in the system before. They likely have convictions before. All those prior convictions are likely to be inadmissible in the guilt phase of the trial as character evidence, which is generally inadmissible. But once your client takes the witness stand, he's a witness just like anybody else. He's subject to impeachment just like any other witness. And anything that could go to his credibility, including prior criminal convictions, may be now admitted when the jury would not have heard of those before. Now, generally speaking, not every prior conviction would be admitted. Most jurisdictions have rules about, well, it had to be relatively recent, within a few years. It has to be relatively serious, generally a felony, for example. There's a variety of rules, but it may suddenly become admissible when it wouldn't have been admissible before. The state may be able to bring in as witnesses people who know your client and will say he's a known liar in the community, things along those lines, which would not normally be permissible, but for you putting your client up on the stand. So that's one risk, that your client is now subject to impeachment like any other witness. In good guy cases of self-defense, that risk is generally not a problem because you're generally dealing with a client who has not been in the system before. So they don't have that criminal background. They're probably not liars. They're normally just normal people in their community. So you don't run that first risk of being punished via impeachment. The second risk is that the prosecutor may goad your client into an outburst because the prosecution will keep the client there for hours, like they're doing here, like they did to Rittenhouse. And they're trying to goad one of the things they're trying to do, they'll be sarcastic, demeaning, insulting, offensive. They'll badger, they'll insinuate bad motive until they get the client to do something like, did you just make a joke? Did you make a joke here and a woman's dead and you're joking about it? So they're trying to get your client to say something in the witness stand that would be harmful then, or could be characterized as harmful in terms of character or the general impression in front of the jury. That happened here. That was a risk that was actually incurred. And the third risk of putting a client on the witness stand is, remember, everything that's happening in the trial, if the lawyer is competent, is actually the construction of building blocks for the closing argument. So everything that's being brought out in trial is ultimately something that lawyer, whoever's doing the questioning, is hoping will be a component of their closing argument. That's why they're trying to get it out in evidence, so they can talk about that evidence in their closing argument. And often they're trying to get the defendant on the witness stand to say specific words, a specific phrase that they want to be able to repeat on closing. Even the defendant told us he didn't see this, or he didn't do that, or whatever it is that they're looking for. And they'll often, especially the prosecutor, will ask a question, the same question in slight variations, because they're not getting the exact phrase they want out of the defendant. So they'll ask it once, don't get what they want, ask it twice in a slightly different way, hope to get a slightly different response. And they'll do this repetitively until they're stopped, until they get the magic phrase they're looking for. Arguably, that happened here in the sense that the defendant kept saying, yeah, that wasn't good police work. That wasn't good police work. That wasn't good police work. So that was a risk that was actually incurred here as well. Those are really unavoidable risks of putting your client on the witness stand. So often you don't want to put your client on the witness stand. But when you have a bad outcome self-defense shooting like you have here, where a 28-year-old woman who was not actually a bad actor is the person who was shot dead, that jury wants to know why that had to happen. And the only way for them to really know is to hear it from the defendant. So I don't think it's really credible not to put the defendant on the witness stand, just like Rittenhouse had to take the witness stand. So no, I don't think it was a bad call to put him on the witness stand. I think he's completely inadequately prepared to be cross-examined. Like him saying constantly that wasn't good police work. His answer should have been, I made the best decision under the circumstances. There are no perfect decisions. There's always choices. And I made a reasonable choice under the circumstances. It should not have been, I did bad police work. I did bad police work. So some of the risks that he actually incurred could have been avoided, and he should have been cautioned against saying anything that could be suggested as being sarcastic or a joke, or attempting to show how ridiculous the prosecutor is being by saying, well, I could have just not showed up for work. Yeah. So no, I think they had to put him on the witness stand, but they should have effectively prepared him, and apparently they didn't do that. And he looks amenable to preparation. I mean, he doesn't completely lose his cool.
Hostage situation?
I suppose.
All those things that it could have been, and you didn't look at your partner and say, maybe we need to come up with a plan before we open this gate?
The plan was exactly what was trained. We open the door, the gate. One of us goes to the left and one of us goes to the right, and then we deal with whatever's on the other side.
Y'all didn't come up with a plan, did you?
The plan was made in training.
You didn't come up with a plan, did you?
No.
Thank you for answering my question.
Objection to the sidebar, Your Honor.
Sustained.
Yeah. So he's, you can believe, if you're a prosecutor, that the defendant you're prosecuting is guilty of murder. You're still not supposed to personally insult them in front of the jury. Let's see, law self-defense members. Let's see. Tax Pro Pam, who, by the way, says she's a brand new law self-defense member. Well, welcome, Pam. Welcome. She writes, question, I am new here. I discovered law self-defense and have only been following for about 6 weeks. If the sentencing phase takes days, weeks, or months, does the defendant remain out on bail as if the trial was still in progress, even though he's been found guilty? I don't know what the status is. I would expect the bail to be rescinded upon the guilty verdict. But that's, you know, that kind of detail is so jurisdiction specific that I wouldn't know what they're doing. I would just check the news to see if they have any reports about that. Normally, upon the guilty verdict, you're taken immediately into custody, and whatever bail existed is revoked because now you're guilty. You're convicted. By the way, you might be surprised to learn that if you're acquitted at trial, you often don't just get to walk out of the courtroom. You have to go back to the jail and be processed out. Can you believe it? But that's the procedure. Let's see. Law self-defense member Paul in Florida says, could have been Godzilla in the closet. Yeah, indeed. Could have been, right? Could have been a bunch of home invasion kidnappers, snipers, ninjas. Who knows? Could have been. New law self-defense member, Tax Pro Pam says, he may have addressed this while I ran a couple of errands. If it was addressed before today, I may have just missed it. I try to listen to work at the same time. Sometimes work wins the competition for my attention. I get it, folks. You can't always be here all the time like I am, but this is my work. Let's see. Law self-defense member Kyle Cowden says, this pisses off my being pissed off. This pisses off. My being pissed off is when the defense does object here. The judge sustained more than he overruled, yet they sat on their hands. Yes, right. So if your objections are getting sustained, that should be an incentive to object more, right? Crazy. Absolutely crazy. And by the way, with the prosecution, when the objections are overruled, that incentivizes the the state to be even more aggressive and overreaching and making improper argument, which is what they should do if they're being aggressive attorneys. I mean, of course, I think the state's being despicable here on the merits, but if the prosecutors are zealously pursuing a conviction here, the defense lawyers should be zealously defending their client. They're not. Let's see. Law self-defense member Tax Pro Pam. I assumed one would have to be taken into custody upon the guilty verdict. Thankfully, I never had to encounter the guilty verdict scenario. Yeah, so I assume he was taken into custody, but I wouldn't know for certain. Okay, let's get back to the replay.
Yes, sir.
So I think they're wrapping up cross here. Yeah, in terms of what's going on with the jury, of course, we don't know. I mean, anything we would say would be speculative, but it's possible that one or more jurors agreed to the logically insensible reckless manslaughter conviction to avoid riots, and then believed that they would have the opportunity to ameliorate. Hey, Ian, how are you?
Doing all right. Let me just fix my audio there. There we go.
So I'm just replaying parts of the trial since nothing's happening with the jury, still in deliberations on sentencing here. But I was just speculating that one thing that might be going on is one or more of the jurors may have agreed to vote guilty on the logically insensible reckless manslaughter charge in the belief that they would have an opportunity to mitigate the sentence to parole for the officer during the sentencing portion. And now they're finding that's not the case, that other jurors want the maximum of 20 years. And so they're not willing to go there. They don't want to exorbitantly punish the officer for a politically motivated verdict in this case.
That wouldn't surprise me at all if we've got some real disparity on, if there's a compromise on sentence or on the conviction, that we might be seeing some real arguments in the back room.
Yeah, because the conviction itself just doesn't make any sense. I mean,
yeah,
unless the jury allowed themselves to be convinced that all the irrelevant things not related to the use of force decision that this officer did, like the way he crossed the street to approach the house, that if that was done, quote unquote, improperly or in a suboptimal manner, that could constitute the recklessness necessary for manslaughter here. Frankly, I put the fault on the defense for that, if that's the conclusion the jury came to, because it should have been made clear to the jury that what needs to have been reckless was the use of force decision, not other things unrelated to the use of force decision. So maybe that's how they got there, or maybe it's just they just compromised on manslaughter because it was available.
I suspect it's more of that. I mean, here in Canada, they just recently changed the self-defense laws to actually create this whole thing of you have to consider everything, like how we walk there and so forth. So I'm going to have a video on that because a guy, Peter Cahill, I think it is, was initially acquitted on a self-defense shooting, and then later they went up to the Supreme Court and overturned the acquittal. And now he was convicted of manslaughter. So it wouldn't surprise me at all.
They overturned an acquittal. That's not really a thing in America.
Not at all in America. And I mean, I think they ran out his money as part of it.
Well, that's a thing in America. Yeah, that happens here all the time. I see that a lot where people get they go through a first trial and maybe they get a mistrial at the end, or maybe they get convicted, but it gets reversed on appeal. They get remanded for a new trial, and they're broke. I mean, they don't have any more resources. They spent all their money on the first trial.
Yeah,
and I see that happen all the time. So they won. I mean, they won in the sense they got their conviction reversed, but they have. And you'd like to think you live in a world where the resources you have wouldn't affect the justice you get, but the resources matter, folks. It makes a big difference.
Huge. And here in Canada, we see things where somebody gets acquitted on with a really, good lawyer on their first trial. That gets reversed. They run out of money. The good lawyer's not going to do it again.
Right.
And so in some cases, they've even been like stuck self-representing on their next trial. And then sure enough, they get convicted and we're like, yay, good job, everybody. Like, I'm not a fan of that.
Yeah, so I don't know if they do this in Canada, but here in the U.S., they have various companies that present themselves like "quote unquote" self-defense insurance companies. They cover your legal expenses if you're involved in a self-defense event. But some of them, their obligation to you ends the moment you're convicted, or take a plea for that matter. But if you're convicted, now you're just a criminal in their eyes, and they're not going to pay for your legal expenses anymore, which means there's no appeal for you.
Yeah.
And they're not going to cover you for a retrial. So the one company I recommend actually continues to cover your legal expenses. So if you're convicted and you appeal, they pay for the appeal. You get reversed on appeal, you get a second trial, they pay for the second trial, for the third trial, whatever.
Nice.
It takes in terms of your legal defense. Yep. That's CCW's, by the way, folks.
Oh. Yeah, that's always critical with people asking about insurance stuff, because you never really, insurance companies have a substantial disincentive to help you once you're actually needing the help. Because at that point, but we see that here where there's people who are like, I have this gun insurance. And often it's like, you realize that this insurance doesn't cover you for most of the things you think it does, right? So I like that if they stand behind people and actually provide the full coverage.
Let me see if I have any questions here. Law of self-defense members. The process is the punishment. Law of self-defense member Tax Pro Pam says the process is the punishment. Often it is. Often you see in these politically motivated prosecutions that it's only that the state can't lose. They can only win. There's only upside to bringing the case because they prosecute you. Either they get a conviction and they say, see, we were right. He's a bad actor. He was found guilty by a jury. Keep in mind, innocent people get convicted all the time. Appellate courts exist because trial courts get things wrong. So just because someone was found guilty, like in this case, doesn't mean they were found guilty on the legal merits, that they ought to have been found guilty. But anyway, the prosecution then says, look, he got found guilty. We were right all along. Or they're acquitted, and the prosecution says, well, we fought the good fight for our team. That's what they do when they prosecute Rittenhouse, when they prosecute Zimmerman, acquitted on all charges. But those prosecutors gain political capital. Even though they lost in court, they won in the broader political sense. So it's a win-win for them. They can't lose, so there's no incentive for them not to bring the prosecution. And then, the punishment itself becomes brutal. Rittenhouse is still involved in all kinds of lawsuits he's defending himself against. And of course, he had all the expense of that. And at least in his case, he was able to raise a lot of money. Zimmerman was able to raise a lot of money. But all these social media type platforms, GoFundMe's and such, they're quick to shut down fundraising for enterprises they don't favor politically. So I wouldn't count on being able to raise money that way if you're involved in a use of force event, if there's any political or racial component to it at all.
Did Rittenhouse, did his fundraiser get shut down? I'm trying to remember all of the fundraising because he had various efforts that he had.
Well, he raised a ton of money for sure. But I think it was raised by one or two of the big lawyers that were involved in this case, the big name lawyers whose names I'm blanking on now, who had very high political profiles as well. They managed to raise a ton of money, although only indirectly for him. So I think there were complaints by Rittenhouse that they were collecting money in his name and then not passing it on to him, or they were collecting money in his name and then not working hard to get him out on bond because they could raise more money if he was still being held in jail. Right? He was a more sympathetic figure.
Yeah, that's that's not fantastic. But it does happen.
That's pretty shitty, right?
Yeah, the sad thing is that there's all sorts of conflicts that come up in law, and people don't really think about just how easy it is to get a conflict with your lawyer in that sense. And it might not be a conflict that prevents them from working, but
so law of self-defense member Tax Pro Pam says Linwood is the lawyer's name I was thinking of. Linwood swindled Rittenhouse. I'm not sure if he swindled him or not. That's just I'm just reading the chat, folks. But I know there was tension about that issue between him and Rittenhouse for sure.
Yeah.
I'm not sure how it worked out. I don't follow the kind of political stuff all that closely. I'm just a small town lawyer, folks. So what, Ian, why don't you tell people where to find you, what you do, all that kind of stuff before I get back into the replay of the cross?
So I'm at Runkle of the Bailey. I do criminal defense and firearms law, although I talk about a sort of variety of things. Right now I've been, some of the coverage I've been doing is about a, have you heard of GWAX, the gun company, sort of?
I don't think so. GWAX? W-A-X?
GWAX. Yeah. There's actually two companies. GWAX Defense makes like a gunshot detection system. So
Okay.
that it's got speakers to listen to it. And then because they needed guns, they formed GWAX Armory as this company to basically own the guns. And they started making a monolithic polymer lower. And then they ran out of money and they couldn't make a new mold. So other companies started making monolithic polymer lowers, and now they've accused them of violating all sorts of trade secret rules. But their trade secrets were things that they were emailing out to people who asked, and there's no indication that the guns that they're upset about were actually manufactured using their trade secrets. And the guy behind it, the funding guy, said,
is this an American company in Oklahoma?
It's an American company. Yeah.
Okay. GWACS.
Yeah.
Okay. Got it. Yeah.
And he said, like, I'm not going to fund any more AR-15 stuff, but I will fund this lawsuit, which has people going, so is the point actually that you are upset that people are preventing you from competing fairly? Or is it just that you're upset that, you just want to use this to shut down AR-15 production? And that's what it looks like. So I've described them as an anti-gun gun company.
Okay. So. All right. Yeah. Okay. When I Google it, one of your videos comes right up. Yep. Uncle of the Bailey. GWAX, the anti-gun company, seeks a gag order, gets clowned.
Yeah. It's a funny one.
So I encourage you folks, go to Runkle of the Bailey on his YouTube channel. Check out what he does. He does great work.
Oh, thank you.
Great work. Always glad to have you on. So we're just going through the cross here of poor Aaron Dean, and I mean the state just beats him up like a punching bag. Nothing substantive. I mean they can't point to anything he actually did wrong. I mean, in a sense, everything he did was wrong because there was always an alternative choice he could have made in hindsight. But they can't point to anything that says, well, doesn't that violate, department procedure? Everything he did was consistent with department procedure. It's just he didn't do the other thing. And whatever he did was the wrong thing. So when he goes through the gate, that was the wrong thing. But if he hadn't gone through the gate, he wouldn't have cleared the backyard. There could still have been bad guys coming out of there. When he goes into the house, he doesn't go in the house fast enough to provide first aid. But when he goes into the house, he should have spent more time clearing all the closets before providing first aid. It's the old argument. If you use hollow point, you should have used ball ammo. If you use ball ammo, you should have used hollow point. There's no answer that'll satisfy the prosecution. There's a lot of burden shifting where they ask him to grade his police work like on a A, B, C, D, F kind of scale, as if he's charged with the crime of unsatisfactory police work. And of course, it would suggest to the jury that, well, if he gives himself a B, obviously he did it wrong. He must be guilty of something. But most importantly, so he concedes repeatedly, well, I could have done that better. That wasn't a great job, maybe 30 or 40 times. And the defense really never objects. I mean, it must be an hour and a half of cross-examination, maybe more. And the defense had maybe five or six objections during that whole time. And they could have objected to almost everything because almost everything asked about was irrelevant to the criminal charges or the legal defenses, like how he crossed the street. That has nothing to do with anything. But they're allowed to ask about it endlessly.
And people really underestimate, if you're ever in a self-defense situation, everything that you do is going to be questioned. And there are never right answers. Like, it's never that you did things right. It's never, because you just can't. There's always some way to second guess it. Even, the hollow point versus ball ammo is a great, whatever you picked, it should have been the other thing.
Right. And they actually made that argument in Rittenhouse.
Yeah.
The state did. So Law Self-Defense member Tax Pro Pam says Rittenhouse was on Seb Gorka's radio show last week trying to gin up more funds for his legal expenses. Yeah, I think I've seen Rittenhouse on Twitter and stuff linking to some kind of fundraising effort, but I don't know any of the details of that. I think Rittenhouse might be on Ricardo Law soon. I thought I saw somebody mention that.
Yeah, no, he was, that was something they were planning to do. So I want to see that.
Law Self-Defense member Tax Pro Pam says, I don't understand why Dean didn't respond to most of the prosecutor's questions with, I followed department procedures. Instead of saying I could have done that better, he should have always said, I made a reasonable choice under the circumstances. I made a reasonable choice under the circumstances. There's always multiple options, but I made a reasonable choice under the circumstances. Not, I did that bad.
And that comes down in part to client preparation because...
Yep. Yeah, I was saying earlier that to my mind, there's three negatives of putting your client on the witness stand. One is that typically your client's a criminal in the criminal defense case. So all their prior convictions and stuff gets to come in when normally that would be withheld from the jury. Second, the prosecutor might goad your client. The prosecutor will be insulting, demeaning, argumentative, and they'll try to goad your client into some kind of outburst that'll make him look bad in front of the jury. That happened here. This defendant made something that sounded like a joke when the case is about the death of a 28-year-old woman, or said something. I don't think he meant it as a joke, but it could be characterized by the prosecution as a joke, and they did. And third, the prosecution is fishing for building blocks they can use in their closing argument. Everything is leading up to closing, and so they'd like to get exact phrasing out of the defendant's mouth that then they can repeat at closing. Even the defendant told us X. And often they'll ask slight variations of the same question in an effort to fish out the precise phrase they're looking for that they want to be able to repeat. And of course, the defendant has no idea what the prosecutor's looking for or what not to say. And he ends up providing the prosecutor with essential building blocks for the closing argument against him. Here, this, at least in the guilt phase, this defendant didn't have any prior bad acts to come in. But he did get goaded into making something that sounded like a joke, and he did repetitively concede he didn't do good police work, which brought back up in closing, of course.
Oh, it's brutal when they you can't prepare somebody enough, but you can do better than in some cases than in others. So
yeah, no, I had a question. How often, how much do you prepare a defendant if you're planning to put him on the witness stand? And I'm like, until you run out of time. I mean, you're continually preparing him until you run out of time.
I had a client who was like, why do we have to go over this again? Because we do, right? This is the rest of your life. Crown was asking for something like 8 years, which, is a big sentence by Canadian standards and not that big by US standards, but still life, ruining, right?
Right.
You lose your 20s to being in jail. You get out and it's like, okay, well, now I've got no prospects. I'm behind everyone on education. And I've got this giant resume hole that you just can't explain. Good luck with any of your hopes and dreams. And he's like, oh, no, I got this. I'm like, you really don't, though. And then he gets up on the stand. He did well. He was acquitted, and he should have been. But he came out and he was like, I wasn't nearly prepared enough for that. It's like, no kidding. Didn't we have this talk?
Yeah, everyone thinks they'll do fine on the witness stand. And I always ask them, have you ever been subject to cross before? And of course the answer is no. But it's like people who think they're going to do fine in a deposition. You have no idea how brutal a deposition can get if you've never been in one before. And they'll gut you like a fish.
We had a local lawyer who got charged with trafficking drugs into a prison or into a jail. And he gave a statement to the police, and it's pretty clear he thought that he was going to talk his way out of that. It's like, you might have watched 1,000 of those, but you've never been in that situation. And he gave up all sorts of things. So, it's tough.
A client who represents himself as a fool, a lawyer who represents himself as a fool for a client, right?
Yep.
Yep. All right, so I think the cross may be wrapping up right here. And if I can't, honestly, I know they did. I believe they did redirect, in which case I'll just flow right into the redirect. And I pause every once in a while to answer questions and things along those lines. But let me kick this back in while we're still waiting for something to happen with this stupid, let me see. That's just a replay in long crime. Okay, here we go.
You just watched the video again, and you've seen it a few times, haven't you?
Yes.
Did you shine your light right in that back window where Atatiana Jefferson was?
Yes.
Wasn't that just basically putting a spotlight to all the bad guys that you imagined were inside that house, telling them exactly where you were?
Police work's inherently dangerous. I had to go look inside the window to see what was going on, to see if there was a burglary.
Again, he's wrong for using the flashlight because it gives away his position. But if he hadn't used the flashlight, the prosecutor would be arguing, isn't it true it was too dark to really identify any threat out there?
Can't win.
It's inherently dangerous, but didn't you make it more dangerous by saying, look at me, look at me, look at me?
Someone had to go back there and clear that window and see what was going on inside that house.
So, and you were gonna be the hero, right?
No.
You were gonna charge in and save somebody from whatever was happening inside that house, correct?
No.
You were gonna be a hero, ignore the rules, ignore trying to set up a perimeter because you had decided that you had to do something, correct?
No.
And you decided to put your window through that, put that flashlight through that window, correct?
Yes.
And anybody that was inside would have seen you, correct?
Yes.
Any bad guy that you potentially imagined being there would have seen you, and they would have been alerted to your position immediately.
Yes.
Is that good police work?
That's how you clear an open structure.
Is that good police work?
Yes.
To risk your own life and Officer Darch's life?
Risks are inherent in police work. I had to go.
You had to turn the flashlight on.
There's no other way to see.
No other way to see. You made that choice, didn't you?
It's a dark night. I had to use my flashlight. Yes.
So all this other stuff that you didn't want to announce your presence, that's when you decide to announce your presence. Right then, through that back window, in someone's own backyard, in a private citizen's backyard, through a gate that was shut, back there through a window. Now it's finally when you decide to announce your presence.
Because I thought we had a burglary.
And you didn't announce your presence with Fort Worth PD, did you? You just used your flashlight, correct?
No, I just used my flashlight.
And whoever was in that house had no idea, did they?
I don't know.
Whoever was in that house had no idea what was coming, did they?
Yeah, object speculation.
Whoever was in that house had no choice what was about to happen next, did they?
I'm not sure what you're asking.
We'll pass it with this.
Redirect.
So I put a poll up on the YouTube channel. Sorry, folks, I don't have a way to do that for the Law Self-Defense members, but on the YouTube stream, asking about what you predict the jury will return as a sentence. All right, not what you think would be an appropriate sentence, not what you think would be appropriate, but what you think the jury might do. After we let this run a little bit, then I'll put up a separate poll asking what you think should be an appropriate sentence. But the choices are 20 years, which is the max here, more than 10, less than or equal to 10, or probation are the options, which of course would be no time served then.
Correct.
Aaron, you know now that Zion Carr not only had enough time to discern that you were back there, but was able to recognize that you had a Fort Worth badge on, correct?
Yes.
And you know now.
This is bad by the defense. So the point they're raising is that the kid says he could see a badge through the window. And I guess we're supposed to infer that therefore Tatiana would have seen a badge through the window. That's speculative, and it's not relevant to the legal defense. It doesn't matter what Tatiana thought. It matters what the defendant perceived, reasonably perceived. And it's part of them trying to make her look like a bad actor. She was doing something wrong. That's why this happened. And that's forcing the jury to decide who they like more, the cop who fired the fatal shot into the 28-year-old or the dead 28-year-old?
I wonder how that's gonna go.
It's just such a stupid idea.
Now, from watching the entire video,
Yes.
that he knew that the boy police officer is the one that discharged his weapon and not the girl police officer.
Yes.
The prosecutor spent some pretty significant amount of time asking you what you could see when you went to different parts of the structures. Do you recall that?
Yes.
Can you see more than your camera on your shoulder is collecting?
Yes.
Can you observe a door, whether it's the pedestrian door or the roll-up door of the garage, and make a quick scan by moving your head where your shoulder may not move and see if it's secure?
Yes.
And that's reason and common sense, isn't it?
Yes, it is.
You were ordered to be there, were you not?
Yes.
You were assigned a call and you had to check, correct?
Yes.
Regardless of whether you left anybody at the front door, somebody from the City of Fort Worth Police Department was going to have to step foot in that backyard to clear the open structure, correct?
That is what the procedure instructs, correct?
You were taken to great task on cross about your fast entry into the house, but then not rendering aid fast enough. You recall that?
Yes.
In your training, were you given a scenario during survival week or weeks before or after that about active shooter and getting into a structure to render aid?
Yes.
What we see on the video of you and Carol doing a fast clear, is that consistent with that type of training?
It is.
Are you taught to, you're going in as a two-person team at that point, yes?
Yes.
And you're gonna take on any threat head on as you get there, because you've gotta go at this point to get to the first aid part, correct?
Yes.
When you get inside, does the event catch up with you once you're inside and find the weapon?
Yes.
Explain that to the jury.
Once I found the weapon and picked it up, just to move it away from the person, I saw the green laser on it. And you hear me go. It's because at that moment I was thinking that's how close we came to dying. Then I set it down, and to my memory, was moving right from one thing to the next. This was passing very quickly. I had no idea until several months later when I saw that camera footage at my lawyer's office that much time had passed.
You would agree with me, the prosecutor asked you on cross-examination if there's any audio or any conversation between the two of you. You haven't had a chance in the lab to listen to that under headphones and amplification, and you can actually hear what's going on in my have you?
No.
We wanted you to testify without having any outside influences to what others may hear on the tape, correct?
Yes.
There was a question early on Mr. Smith's cross about y'all walking up the driveway and you didn't know where darts was. That's different than the training and experience you guys practice when you cross over in the backyard. Is that, you recall those two different questions at different
Yes.
times?
So confusing.
They're different. You knew darts was down the left side when you were walking up the cars.
Yes.
When you illuminate the cars, are there any windows on the, we look at addressable side A, B side of the building being the east side?
Yes.
There's no windows down there, correct?
No.
The prosecutor asked you if you were gonna walk into some sniper's nest. Whether he called it or not, that's what it is when you have a perch on a second story, correct?
Yes.
feel like there was any sniper's nest with this open structure call?
No.
You have to check all four sides of the structure, and you ran into trouble when you got to the back side of the third side, correct?
Yes.
Did you ever get to the fourth side of the structure to check it?
No.
In looking in that window where this incident took place, would you be able to get a better vantage point as to what's inside going back toward the front windows and door?
Yes, that's what I expected.
You were asked about looking through the front doors and walking across them, whether or not you backed up to Kansas to walk around the doors. Are you able to make observations inside an area to see if it's clear to slide past it?
Yes.
Are you able to make observations as an officer and look through a doorway and make a decision whether or not at that second, at that moment in time, there's a threat and you can clear it and move on?
Object on the leading.
Suspend, don't leave your witness.
Tell the members of the jury what it is to clear a door properly, since you weren't allowed to answer those direct across.
Well, when you clear the door, whether you do it slowly or quickly, you look through it, across it to see that there's no threats at that moment, and then you proceed on at that moment if it's clear.
Now, you're an engineer. You didn't have a protractor up there, did you?
No, sir.
Are you clearing this with a sweep of your eyes?
Yes.
Are you taught that day in and day out at the academy?
Yes.
Is that part of the muscle memory you testified about?
Yes.
On that night when you got in the back?
So, I really don't like this whole muscle memory notion that they keep bringing up. I mean, it's okay to say someone acted consistent with their training, but when you say muscle memory, it makes it sound like it's reflexive and not requiring actual decision making. But if you're killing someone in self-defense, that requires actual decision making.
And I don't know. I mean, they really need to frame the training aspect properly to note, if you have an issue with the police, because a lot of people do have issues with policing, that doesn't make this guy guilty. It makes it an issue, for the police. I'm worried that the jury's sitting there listening to this and going, well, at the end of the day, we don't like his training. So we don't think his training
We don't
is
like the
reasonable.
policy, right?
Yeah. And
they convict him for policy.
Yeah, they got to frame it to this specific guy. And that's, most self-defense or, most lawful shootings fall into the lawful but awful category. And they got to sort of frame that properly.
Yeah, it's somebody in the chat says, what's wrong with Danny's voice? You guys will never stop.
That's going to keep going forever.
Yeah, because we had a bad outcome here, right? I mean, that's why this guy had to take the stand, because it's a bad outcome case. Someone was killed, 28-year-old woman who was not actually a bad actor was killed. The jury wants to know why that had to happen, if they're going to think favorably in terms of the person who did the killing. So I don't think he had any choice but to take the stand. I think he ought to have been much better prepared than he was. And I can't help but wonder how much of this. So I don't know if you're aware, but his lead counsel, who'd been on this case since it happened 3 years prior to the trial, was very old and sick and died like a week before the trial.
Oh, geez.
Now, apparently he knew he was dying because the two counsel who were in the courtroom here were brought on this past summer. So it's not like they were suddenly handled the case, days before the trial. They'd been involved, but I can't help but wonder if there was a clear kind of baton handover. You know what I mean? Like maybe these guys thought this defendant had been better prepared for cross-examination. Maybe the lead counsel had a completely different theory of the case, narrative of the case that was much more compelling than what these guys did. But because he was old and sick and dying, he didn't do an effective job of getting it to these guys, or these guys didn't do an effective job of getting it from him. It's certainly something that's not common to have your lead counsel die the week before the trial starts.
Yeah, and it makes a sort of wonder about, are these replacement guys the guys he would have picked had he known that they were going to be the people he'd be fighting for his life on?
Did he pick him, or did he just let his lawyer pick him? His lead pick him. Say, hey, I know a couple guys who can step in for me because I'm too sick now to do this. And he just trusted his lead counsel, but maybe his lead counsel's decision making was compromised at that point. I mean, let's face it: if you're dying, there may be things more pressing on your mind than, you know, shelving off all your work to other attorneys to take over.
Yeah, it might have just been who's got time in their schedule as opposed to who's the best person for the job.
Yeah, interesting.
And sadly, the people who have lots of time in their schedule, there might be a reason why their dance card is open.
Right. Law self-defense member Paul in Florida writes, I was deposed once and the lawyer kept pausing mid-question. And when I started to answer, she yelled at me to wait until she was finished asking the question. Really irritating. Yeah, some lawyers do depositions that way. They're trying to knock you off your feet, basically. And sometimes they'll ask questions and then they'll pause. And now you're waiting for them to maybe complete their thought. And they yell at you for not answering the question promptly. I mean, it's like with this prosecutor, there's nothing you can do that's the appropriate response. And it's because they're trying to shake you. Maybe because they don't think they can get favorable responses from you on the merits. So they're looking for an outburst. They're looking for you to say something that could be mischaracterized. They're looking at you to basically answer the wrong question, you know, answer half the question, and then give a response, again, that can be mischaracterized. Let's see if there's any super chats that have come in. Nope, we're good. All right, continue with the redirect.
Backyard, are you protecting not only yourself, but Officer Dark
Yes.
and passive witness?
Mr. Smith.
But again, you didn't know for sure.
So that was like an hour and a half of cross and like 5 minutes of redirect. There was a lot of ground to cover on redirect, a lot of damage to fix from that cross. And that was such a superficial response. And now, of course, they're back on recross right away, the shouting prosecutor.
Where Darts was behind you in that backyard, did you?
There is no way I could prove it. I trusted that she was doing what she was trained and was standing right behind me.
Before the defense attorney got to ask you that follow-up question, you testified earlier that you had no way of knowing for sure where Darts was in that backyard. Are you changing your testimony?
No, I have no way to prove where she was standing. I trusted that she was standing behind me as we're trained.
And don't the general orders say on a silent alarm, which is how you treat an open structure, correct?
Yes.
That all main exit ways should be guarded so as to prevent the escape of any offender.
Yes, they do.
And y'all did not guard all the main exit ways, correct?
No.
The two biggest exit ways when you walked up to that house on East Allen Avenue are the front door and the side door, and those were left completely unguarded, correct?
Yes. Not
one person could tell you if anyone walked in or out of those doors while you and Officer Darts went to inspect the backyard, correct?
No.
And that's
All completely irrelevant. I mean, this was an irrelevant hypothetical. There were no bad guys. In any case, you can't simultaneously guard a door and walk around the structure looking for signs of forced entry. You have to make a decision about what you're going to prioritize. And it's irrelevant to the criminal charge or the legal defenses in this case. But no objection from the defense ever, it seems. Hardly ever.
violation of general orders, isn't it?
It's not a perfect execution of the general orders.
You still sticking with that lead?
Yes.
There's been some questions from the defense attorney, and you've talked, and you keep calling it a weapon.
Yes, because it is.
As Tatiana had. I mean, you didn't yell weapon to Officer Darts before she walked in, did she? Did you?
No.
That's because a weapon can be a lot of things, correct?
Yes.
A weapon can be a knife.
Yes.
Correct? A weapon could be a lead pipe, correct?
Yes.
A weapon could be a sword, correct?
Yes.
And you said nothing specific to Officer Darts before you let her into that house. Wow.
So this is a big part of the prosecution narrative, is because he didn't shout gun. He shouted, "Show me your hands." He didn't tell Darch after he fired his single shot that he fired because there was a gun. And so the state's trying to suggest that the jury should draw a negative inference that therefore he had not actually seen a gun when he fired the shot. Even though the gun was found next to the body, the 8-year-old nephew testified that the aunt had pointed the gun at the window. So the overwhelming weight of the evidence is that it's consistent with the defense narrative that the gun was pointed at him. We're supposed to draw this negative inference from the fact that he didn't say the word gun. And the defense never adequately addresses this. And it wouldn't be hard to do. They could have asked him on on redirect, when are you allowed to use your gun, fire your gun lawfully when I'm facing a deadly force threat? Wouldn't it be reasonable for your partner to infer that if the gun fired, that's constructive notice that you were facing a deadly force threat? And by the way, they could ask that question directly of the partner when she was on the witness stand as a witness called by the state, or they could recall her as a witness as part of their case in chief. And they never adequately addressed it when his not saying gun is such a huge component of the state's narrative of why we should not believe him.
And I mean, it's so ridiculous. It's like this fragment of time, and you're under stress. Like, people do different things.
Better walk into that house, did you?
No.
Pass the witness.
Mr. Brissett.
Nothing further.
All right, so that's it for Dean. I do have a comment here that may be of interest to you, Ian. It says, from Law of Self-Defense, Paul in Florida writes, a shooting at a condo board meeting in Vaughan, Ontario, Vaughan, Ontario, five dead plus the shooter.
Yeah, Vaughn, it's not
Vaughn.
clear entirely what happened on that one, but it looks like this old guy who had a lengthy running dispute with the condo board appears to have shot several people, and then it's not clear whether he shot himself or if the police shot him, because there's all sorts of I mean, it's one of these things where it's right in the immediate aftermath, so everything is speculation. And so we don't know what exactly went down there, other than that this guy appears to have had he's had court battles with them. He was, I think he was declared vexatious, or they at least noted that a lot of his his legal battles were abusive. And I mean, there was mental health issues. He was claiming that electromagnetic radiation from the panels below was leaking into his apartment. So it's like literally something out of Better Call Saul.
Yeah, that's bad.
Yeah, it's one of these. So it's not clear whether if it's, if this was somebody who had a handgun lawfully, or if but they haven't said that he had a gun license. So I'm suspecting not at this point. But again, just conjecture. You just sort of can't really tell. So we'll see. But I'm sure it's going to be used as part of the push for more gun bans.
All right, let me see if I have any other questions here before. I think the next I'm going to pull up the good expert witness by from the defense. This was the police policy expert witness for the defense. Their other expert witness was the photography guy, and his testimony was so unbelievably boring that I'm not going to subject anybody to that. But the public policy expert witness was pretty good, especially on cross-examination by the state. So let me pull him up. Let's see.
How are you employed or otherwise occupied?
Just real
I'm
quick,
currently
guys,
an
this is a
assistant
medical
professor
expert for the
practice at Sam
defense,
Houston State
and
University.
they've already started court. This is outside the president.
That's FFA commenting. This is not a medical expert. The media is always wrong. This is a police policy expert.
This is the jury.
It's like one day they'll get it right.
Criminal
It's
justice, I
not that
teach
day.
in master science program, mainly to mid-career law enforcement officers.
What do you mean by mid-career law enforcement officers?
Sergeants, lieutenants, captains, those with the supervisory leadership duties.
Does Sam Houston State University, that's down in Huntsville, yes?
That's correct.
Does that have a nationally renowned criminal justice program?
Yes, number 2 in the country.
Who's number 1?
Does it matter?
What type of education and background do you have to
I like that answer.
I completed my bachelor's degree at Sam Houston State in 1980, just after getting out of the Marines. I got into law enforcement at the Harris County Sheriff's Department office. Then in 1996, I went back and started my Master of Science there at SAM. Finished that in 1998, 99, started my doctoral studies and was conferred my PhD in May of 2004.
What level of peace officer certification do you hold currently?
Both Master Peace Officer and Instructor.
And that's here in the state of Texas?
That's correct.
Which departments, if there was more than one, carried your commission while you were an active duty police officer?
I began with the Splendora Police Department, a small East Texas department, went to the Montgomery County Sheriff's Office, and from there to the Harris County Sheriff's Office in Houston, where I spent 36 years.
What were your duties at the Harris County Sheriff's Department?
A little bit of everything.
So I see a comment here. It's not a super chat, but it's sufficiently interesting. I'll share it from Be Smart. It says, it's crazy that Bob Gill, the older looking defense attorney here, is also a retired criminal judge. He was a judge for almost 15 years. Folks, there's a difference between being a judge and being a zealous criminal defense attorney.
Yeah.
If anything, I might think that those two are contraindicated.
Everything. In the Harris County Sheriff's Office is unlike, let's say, Tarrant or Dallas County Sheriff's offices. They're large populated areas in the unincorporated areas of the county. So we have a large jail function. We also have a fairly large law enforcement function. And you basically go back and forth between the two disciplines throughout your career.
Upon promotion, you get stuck in the jail. You spend some time, you get to go back to the streets. Is that?
That's correct. Yeah.
When you talk about the law enforcement side of the Harris County Sheriff's Department, you're talking about a area that you were over as a supervisor commensurate with some medium-sized police departments here in the Metroplex. Would you agree with that?
Yes, there were. I was in District 1 when I retired. I was the captain and the station commander. There were approximately 800,000 residents in my district, and I had 174 deputies.
In addition to the 174 deputies under your command, did you also command other agencies were assigned to you and fell under your command?
I see another comment here. It says, one would think you would need to be a good lawyer before you could be a judge. No,
Nope.
no, I don't know how that works in Canada, but here in America, judges are either elected or appointed. If they're elected, it's obviously that's a political function. It's how popular they are. That's how they get elected. If you're appointed, it's a political function. You're being appointed by politicians. So a lot of times it's just who you've done the most favors for. That's all. It's got nothing to do with legal acumen. I can tell you there are a lot of bad judges out there. They're not picked for competence first.
There's some really great judges, but a lot of judges, if you go and dig through their, their political donations, there's a lot of sort of tie of donations to becoming a judge. It's an unfortunate thing.
And think of how different a job it is, being a lawyer and being a judge. I mean, I would throw myself off a building before I was a judge. I would find it so boring. It would be unbelievable. You're hardly ever doing anything except watching lawyers argue. I'd much rather be in the arena, being the lawyer, making the arguments.
There's actually a thing I've noticed where like these really hotshot lawyers sometimes become judges. And there's this phase where they can be really difficult to appear in front of.
Yeah,
and
right. They want to be more active than a judge is supposed to be.
Yeah, they're bored and they want to sort of pick fights, right. And it sucks. You're just like, this again. And then they settle out, hopefully.
Yeah, or they leave and they go back to practice.
That happens too.
I mean, that's what happened with this guy, apparently.
In a previous assignment as the task force commander, yes, I was part of a joint task force with FBI, DEA, other federal agencies, as well as local agencies.
During your career at Harris County, were you invited to be a candidate at the FBI National Academy?
I was.
Do you recall what session you graduated from?
Yeah, the National Academy. That reminds me. I actually have a picture here. Let's see. I just came up on my files recently. I came across it again. Let me see.
This guy's really good at doing the drop information thing. Oh, nice.
That's me. That's the National Academy. So I teach at the National Academy myself every once in a while. This is taken in the main auditorium of the FBI Academy down in Quantico when I was a little fatter.
Session 247.
And how long is the program at the National Academy?
The FBI National Academy is a leadership program. It's approximately 10 weeks in length. They're at aboard the Marine base at Quantico, Virginia.
Have you had training during your career or your doctoral studies in use of force incidents?
Yes.
Can you explain that to the board?
I've had the training that any other peace officer gets. I've also reviewed several other studies involving use of force, the mechanics of force, as well as the legal liabilities of force. I've also reviewed many use of force incidents.
Have you attended any classes from the Force Science Institute?
Yes, I have. I graduated from their main program, their 40-hour program in, I want to say, February of 2018.
And the Force Science Institute is out of the northern Midwest part of the country, is that correct?
Yes, it is.
Well, they
Member of any professional organization?
so I'm also a graduate of the Force Science Institute. I took their full week course. I guess it's kind of their bread and butter course. It's mostly for law enforcement, but somehow I finagled my way in. And they teach that course all over the U.S., maybe even internationally. I don't know. Yeah, they probably do it internationally. I think they're based in the Chicago area, but that doesn't matter. They do their work everywhere. And they study stuff like police reaction times to threats, identifying a threat, characterizing a threat, misidentifying threats, circumstances under which a car could be a threat to an officer, for example. They do a bunch of scientific type studies. I would call them pseudoscientific. I know to police officers, they probably look rigorously scientific. To someone who's actually been trained rigorously in doing scientific studies, they're not scientifically rigorous. But full credit to FSI, they're the only organization doing anything like it. So at least they're making the effort and collecting some data, however imperfect, and it may be impossible to do it perfectly. So I like their work, but some of it I think is a bit of a stretch when it comes to scientific rigor.
Sadly, there's lots of that in policing.
Yeah, we were talking about this the other day with somebody. A lot of the forensic science stuff in law enforcement is just garbage, and it's never been rigorously studied, and it's just nonsense. But it's presented as if it's real, like trust the science, with capital letters, alternate capital and lowercase letters, and of course a lay jury. What are they supposed to think? The judge says it looks okay. The party presenting it says it looks okay. Maybe even the other party says, okay, that's science. But often there's no merit to it at all.
And sometimes you see things that's just horrifying. There was one where there was a digestion sort of issue of basically could the killing have happened in this particular time frame, because there was about an hour window where the guy's alibi didn't hold together. And they're saying, okay, could it have been during that hour? And they take it to this guy who's not a doctor or anything else, but he says he can do digestion, whatever. And he gives it an assessment of 12 hours, which was too long. It was basically like, this makes it impossible. So then they came back to him and said, well, here's our timeline. And he does it again, and he comes back with 8 hours, which is, just perfect to land it in that window. And it's like, this is not how science is. Like this, so wrong on so many levels. And
for a lot of these guys, there's no null hypothesis. That science is always right. Whatever answer you're looking for is the answer they can develop for you. We talked earlier about the importance of having resources in order to, get something like justice, that the amount of resources you have matters. And a good example of that is the George Zimmerman trial, because there was a part of the evidence in that trial. Of course, the fight between George Zimmerman and Trayvon Martin was a neighbor called 911. And in the background of the 911 call, you can hear somebody screaming. And the state was saying, well, that was Trayvon Martin screaming for his life before Zimmerman shot him. And of course, the defense was saying, no, that was George Zimmerman. who was screaming because he was being attacked by Trayvon Martin. So the state went and found this like a voice identification expert to testify in the state's behalf, saying, no, I use this computer algorithm and I can definitely tell that's the voice of Trayvon Martin and not of George Zimmerman. This guy was a complete kook. The algorithm he used was his. He had developed it. He had invented it. So he had a monetary interest in this being accepted as a tool for court. So he would have personally profited. And it was garbage. But to counter him in the Daubert hearing to assess whether or not this should be admissible as evidence, to counter that, the defense had to go get a guy from the FBI who did their voice recognition stuff, an expert retired from the NSA who used to use fancy mainframe computers to identify like intercepted Russian telephone communications. I mean, they had to get these world-class experts, and they won on the Daubert hearing. They got the state's expert thrown out. But man, it cost them a lot of money to do that and a lot of effort. And if it had gotten in, the jury would have been told, this guy's an expert and his algorithm works. And Trayvon Martin was begging for his life. I mean, that would have doomed George Zimmerman. By the way, when they played that same recording for Trayvon Martin's father, the father could not identify that screaming as his son.
Yeah, that's a big one. Because, I mean, the other thing is judges don't typically have a good idea of scientific method.
No, at all.
You'll present them with something and they'll say like, oh, well, I was able to correctly match 2 sets of fibers every time. And you go, okay, cool. Was it just that you were able to correctly say, yes, these 2 things match when you were presented with 2 things that you knew were a match? Because if so, that's like, you could train a dog to just say yes every time. Like this is not, but.
How about we test for false positives and false negatives? How about that? You have any testing like that? And they never do.
Yeah.
They never do.
It's terrible. I would love to see things like, I mean, in Canada, we had a major false conviction over eyewitness identification because lineups are so bad.
Yeah.
And you can use lineups to intentionally taint a witness. People don't sort of think of that, but
you're changing their memory when you do that.
Yeah, you could convict just about anybody if you can shape the lineup that you put in front of the witness. And so they had to sort of establish minimum procedures, but we don't do anything like that for, say, fingerprinting or tool mark analysis or anything like that. It's just, do these 2 things match? Yes, no. Also, by the way, if you say no, then a guilty person walks. Is sort of how this gets presented to these experts.
Right. And even with DNA evidence. So the actual analysis of the DNA is pretty refined, but the collection is not a refined practice. They just swab things kind of at random. And we don't have any good data on, for example, if it's supposed to be contact DNA, what percentage of the time is that actually left at detectable levels? How long do the levels, are they detectable over a period of time, like a week or a month? We don't have any of that data, but we hear argued in court all the time. Well, he claimed that he grabbed the gun, but there's no DNA on the gun. Well, what's that supposed to mean? That just means maybe he didn't leave any, or maybe not at detectable levels, or it completely obviates the purported use. Now, if you find blood or some bodily fluid and you test it for DNA, you'll probably get an accurate result. But there's a lot of complications to the actual real world application of this DNA analysis. That's never, these procedures are never rigorously validated.
Well, and what if it's just a lazy swab? Like the guy just kind of half-heartedly waves the swab at the gun, and you're like, okay, yeah, there's no DNA found, but the swabbing was terrible.
Right. And the person doing the swabbing doesn't know whether or not the case is important. I mean, they have no context for what they're doing. It's just another item coming across their lab table doing a swab on. So might they be having a bad day and do kind of a superficial job? Sure. I mean, they don't know they're going to be testifying in court 3 years from now about what was discovered with that swab.
And 3 years from now, are they ever going to say, yeah, I was having a bad day and I just did a lazy swab? No, they're going to be like, I am always super diligent.
I followed our practices and procedures.
Yeah, to the letter. And, I never deviate from these at all for any reason.
Right.
And
of course, one of the reasons they have the practices and procedures is first, hopefully, so they'll do it right every time. But secondly, somewhat more surreptitiously, so that they'll testify in court the same way every time. It's like how cops write traffic tickets. You know, they don't write them as they're each a unique event. They use basically the same format for writing out every ticket, so they don't actually have to remember the actual ticket if they're ever testifying about it. They just, well, this is how I always write them. So there's no real recollection. It's just they follow a certain pattern, so that's how they pretend to recollect it.
Yeah.
Let's see, law self-defense member and firearms instructor up in Montana, Will Parker, graduate of the law self-defense instructor program, says one of his colleagues, and that's where you can find Will Parker there, folks, fmgw.net. Great guy. He's hosted me several times to teach law self-defense courses up there in Kalispell, the Kalispell area of Montana, almost Canada.
Nice.
That's just below the border of Canada. I mean, you can almost throw a tennis ball and have it land in Canada. Glacier National Park. Will says one of his attorney acquaintances wants him to run to be a JP, Justice of the Peace. I would encourage you to do that. I bet that'll be a great experience. You don't have to do it forever if you decide you don't like it, but I think you'd probably enjoy that. Let's see. Will Parker writes, I feel blessed to have had the foresight to have backing such as CCW Safe to pay for a world-class defense and expert witnesses. I have a CV that is very robust. That is true. Will has a very robust CV. Let's see. Nate writes, interesting video just released on the police activity YouTube channel an hour ago. Suspect points a gun at Officer 1. Officer 2 just shouts, hey, 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 as Officer 1 proceeds to get shot by suspect. Very interesting to see because of Aaron Dean's criticisms in this case.
Training breaks down when there's a gun. When there's a life and death moment, it happens.
Let's see. Tax Pro Pam, Law Self-Defense member Tax Pro Pam says, what exactly is a justice of the peace versus a judge? I've considered them interchangeable much of my life, but now, no, they are not exactly the same. Yeah, it's kind of, I don't know. I don't mean to be derogatory. It's kind of like a mini-me judge. So they're handling relatively unimportant matters. It's things like maybe little civil controversies that don't arise to like a full-blown lawsuit, or some minor criminal complaints. Sometimes they do marriages, things along those lines.
Where I am, bails, traffic tickets, search warrants, all of that kind of stuff would be justice of the peace usually.
Yeah, I think we would call that a magistrate here in the U.S. So like a level above justice of the peace, but below a trial judge.
Right. Fair enough.
For stuff like bail. But it could vary by jurisdiction. So that's just a generalization. Nate, if you have a link to the police activity video you're talking about, feel free to put it in the member chat. I think links are allowed. I'll put in my own link and see what comes up. I'll put in the free book link. Well, at least I'm allowed to put links in, so try it. If you have a link for that video, go ahead, put it in, share it with the law self-defense community. Let's see. Tay Logan on YouTube, $5 super chat. Thank you. Says most voters do not know anything about the judges they vote for, if they even vote. I mean, these are generally very low vote count elections for judges. A lot of people get to that part of the ballot and they don't know any of those people, so they don't bother checking any of the boxes. So it's the judge's friends, basically, that get them elected into office. Very, very small number of people. All right, back with the defense expert on police policy.
Yes, I'm a member of NTOA, the National Tactical Officers Association, the TTPOA, the Texas Tactical Police Officers Association, the IABTI, the International Association of Bomb Technicians and Investigators. On the practitioner side, on the professional side, I'm a member of the ACJS, the Academy of Criminal Justice Sciences, as well as ACS, the American Criminological Society.
How does a police officer get to be part of a bomb squad?
Unlucky at best.
In Harris County, when you were there, you helped form the bomb squad of the Harris County Sheriff's Department, correct?
I did. I was one of the first members.
So you had to have specialized training at the Redstone Arsenal in Alabama on how to be a bomb tech. Is that safe to say?
That's correct. Class B 186.
You were hired early on in this defense by Jim Lane
Yes.
to look at Aaron's use of force in this case and make some recommendations to us and ultimately maybe some opinions to the triers of fact. That was your engagement with us.
Yes.
And you know that we're going to compensate you for that when this is all over.
Yes.
At least you hope so, right?
Yes.
Okay.
Keeping in mind I still have access to explosives.
Yes. Fair enough. No bomb chief prosecutor over here understands that full well. The green light, right? Okay. So we're in this expert hearing. I think the state defense, we talked briefly before we went on the record of just going through your background and just what opinions you intend to elicit today. Not a full, we're not going to dive into it. Judge, maybe go off the record for just a second.
Yes.
Yeah, let's just, you want to just.
Absolutely.
All right. Dr. Koontz, can you give us, you formed some opinions in looking at this information, correct?
Yes, I have.
And as part of that information, we provided you, I think, everything that we got our hands on that Mr. Smith and Ms. Diener provided us under 3914. We gave it to you so you could have access to it. Is that correct?
I received a number of documents. Yes.
In addition to documents, crime scene photos, extra photos that the state may have produced and given to us, videos from every officer that was out there.
I'm sorry, from every officer. Yes.
Videos from every officer out there.
Yes.
You're kind of hard of hearing sometimes, correct?
I am. I'm sorry.
Did you not put ear protection when you were downrange at some point?
What?
Okay. Pay attention, mister. All right. So what?
I like this guy.
Here to give to the jury. Can you give us a high level overview of what your thoughts are on looking at this use of force incident?
There are two incidents. The first obviously is the use of force itself. Was that proper police work? Was it justifiable under Texas law? And as well as the police procedures that were used by Officer Dean and Officer Darch in handling this call.
So if we were to maybe break it down into three chunks, there's before they get to the gate, and then there's a couple incidents inside the gate. Is that a safe way to look at this?
Yes.
Can you take us what your opinions are before they got to the gate?
In general or in detail?
In general.
Their approach to the scene, the way they handled that scene, the way they walked through the scene was proper police work, given the nature of the call and what they observed on that scene.
And you base that upon everything you've had available to you in the pretrial discovery, plus you got to listen to Officer Dean testify, correct?
That's correct.
Then you have, if we were to break the time down inside the gate, there's two sequences of time I think you're here to testify about. Is that correct?
That's correct.
What's the first sequence of time?
The first sequence of time is Officer Dean's approach to the window. And as we saw Mr. Fredericks point out yesterday, there is a deep breath when we hear that deep breath on Officer Dean's body-worn camera. We see, based on the camera angle, we see him straightening up. It appears he might be stepping back slightly. The thumb comes off of the flashlight, and we now know that he's drawing his weapon. That's the first step. And then there's a second step. Do you want me to go further on the first step?
If Mr. Smith does, he'll ask you some questions here in a second.
Okay.
Said broad strokes, and then he can ask you some follow-up.
Okay.
The second sequence, where does that start?
As part of the first sequence, Officer Dean, once he draws his weapon, he begins to step forward to track what he's just seen and keep track of what he's just seen. But as he does that, he's confronted by a subject pointing a pistol at him. And at that time, he fires his pistol.
The fourth phase, I believe, of your testimony is the response to render aid that takes you leaving the gate and going into the residence till Dean turns his camera off and is putting a patrol car. Is that correct?
Yes.
What observations do you plan on providing the jury about that?
Essentially, that Officer Dean immediately got on the radio, notified dispatch there had been shots fired. Immediately after that, asked for, I believe up here it's called MedStar, medical system.
It's a Jimmy John sandwich, folks.
Just shot. As they are backtracking out and going to the front door, he's asking Officer Darch if she has her TACMed bag, which is basically a small first aid type of kit to render aid. And then ultimately when they make entry into the residence and renders aid there.
The fifth point for that area would be how, I believe, how Officer Dean or how officers are trained to move weapons away from individuals.
Yes.
And what is your thoughts on that?
Police officers are trained to do exactly that. If you have an individual down, now whether they're injured, whether they're not injured, the extent to which they're injured, if there's a weapon close by, get the weapon away from them. One, we do not want them to have access to it, but also two, we don't want to be stepping on it. Our first responders will not approach a subject to render aid if there's a weapon right there with them. So this basically prevents further harm. It prevents the necessity perhaps for another shot being fired, and it speeds the ability for first responders to render aid to them.
Thank you. I'll pass the witness.
Cross-examination.
That was a very quick direct. I'd forgotten how short that direct was of their expert.
Very effective, though.
The cross, this guy handles the cross real well, to the point where the only rejoinder at closing is really the state complaining that they couldn't get this guy to agree with anything the state was trying to say, which is pretty much the perfect defense expert. I do have a question here from Super Chat. It's $5. I guess it's directed at me. Just a map nailed to the wall, it says. Not implying you would, but would there be any value to having someone with your knowledge as an expert witness, a self-defense expert? Well, I don't hold myself out as a self-defense expert when it comes to things like tactics and strategies for self-defense. I've had a tremendous amount of training in that area. For many years, I was an instructor on self-defense law at the SIG Arms Academy, 6-hour academy now, up in New Hampshire. And during that 15-year period, they let me take any courses I wanted. And a lot of them were nominally police only or military only courses. So I've had a tremendous range of instruction, which I found very personally satisfying, but I wouldn't hold myself out as a self-defense instructor. There are other people who do that full time who I would recommend in place of me. My expertise, what I hold out to be my expertise, is self-defense law. And of course, my legal practice is basically as an expert legal consultant. That's what I do. I consult to other attorneys who are lead counsel for their clients that are charged with a use of force crime and claiming self-defense as a legal justification. And usually my deliverable is a very comprehensive expert report, a couple hundred pages long. I've never been asked to actually testify in court as an expert, and I wouldn't expect to be, because once you're in court, the legal experts are supposed to be the judge primarily and the lawyers arguing their positions. The judge thinks of himself as the legal expert. He's the one instructing the jury. Generally, it would be weird to me to have the judge bring in some other legal expert. Perhaps if it was some very esoteric area of the law, like maritime law or some kind of real property law and some odd issues that the judge might not have been exposed to since law school or something. But what I cover is self-defense law. It's pretty stable. It's pretty well established. There's standardized jury instructions on it. So what typically happens in my consults is I deliver my report to the defendant, and the defendant uses that to make their legal arguments to the judge in the most compelling way. So that's how that works on my end. If I was asked to testify as a legal expert in court, I'd be happy to do that on behalf of a platinum member. It just hasn't happened. And I would be surprised if it happened. Let's see. Law Self-Defense member Tax Pro Pam says, yes, I tried to find out more about the judges in our ballot, but it was virtually impossible. Yes, that's a real problem, getting good information on your judges. If someone's not actually a member of the legal community, it can be really hard because you're not exposed. They're generally not getting much media coverage. You might try, if your jurisdiction, there's often the local bar association will have like a legal newspaper for the legal community. And if you can find a law library that archives that kind of stuff, I guess it's probably all online now. You might be able to search for the judge's name and see if there's been any kind of controversy. But those legal newspapers don't tend to write negative things about judges. So
the other thing you can sometimes do is look up their name and at least, in some search databases, look over their past decisions, like their written decisions. And you might be able to get a feel for them that way.
Let's see. If Pam continues, if one could find cases over which they presided, no one has time to read all of the opinion or know if they are valid because we know nothing about the parties involved. It's like the difficulties for most people in picking out an attorney in the first place. Most people are really uninformed consumers of legal services. So they're not in any position to make a realistic assessment of whether a lawyer is good or not. There are exceptions, particularly in the business community, where you're retaining lawyers all the time for similar types of activities. And so you develop relationships with those guys. But in terms of the criminal defense context, for people like us who don't normally have exposure to the criminal defense system, we wouldn't have any of that foundation.
Yeah.
Law Self-Defense member Tax Pro Pam writes, Tom Skerritt's doppelganger is still my favorite witness of the last few trials. That would be this witness, Tom Skerritt. Nate writes, Law Self-Defense member Nate writes, the reason I found that interesting is if you look at the timestamp start from hey to when the shooting starts, it's just a split second. It just goes to show in a high stress situation, the right words may not come out. Yeah, of course, right?
Yep.
Most common thing in the world. You don't have time. And the time's not set by the officer firing their shot. The time is set by the threat. The threat determines how much time there is.
I mean, people mess this up in airsoft games where they're not life and death. They're going to mess it up even worse in real world shooting situations. I've seen cops pull out a flashlight when they meant to pull their gun because they just, freaked out and they grabbed something off their belt.
And people have no idea what they said afterwards. Yeah. It's kind of mouth noises. I used to run students through a very high-end shooting simulator system that I used to bring with me to classes. And they were shown a video of a prospective threat, some kind of prospective threat scenario, just a video. And they used a fake plastic gun that just shot an infrared beam, no danger. And they had to solve the problem, which might require shooting or not shooting. And then when they solved the problem, they had to turn back to the class, tell us what they saw, what they did, why they did it, the legal rationale for their use of force decision-making. And this was after a full day class of law of self-defense. But they couldn't remember what they did. I mean, if they shouted verbal commands and we asked them what the verbal commands were later, they couldn't remember what they were, or they would tell us different words than we actually observed them shouting. They just, even under that modest amount of stress, the way your brain captures and stores and recalls information is completely different than the normal experience and rather unreliable.
I saw a video of police officer stops somebody and the guy gets out of the car, which is always a bad move, right? Because now the cop is freaking out. And he's getting out of the car with an umbrella, and the cop doesn't shoot him, but shouts at him. And what he shouts is just completely incomprehensible gibberish. And the guy with the umbrella goes, what? And just sort of huh? And the police officer sort of stops and they look at each other and the guy goes, oh, and drops the umbrella because he realizes that he's doing a stupid thing and gets arrested and all of this. And I'm going, first, dude, do you have any idea how close you are to getting shot? But also the police it wasn't even words. It was just, blah, 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 blah. And the guy's like, I don't know what you're saying. It's difficult for people to really figure how these things go.
Law Self-Defense member Tax Pro Pam says, my husband is a Desert Storm veteran. Well, thank you for his service. Thank him for his service. You too. Thank you too. Even though he qualified expert on any weapon he could, he was in transportation, not infantry. He moved tanks all over the desert. They were ambushed once, and he affirms that once you're fired upon, all logic and training temporarily disappears. Will Parker, law self-defense member Will Parker writes, finding my criminal defense trial attorney, I took advantage of the years following Andrew, reading his books, sitting in his classes to have an actual interview consult with my attorney. I also looked into his background and cases tried. Yeah, folks, I know it's, of course, self-promotion, but one way you can make yourself a much better informed consumer of legal services in the use of force context is to get my free book, The Law of Self-Defense Principles. Look at the reviews on Amazon, 1,200 plus reviews, 5-star rated. It's one of the best sellers in the criminal law category on Amazon. But don't buy it on Amazon. Amazon will charge you $25 plus shipping and handling. I'll give you the book. Just cover the cost of shipping it to you, the shipping and handling. I eat the $25. And if you read the book, and most people can read this book in an afternoon, it's written in plain English. It's an easy read. At least if you're involved in a use of force event and have to begin interviewing attorneys for your legal defense, if you're charged, you'll have some sense of the right questions to ask and some sense of what kind of answers you should be getting back. So you'll have made yourself a more informed consumer of those legal services for $8 or whatever the shipping and handling is. That's pretty good, folks. And if you'd like to get someone a gift this holiday season, beautiful hardcover version of the same book, looks great on the bookshelf, might keep a loved one out of prison if they're compelled to defend themselves or their family. Did I say where to get the soft cover? lawofselfdefense.com/free book. But if you'd like the hardcover, these are not free because the hardcovers are too expensive to print up. But they make wonderful gifts. You can get this at lawofselfdefense.com. Get hard. Be a more informed consumer.
If you own a gun, you should really know some self-defense law. Like, I think that you can't have one without the other.
All right, let's get back to Tom Skerritt on cross-examination now.
Just briefly, Dr. Coons, are you aware of any Fort Worth training that would tell an officer not to announce his presence at a open structure hall?
Yes.
Where is that specifically?
I don't know it specifically, but it is common practice. It is common, and it's in Fort Worth policy that caution is to be used when approaching possible crime scenes.
But where specifically, in any training, did you review all the training documents for Officer Dean? For Officer Dean?
To some extent, yes.
So specifically, where is the instruction to Officer Dean not to announce himself at an open structure hall?
It would be in the scene approach training.
Did you review that?
Not the lesson plan, no.
Do you know specifically from what you reviewed that Officer Dean was told specifically not to announce his presence at an open structure hall?
In those specific terms, dealing with that specific call, no.
Okay. No further questions?
Pretty correct. Any objections to this witness testifying, Mr. Smith?
That was their cross?
No objection.
Jury here? Jury's here. Y'all ready to go?
We have just one moment, Your Honor.
All right, so that was not the actual direct and cross. This was the voir dire. So the jury's not in the courtroom. They're just questioning him to get a sense of the scope of what he plans to testify about. Now that that's been done, and they're going to accept him as the judge will accept him as an expert within that scope. Now the jury will be brought in. We'll have the real direct, the real cross, and those take a much longer period of time.
Yes.
An assistant professor of practice with Sam Houston State University.
For those that may not know where Sam Houston State is, where is that located?
It's down in Huntsville, Texas.
And how long have you worked with Sam Houston State?
I've been on full-time faculty since my retirement in December of 2018, and then I was an adjunct faculty member there prior to that.
Where did you retire from full-time?
The Harris County Sheriff's Office in Houston, Texas.
How long were you with Harris County?
36 years.
Were you a certified Texas peace officer during that 36 years?
I was.
And do you still have a certified Texas peace officer license?
I do.
And there's different levels the jury's heard about. Aaron and Carol had a basic. What level do you hold?
I have a Master Peace Officer certificate as well, a license, as well as an instructor's license.
36 years before you retired, you had to go to an academy, correct?
Yes, I did.
And where did you go to an academy to begin with?
The Harris County Sheriff's Academy, and they're in Houston.
You've had a chance to listen to some of the testimony here this week and review the materials in this case. 36 years ago, they still teach the basics that they do today in the police academies?
The basics, yes.
In addition to going to a police academy, what other type of training have you had that prepared you to come to court today?
I've had a number, literally thousands of hours of in-service training throughout my time with the Harris County Sheriff's Office. I've also attended the FBI Hazardous Devices School in Redstone Arsenal, Alabama, where I was certified as a bomb technician. I have attended the FBI National Academy in Quantico, Virginia, which is a leadership and management school for police administrators throughout the United States and throughout many parts of the world.
Dr. Coons, to be called doctor, what type of formal education do you have as well?
Well, I completed my doctoral studies in 2004 there at Sam Houston. Prior to that, I completed a master's degree in 98 and then my bachelor's degree in 1980. Yes, 1980.
Your doctoral's in criminal justice?
It is.
And what is criminal justice from the educational perspective? What do you teach?
What I teach in our Master of Science program, which is geared toward mid-career practitioners. So we're talking sergeants, lieutenants, captains in law enforcement agencies throughout Texas. In our online program throughout the United States, we've even got some students with the Chinese National Police. And we basically bring them up to speed on several aspects in criminal justice. I teach management and administration, administration and leadership, as well as ethics, and then human resources.
Why ethics to mid-range police officers?
Ethics is critical to policing in the United States. Not so much if you're in a totalitarian dictatorship, but here we need to understand not so much what to do at times, but what's the right thing to do.
So those
And
Chinese students probably don't pay much
Leadership.
attention during this.
In addition to the training you talked about, did you also go to a program called the Force Science Institute?
I did. I attended Force Science in February of 2018, and it talks a lot about human dynamics, the speed at which people can perceive things, react to things, and other subjects along those lines.
In your time at Harris County, in addition to being part of the bomb squad, did you rise to a level of supervisory position inside the department?
I did. I joined the agency in September of 1982. I made sergeant in August of 1985, lieutenant October of 88, and then captain in May of 97.
As part of your duties, the Harris County Sheriff's Department set up a little bit different than some of the departments here in the Metroplex. Would you agree with that?
Yes.
Is that based on the geographical areas of the county of Harris, that there's a large part of unincorporated as compared to, say, Tarrant or Dallas?
It's not only a large part of the county is unincorporated, but it's also very heavily densely populated as well.
Are there, we've heard about districts here, central, east. Was the sheriff's department there assigned district numbers?
Yes.
In the last district that you were in charge of, how big a population space were you responsible for?
I was responsible for over 800,000 people and 174 deputies.
In your role as a commander of that sector, do I have that right, commander, or what was the title for that?
District commander.
Did you have to review use of force reports?
I did.
What is a use of force report?
This is something that's relatively new in policing, probably about the last 15 years or so. It's a general rule in American policing now that anytime an officer uses force, for whatever reason, they generate a separate report detailing the force that was used, the resistance that required that use of force, where the force was applied, what category of force was used. And that way we can keep detailed records to what is basically working and what's not working.
When you look at a use of force report, those can happen from simple laying hands on an individual.
Yes.
All the way up to the discharge and use of deadly force. Would you agree with that?
Yes.
And as your role, you were responsible for reviewing those for your sector and making decisions whether to send them up the chain of command or finish them at your level. Is that safe to say?
All except for officer-involved shootings. Now there I would review, but an officer-involved shooting, the decisions are made at a much higher level.
Whether it's a simple use of force with hands or an officer-involved shooting, it's important to walk through the process and evaluate this from the eyes of the officer at the time, knowing what they knew. Is that a safe statement?
Absolutely.
You've had a chance to review a bunch of materials when Mr. Lane retained you to be part of the defense team. Is that safe to say?
Yes, it is.
You've had a chance to look at State's Exhibit 1 and then the work that Mr. Fredericks did on the video, breaking it down frame by frame and showing you what you could discard from the image and what you could pay special attention to, correct?
Yes.
Are you prepared to walk the members of the jury through how you would grade and walk through this use of force situation here today?
I am.
In addition, there's been a lot of talk, and you've been here this week. Expert row is right here on the front row behind us. A lot of discussion about general orders.
Yes.
You're aware that Fort Worth has general orders.
Yes.
Is it safe to say every department in the country has general orders?
I would hope so.
Department of Justice for their agents has an overarching set of general orders for their agents as well.
Yes.
You looked at academy materials. In addition to academy materials from Fort Worth, you know, if you do, that TCOL, the certification body for you and other peace officers, the sheriffs that are here in the room, have basics that you have to teach to, a minimum level. Is that safe to say? As part of their criteria to be a peace officer, you got to know this?
Yes.
If we could break this down, let's start from the time they receive a call. Why is it important to get the most information possible on the screen to the officers when they go to the scene?
Well, the more fully briefed an officer is when he or she is en route to a scene, the better they're able to make decisions about how to handle that scene.
You've seen the call text that's been admitted, the typed words, and then you've listened to the audio for the dispatch and seen the NBC printouts, correct?
Yes.
You understand that the play call for this from dispatch was a signal 56, correct?
Yes.
Local news is reporting they have a verdict, folks.
Ooh.
But we haven't switched back over to the courtroom yet. It says verdict at 2 o'clock, which would be the top of this hour, 2 o'clock Central Time, U.S., Texas time. So in just a few minutes, we ought to have a verdict.
Exciting times.
Yeah, I'll get my life back. Thank you so much for joining me, Ian. It's always nice to have some company.
Oh, happy to be here. It's this one's such a weird, like an unfortunate case. I feel like people are so upset by like this notion of, and I don't think this is really the textbook example, but they see these cases of like bad police and they get upset by that. And then they just want to punish police generally. And I mean, I feel like the criminal law is really the wrong avenue for that in most cases. I mean, there are bad police officers, but usually it's not what's going on. I'm not exactly like the biggest pro police guy, but I find it hard to sort of be like, well, here's where here's where this guy, started to deviate or anything like that.
I said verdict. It's the sentence, of course, is what I mean. Sorry, folks. Try to get an email out real quick.
Tell people get here now.
Yep. Exactamundo.
You are about to miss it. Get here. And of course, he's got the classic mustache. I think those guys, I think police officers get issued those.
It's a certain look for sure. Okay, so not in the courtroom yet. Going to stop this screen, be ready to pop up the court stream on a moment's notice. Exciting stuff. Exciting, exciting.
Court stream, they like to mess with us.
Get back to the super chats. Looks like nothing new there. Oh, the YouTube poll. Where's my YouTube poll? So what did people predict would happen? Not their preference, but what they predicted. 20 years, which is the max, 7%. More than 10 years, 16%. Less than or equal to 10 years, so at least some prison time, was 49%. The plurality and probation was 28%. So now I'm going to put up what you think the sentence should be.
I find this one hard to really go with because It's like, what should the sentence be if you think it's manslaughter, or what do you think the sentence should be based on
Only
what
for
we're actually
manslaughter.
looking
Yeah,
at?
what he was convicted of. Less than or equal to 10 years. Okay, folks, the new poll is up. So now it's what you think the sentence should be, not necessarily what you think the jury will deliver, but what you think would be an appropriate sentence in this case. So far, 91% for probation, with about 100 votes in. Yeah, you don't have much time to get your votes in, folks. It's happening quick now. Well, top of the hour is right now. So
Yeah, it's like a minute out.
So far with the poll, 400 votes, 81% probation, 14% less than or equal to 10 years, so at least some prison time, and 3% for more than 10 years, 3% for the max, 20 years. And I expect long crime would be the opposites. Oh, he's in the courtroom on long crime. All right. Present, share the screen. Okay, no volume. Yeah, he doesn't look good.
Yeah, no. It looks like he just didn't shave.
Didn't sleep.
Didn't sleep. That's not great.
Few days in jail. We've been told that.
Yeah, it's. I don't want to play the WFAA commentary feed, folks. That's the video is public record. That's a pool video. I don't mind sharing that, but their commentators are things they pay for. And this is a long crime stream, and there's no audio on it from the courtroom. I could stop that banner. Live sentencing from the courtroom.
Heck, the guy next to him looks like he didn't sleep a whole lot either.
That's Bob Gill. That's his defense lawyer, who's the former judge.
Yeah, he doesn't look like he's having a great day.
1,000 people watching on YouTube. I don't know how to count the number of people watching on the member dashboard. Let's see. Yeah, it looked like he was being uncuffed there. So now that he's a convict, he's subject to being secured. So it's probably in a holding cell all night, which is not the most comfortable place to sleep. Is Uncivil back? Feel free to jump in, Uncivil. You still have the guest link. Holding right about 80% on probation on the new poll, what people think the sentence should be, not necessarily what they think the jury will return. About 20% on some jail time less than 10 years. I guess we have the families in the courtroom now, both the families, it looks like. And everyone's wearing heavy winter coats. What the hell is the temperature down there?
Might just be one of those things where it's like unseasonably cold for the particular
55 degrees. That you'd think they were in Canada. Jeepers. Look at those coats. Like heavy wool overcoats.
Those coats are heavier than what I'm wearing to go outside right now. And it's 22 below in American units out in Canada right now, and I'm not wearing anything that big and
22
heavy.
below. Dear God.
Oh yeah, and the dogs
All right.
are like, "We want to go play." It's like, really?
All right, we got audio. Here we go. There's the judge.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in.
And here we go.
See people saying no cheering allowed? Yeah, no cheering is allowed. Didn't he throw somebody out for like making a face earlier?
Yeah.
This judge
Everyone
doesn't
may be
screw around.
seated. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay, hand it please to Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment and confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number one, is this your verdict?
Yes, Your Honor.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes, Your Honor.
Juror number six, is this your verdict?
Yes, Your Honor.
Juror number nine, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence.
No reason for this to happen. A weak defense is responsible for this. Malicious prosecution, but a weak defense allowed that to happen.
Would you want?
Oh, the image froze for me.
Same here.
I'm going to skip that. If anybody wants to watch it, you can go to Law and Crime or WFFA for the feed. But that's it. 11 years, 10 months, and 12 days. So I guess they had a numerologist on the jury.
Yeah, that's a weird. How'd they got to that? I don't know.
It's and clearly, I would suggest a compromise sentence, much like there was a compromise verdict, right? It was looking at 0 probation to 20 years. They gave him just under 12.
Right near the middle.
Yep. And this is a wrongful conviction on the legal merits. There's no rational way for a jury to arrive at guilt on reckless manslaughter here. A bad outcome case, so people's emotions are riled up. We know there were protests. People might be scared about violence in the streets if they don't return a guilty verdict. But there's no guilty verdict here on the legal merits. We know, for example, that he always maintained he deliberately shot her. That's not recklessness. That's an intentional shooting. We know the jury acquitted him for that intentional shooting because otherwise they would have convicted him. So, and the only basis to acquit him on the murder charge is self-defense. So because they didn't convict him of murder, we know they believed the self-defense. And if something is done in self-defense, by definition, it's reasonable. And if it's reasonable, it's not reckless. So there's simply no rational way to get here based on the facts and law in this case. And now he's going to do almost 12 years in prison. I believe Texas does about good behavior 50% of the sentence, and you're up for parole. Whether he qualified for parole in today's times is another question. But he could prospectively get out in about 6 years. For what? For having a bad legal defense, as far as I'm concerned. And this doesn't have to happen. There are good lawyers out there. There's law self-defense out there for this kind of case to make sure your lawyers aren't doing this, or at least if they're doing it, someone's making you aware that this is not the direction to go in, so you can make an informed decision about your legal counsel. And keep in mind, if you're a Law Self-Defense Platinum member, you get my legal consultation on your case for nothing. Nothing. That's what the membership gets you. And you don't have to be at risk of this. But I have to say, you have to be a member at the time of your use of force event. You can't do this retroactively. That's not how it works. So something to think about. You can learn more about our Law Self-Defense Platinum membership, everything it gets you, at lawselfdefense.com/platinum. Jamie in the super chat, $5, says, Aaron Dean didn't know Atatiana Jefferson. He didn't set out to murder her. So this is BS. The whole trial was BS. All BS, race, and politics. Good luck to our police. Good luck to the people in Fort Worth getting a burglary call answered. You think a cop is going to risk a 12-year sentence to investigate the burglary at your home? Or you think he might wait an hour or two until he can be fairly sure that it's not going to be a burglary in progress call?
Yeah. Oh, we'll just wait until they're gone. Best of luck.
That's the rational response. So to those of you on the Law Self-Defense member dashboard, thank you for spending all this time with me. For those of you who are not just members, but platinum members, just know you have me in your corner should the worst happen. You don't have to be subject to this kind of prosecution and this kind of verdict and this kind of sentence, because I will fight for you. This doesn't have to happen. It really, I swear, this is the kind of thing I lose sleep over.
Yeah.
If the process is followed, good due process of law, and we end up with a guilty verdict, whoever the defendant is, I don't lose any sleep over that. But when I see the process corrupted, the law misstated to the jury, the evidence misstated to the jury, and a defense team that doesn't do their job in zealously defending their client, and then that client gets convicted, I have no confidence in that verdict and no confidence in the sentence. and it just didn't have to happen. And yes, if you're a platinum member and heaven forbid you were to get convicted, despite my help, I continue to help you on appeal, continue to help you on retrial. That is all covered. For those of you who joined on YouTube and Rumble and Twitter, thank you so much for spending your time. Ian, thank you so much. Remind everybody where they can find you, Ian.
Runkle of the Bailey on YouTube is sort of the best place. And thank you for having me. This is kind of a fascinating and unfortunately tragic case.
Tragic all around, of course. Tragic that Atatiana Jefferson died too. That's not a good outcome. This is a bad outcome case. Nobody wished her dead. Obviously, we know this wasn't an intentional killing, even by the officer who was convicted here. It's just a tragedy all around, and just made worse by this unnecessary, unjust verdict and appropriately, correspondingly unjust sentence. But that's the world we currently live in. All right, Ian, I'll say goodbye. Check out Ian, folks. He does great work. And
see you, folks.
For everybody else, thank you for spending all this time with me. I know it's been a long road for this trial to an unfortunate outcome, but we learn lessons from it, don't we? I hope we do. And until next time, I think we'll get back to our normal schedule this week. And then after Christmas, maybe a little light schedule in terms of content delivery, but we'll get back to our normal flow of things. We'll start answering some of the platinum member questions and so forth now that this trial is wrapped up. And so I look forward to delivering all of that to all of you. And until next time, as always, I remain Attorney Andrew Branker for Law Self-Defense. If you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. You also owe it to yourself to make sure you know the law, so you're hard to convict. All right, folks, until we meet again, probably tomorrow, I remain Attorney Andrew Branker for Law Self-Defense. Stay safe.